And they're off.
And we're live streaming. Good morning, everyone. This is the Joint Standing Committee on the Judiciary. And this morning we have 4 public hearings, and then we actually have about a dozen work sessions this afternoon. So we will jump right into our work. There are members of the public who have signed up to testify on our bills this morning, and they are in the attendee space. I think that they can hear what we're saying, but to those who are in the attendee space, because we received a question, you will be brought onto the panel and be able to activate your audio and video when it's your turn to provide your testimony, and we will be calling you at the appropriate time. And until then, you'll be in what we refer to as the attendee space, and you can hear and see the work of the panel. But again, you will only join the panel at your proper time for testifying. And I did put in the chat the order of this morning's bills so that people can look at that and see where we are. And our committee clerk typically indicates on her screen the bill that we're currently hearing so that people can know the status of where we are this morning. We usually begin our day with committee introductions, and we will do that today. And I'll start with Senator Sanborn.
Good morning. Thank you, Senator Carney. I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Representative Harnett.
Good morning, Madam Chair. Thank you very much. My name is Tom Harnett. I represent House District 83, which is the city of Gardner where I live, and the town of Farmingdale. And welcome to everyone.
Representative Babbage.
Yes, how do you do? Thank you, Madam Chair. Welcome all. And my name is Christopher Babbage. I represent House District 8, which is part of Kennebunk.
Representative Reckitt.
Morning. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Representative Moriarty.
Thank you, Madam Chair. Good morning, all. I'm Steve Moriarty, representing my hometown of Cumberland and also part of Gray.
Representative Sheehan.
Thank you, Senator Carney, and welcome everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
And let's see who's next. Representative Libby.
Thank you, Madam Chair. Good morning, all. Laura Libby, coming to you from the State House. I represent District 64, and that is part of Auburn and all of Minot.
Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Thorne.
Morning. Thank you, Madam Chair, and welcome everybody. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up in beautiful Penobscot County.
And Representative Evangelos.
Thank you, Madam Chair. And good morning, everyone. I'm Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you. And we have a couple of committee members who may be joining later. We'll have them introduce themselves. This is a really busy time of year, and we are pulled in multiple directions for introducing and testifying on other bills in the legislature. I'd also like to introduce our legislative analyst, Peggy Reinsch, and our committee clerk, Susan Panett. Good morning. And with that, I will, start with just a couple of reminders. We'll be doing hearings on 4 bills. We have a lot of members of the public signed up to testify on those bills. And for the information of the public, and as a reminder to committee members, the public hearing part of the committee process is really for us to hear from members of the public on our legislation. The time for expressing our own opinions and debating on bills comes in the work session and in the context of casting votes on bills. We do have a 3-minute time limit on members of the public who are testifying on bills. The bill sponsor, of course, gets unlimited time to present the bill, but after that, everybody will be subject to a 3-minute time limit. And because our day is so full, we're going to be really strictly enforcing that this morning. So we appreciate your cooperation. And with that, I'll open the hearing on our first bill, which is LD 793, an act to include as a factor in sentencing the selection of a victim based on the victim's employment as a law enforcement officer. And this is being presented by our colleague, Senator Davis. And let me see if we can bring him onto the panel.
I think I'm there now.
You're here. Thank you so much for joining us this morning, Senator Davis. We're pleased that you're here, and you can begin your testimony whenever you're ready.
Well, thank you very much, Senator Carney and Representative Arnett and members of the Judiciary Committee. I got to say it was all very nice yesterday to see everybody, and I really miss, after being here for quite a few years, not being together. I think we're missing out on a lot. I am Paul Davis, and I have the honor of serving the people of Senate District 4, which includes all of Piscataquis County and parts of Somerset and Penobscot. I am here today to present you testimony on LD 793, an act to include as a factor in sentencing the selection of a victim based on the victim's employment as a law enforcement officer. And I would tell you up front that I have done quite a lot of research on this, and I'm going to ask you to go to a work session after I get done. But prior to that, I just want to tell you and give you my reasoning for putting this in. In 1971, I applied to the Maine State Police. I wanted to be a state trooper. There were over 2,000 people that applied during that time. And 25 of us, as I recall, there might have been 24, were hired. From 1997 to 2013, we saw a rise in the number of people applying to join the law enforcement ranks. However, according to a 2019 survey conducted by the Police Executive Research Forum, 63% of police departments said they had seen fewer applicants in just 5 years prior. Now, I also learned yesterday of a poll that's being done where there's a lot of concern amongst the public of the fact that fewer people are applying for police jobs. And they said in this poll, I haven't read it in depth yet, I just got it yesterday, but said that 88% of the people in Maine feel that it's the lawmaker's job to correct this in some way. The reality is fewer men and women are stepping into law enforcement, a role that is to serve and protect the community. I believe that a lot of this has to do with what is happening in our country. I know a lot of police officers, and I can tell you that 99% of them are great people. Now, I'm not going to say that there aren't a few that are bad apples. There certainly are, and there isn't any possession. But I believe that these few members have misused their authority, resulting in terrible situations. In doing so, I believe it has painted a poor image of those in law enforcement, what we're really all about, serving and protecting. I submitted this bill because I believe a negative bias has developed in many people towards members of law enforcement. And I wanted to be sure that the men and women that are in uniform are protected. However, as I said in the beginning, after further research, I do not feel this bill is needed, as it is already a crime to assault a member of law enforcement. And again, with that being said, I would ask that the committee go into work session and vote ought not to pass on this bill. And that's what I have for you this morning, Senator. Thank you.
Thank you very much, Senator Davis, for providing that background and also for your good work on this bill. We really appreciate you being here today and to raising those important issues.
Thank you.
Yeah, thank you. And with that, and at the bill sponsor's request, we will close the public hearing on 793. And is there a motion to go into work session on this bill? Moved by Representative Thorne and seconded by Representative Reckett. And is there a member of the committee who would like to put forth a motion at the request of the bill sponsor? Go ahead, Representative Moriarty.
At the request of the sponsor, I move ought not to pass.
Thank you. Is there a second? Seconded by Representative Poirier. And Ms. Panett, I think we are ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll call the absentees. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 11 members voting in the affirmative, 0 in the negative, and 3 members are absent.
Thank you very much, Ms. Panett. And with that, the motion carries. Ought not to pass. We'll close the work session on 793. And once again, Senator Davis, it's wonderful to see you today and thank you for your service.
It's great to see you, and I hope you all have a great weekend. Thank you very much.
Take care.
Take care.
And with that, we'll move forward and open the public hearing on LD 908. This is an act to protect Maine residents and organizations from unreasonable and illegal surveillance, monitoring, and tracking. It's being presented by Representative Warren of Scarborough, and I am just going to invite her to join the panel. And Representative Warren, whenever you're ready, you can activate your audio and video.
Good morning.
Good morning and welcome to the Judiciary Committee.
Thank you.
You can proceed with your bill presentation whenever you're ready.
Great, thank you so much. Good morning, Senator Carney, Representative Harnett, and the colleagues, my colleagues of the Judiciary Committee. I want to just state up front that I am asking saying that I'm looking to have this bill moved to the Committee on Transportation. I don't believe it's within the jurisdiction of your committee, but I'm going to move forward giving more detail as this is a concept draft, and I appreciate your time and consideration this morning. So after 9/11, there was a national effort to move in this direction of facing a quote unquote war on terror. In a well-intentioned effort, there was a creation of immense amount of civil liberties violations, breaches from, I would argue, the Patriots Act to ramping up of the security state to the work of the Department of Homeland Security in some instances, unfortunately. Now, it's my strong belief that at this time, we need to return to the decisions made in this period, spanning over 20 years as we remove ourselves from Afghanistan. And with this privilege of hindsight, I think that we could take an opportunity to view certain issues of civil liberties in a new light. With this bill, I hope we can advance a common sense reform which moves us in the direction of undoing immense harm, wasted state resources, overworked law enforcement, and public safety officials, to speak nothing of the separation of families, as well as the disruption, harm, and terror experienced in the lives of many human beings across Maine. Now, at various instances in the past 20 years, in this effort of war on terror, there have been moments of resistance where the Maine legislature, governors, citizens, organizations have spoken up and attempted to resist this overreach by the federal government on our state and way of life. One such instance is requiring proof of legal citizenship in the issuance of a driver's license or state ID for Maine residents. Until 2008, Maine had been one of few states that had no rules on the books limiting licenses to legal US residents, including undocumented immigrants who would otherwise be eligible for driver's licenses and state IDs in the state of Maine. This simply means that we had not collected unnecessary information from private Maine residents. At that time, the Department of Homeland Security was pressuring Maine and other states in New England to tighten laws in this broader effort of a war on terror, which sought to track and monitor human beings in our country as if we here were a site of a kind of war upon our own residents, where our neighbors were set up to be assumed criminals and their rights undermined in a subversion of justice, guilty until proven innocent. Then Governor Baldacci introduced a bill to the Maine legislature, which did pass and was signed into law to create a rule that effectively prevented undocumented immigrants and other individuals without a social security number from obtaining licenses. To their credit, the Maine legislature had passed a law 1 year earlier in 2007, which barred the Secretary of State, who oversees the motor vehicle regulations, from complying with the Real ID standard, requiring that higher surveillance standard. When passed, Governor Baldacci said the law, quote, increases security and fulfills my commitment to the Department of Homeland Security. Well, as an independent, I might be especially biasly sympathetic to the separation of state and federal governments, but with that bias, I do believe we have the right to act on our independence here. We have the right to determine for ourselves the laws that will best keep our community safe in the state of Maine. That is our duty to determine as a legislature. And it's not the power of an unelected federal agency like Immigration and Customs Enforcement. Secretary of State Shannon Bellows, then executive director of the Maine Civil Liberties Union, affirmed this very view at the time, saying that there were legitimate questions raised concerning a federal agency requiring a state legislature to pass this legislation, as well as about the constitutionality of the Real ID Act, saying, quote, the legal status requirements pushed on us by the feds violate our civil rights while doing nothing to make us any safer. For the Department of Homeland Security to have singled out Maine in this way was an extraordinary abuse of power. Well, today, more than a dozen US states have already accepted to allow driver's licenses and state identifications without requiring a proof of citizenship to the state. In addition, so does the District of Columbia. Some measures intended to keep Mainers safe do just the opposite, and that is a shame. The job of public safety officials, our local, county, and state law enforcement is made immensely more difficult when made to work on behalf of a completely separate federal agency, ICE, instead of focusing on keeping our community safe here. I appreciate your consideration of this piece of legislation, and I ask that it be moved to the Transportation Committee to be considered under their jurisdiction. Thank you for your consideration, and I am, of course, happy to take questions at this time.
Thank you very much, Representative Warren. I do actually have a couple of questions for you. Do you have proposed amendment language that you plan to offer in the Transportation Committee?
Yes.
And have you reviewed it with the chairs of the Transportation committee, and are they willing to accept transfer of this bill to their committee?
No, I have not reviewed it with them. And so I don't know whether they would be willing to take it.
Okay. Thank you. I think that from our perspective, procedurally, we can't vote to send it to transportation without knowing how that committee feels about it. We also are in a situation this late in the session where concept drafts are raising concerns because we're just running out of time to work on bills. So that's kind of where we are as a committee. So if you could, prior to the work session, actually, as soon as you can, check in with the chairs of transportation and then send co-chair Harnett and I an email letting us know if the transportation committee is willing to accept the bill. That would be really helpful. And thank you very much. And I'm not going to open it up to questions from committee members because either way, this is a bill that we're not going to do any work on. But let me just check and see if well, actually, I'll ask. I'm looking at those who are in the attendee space. If you are here and wish to be heard on LD 908, I'm not sure that we're going to take people off the attendee list, but I just want to know for my own information. Is there anybody here who is in the attendee space who wanted to speak on 908? Okay, and so because we are not going to hear, to conduct a hearing on 908, I'm going to ask the bills, I'll tell the bill sponsor that Maria Woodbury and Michael Kebeda are here and are wish to support your legislation. So if you could please check in with them as you move forward. All right. Okay. Thank you very much. And go ahead, Ms. Warren, Representative Warren.
Oh, thank you. I just wanted to also flag that Kelly Merrill is also here, and as well Grace C. Murnane.
Oh, good. They didn't raise their electronic hands. I'm glad that you pointed that. I just wanted to make sure that you were aware of the interested members of the public who wanted to support you should the bill move to the Transportation Committee. Great. All right. Thank you. Representative Moriarty, did you have wish to raise an issue?
Just procedurally, I would move to table.
I don't think we actually need to do anything at this point because we're just going to end the public hearing. We'll just close the public hearing. Thank you. All right. And so again, Representative Warren, thank you very much for coming before the Judiciary Committee again. And thank you for raising these important issues about the Real ID system. And with that, we'll close the public hearing on LD 908. And at this point, we're going to move on to our next bill, which is LD 214, an act to eliminate qualified immunity. And I'm going to turn the virtual gavel over to co-chair Tom Harnett. And thank you very much, Representative Harnett. It's all yours.
Thank you very much, Senator Carney, and welcome to all in attendance today. I am going to open the public hearing on LD 214, an act to eliminate qualified immunity for police officers. And before turning it over to the bill's sponsor, I want to make a few remarks about procedure. We have over 40 people signed up to testify on this bill, including the bill sponsor. I will be enforcing the 3-minute clock for everyone other than the sponsor. What I will do when you have about 15 seconds left, I will show you my phone, which has the timer, and I am going to have to do a hard stop at 3 minutes because otherwise, just with 3 minutes, we're going to have over 2 hours of testimony. I would also just ask committee members to keep in mind that this is a public hearing. We are here to listen to testimony. While there may be questions that need to be posed, if you have a clarifying question, I will let some of those go, but I don't want this to turn into a debate. We'll debate the issue at our work session. This is really just to get the information in front of us so that we can bring the hearing to a conclusion in a reasonable time. And I hope that we can work together towards that end. Senator Carney?
Would it be helpful to you, Representative Harnett, if I run the timer?
It would be extremely helpful.
I will do that.
Carney. Thank you. Thank you very much. So look for Senator Carney holding up the phone, and then she will let me know when the 3 minutes is up. So I'm going to begin by calling the bill's sponsor, Representative Jeffrey Evangelos, a member of our committee. Welcome, Representative Evangelos.
Thank you, Representative Harnett. Thank you very much. And good morning, Senator Carney, Representative Harnett, and other distinguished members of the Judiciary Committee. I am Representative Jeffrey Evangelos from Friendship, and I represent House District 91, and I am speaking today in support of LD 214, an act to eliminate qualified immunity for police officers. As the bill summary indicates, LD 214 eliminates the ability to assert a defense of qualified immunity for civil actions concerning the actions of state police officers, sheriffs, deputies, constables, municipal police officers, Marine Patrol officers, game wardens, and Capitol Police officers brought under the Maine Civil Rights Act. In plain English, this bill will allow people who have had their civil rights violated by the unlawful or unethical actions of law enforcement to pursue a civil rights claim in Superior Court. This bill represents a long overdue reform that will align the rights of all people, including the police. One nation, one people, all subject to the same laws, no exceptions. Let us never forget that we are a civilian nation ruled by civilians, and that the police and military are subservient to civilian rule, just as President Eisenhower asserted when he assumed the presidency in 1953. When asked if he was going to wear his uniform after he was elected in November of 1952, Eisenhower said no, that he is now a civilian leader of a civilian nation and put his uniform away forever. That valuable lesson seems lost on law enforcement today. The current double standard police benefit from reminds me of the lessons we learned in high school when we read George Orwell's Animal Farm. It's an allegory about what happens when one class of people, namely the police, adopt standards that benefit just them at the expense of their peers. Some people are more equal than others. As you may recall, that story didn't end well. Recent news reports from across the nation and right here in Maine make it imperative that Maine adopt standards that allow its people to legally confront law enforcement in court when the police abuse their authority and violate our civil rights, up to and including the unjustified, unlawful use of deadly force against unarmed individuals. How could anyone, including the police officers, be so obtuse to be devoid of the tragic developments sweeping the nation in reference to police abuse of power? Maine's abysmal record of justifying every single police shooting since records have been kept, with a score of approximately 170 to 0 ruled justified by Maine's Attorney General's office, highlights the need for this critical reform. Maine's criminal justice system and the Attorney General's office suffers from serious systemic biases, conflicts of interest, lack of accountability, and lack of transparency. Cover-ups have become the norm, and our free press has been shut down by law enforcement's refusal to release public records and information. Under current law, malicious police officers are held harmless under the qualified immunity standard, a standard that was developed out of court doctrines, not legislative law. Perhaps we finally have the answer as to why the Attorney General's office has ruled every law enforcement use of force justified, including incidents when the victims who were killed were unarmed. In a letter I received on April 7th, 2021, from a retired Waldoboro police officer, a sergeant, who said he attended a training session that was conducted at a local high school, and I quote, "The instructor was Brian McMaster, Chief of Investigations of the Attorney General's Office. Officers from Knox and Lincoln agencies took this training if they could make it. State police officers were frequently there as well. The class was about officer-involved shootings. I remember hearing Brian McMaster tell this class that as long as he was in charge of police officer-involved shootings, we had nothing to worry about, as all shootings would be ruled justified. This always bothered me, and I reflect on it. This from time to time, close quote. This gentleman is in his 80s now. After receiving the letter, I called the retired officer and asked him if he was in the Waldoboro Police Department in 2007 when an unarmed 18-year-old boy, Gregory Jackson, was shot in the back 4 times, September 23rd, 2007, with another execution-style shot to the back of his head, killed by Waldoboro police while he ran into the woods. He said no, he had already retired, but if he was still employed there, and I quote, "I would have quit in protest. Everyone knows that case was unjustified." The Jackson family was prevented from receiving any justice because of a cover-up and because qualified immunity prevented them from prevailing in the courts. In 2019, I presented this case to Attorney General Fry and asked for a review. He agreed. 2 years later, we are still waiting for his ruling. I plan on entering this letter into evidence on this case to the Attorney General today. As the recent 6-part Bangor Daily News series exposed, systemic problems and abuses within Maine County Sheriff's Departments have gone unpunished and uncontested. On April 18th, the Press Herald and Bangor Daily News collaborated on investigating scores of serious documented cases of misconduct at the Maine State Police. These cases involving both agencies included officers beating up their wives. These officers are still serving on active duty status and in good standing. Cover-ups and the abuse of non-disclosure agreements, along with the refusal to release critical information to the press, have become the norm and have all contributed to our loss of faith in law enforcement. I consider this to be an abuse of power. This legislation will level the playing field, so when our good people are victimized by the unlawful actions of the police, they will now be able to seek redress in the courts. Conversely, good police officers who do the right thing, abide by our laws and constitutional protections, have nothing to worry about. Criticism of LD 214 by law enforcement accuses the bill's sponsor of contributing to the law enforcement's recruitment and retention problems before it is even enacted. Let's be clear about something. The recruitment and retention issues experienced by police in Maine is a problem of their own doing. Why would a good officer want to work with systemic abuses tolerated and encouraged? Last month, we learned from the Bangor Daily News that the town of Gouldsboro gave its police chief a verbal warning and ordered him to undergo sexual harassment training for harassing a female employee. A town patrol officer was fired and then given his job back. And last month, a 3rd police officer quit, calling Gouldsboro Police Department, and I quote, "an embarrassment to law enforcement" in his resignation letter, Bangor Daily News, March 19th. And on April 3rd, 2021, the Bangor Daily reported that low morale and few applicants were the causes of the recruitment and retention crisis. So let's be clear about this. I don't believe in defunding the police. I'm not a defunder. This bill is about promoting good practices and the good work of the good men and women who serve our state. In May 2020, a heroic state trooper blew the whistle on the Fusion Center's illegal activities, exposing that agency's multiple constitutional violations against law-abiding citizens, documenting serious violations against our right to privacy guaranteed under the 4th Amendment and the right to peaceably assemble guaranteed under the 1st Amendment. The trooper who brought these issues to light was retaliated against. When confronted with these unlawful actions by the state police at a joint hearing of criminal justice and judiciary last summer, Commissioner Sawchuk refused to truthfully answer questions from his civilian overseers, the Maine legislature, highlighting the abuse of power law enforcement believes it is entitled to. I've given you 2 references to that. On a personal note, I've been a legislator since 2012. Not once have I ever come under the ruthless attacks that members of law enforcement community have subjected me to in retaliation to this bill, once again demonstrating the serious crisis that plagues law enforcement, including anonymous threatening phone calls, libel on social media, threatening emails, threats against me to never call the police, demands that Capitol Police remove any security for me personally, and the lowest of them all, attacking my dead father, a former state trooper who fought in World War II, for bringing me into the world. This harassment just magnifies the systemic abuse that plagues law enforcement profession in Maine. And here are some documented examples. Just 2 days ago, a retired Gorham police officer, Mike Mercer, posted this on Facebook under the picture of my grandchildren. "Where are you now? Show your face. LD214 is insanity. All you idiots who voted for this putz doesn't deserve to have a police officer respond to your house or to save you and your kids. You will suffer by voting for this idiot. You can redeem yourselves by calling and telling the whacked out legislature we need our local police." And his second post, again under the picture of my grandchildren. "This is a picture of a person who wants to end American law enforcement. Are you happy you voted for this idiot, Jeffrey Evangelos, communist representative? And this, you, sir, are disgusting. Your regard for our local law enforcement is appalling. I can't believe you consider yourself a representative of the state of Maine. You should be reminded that you work for us and that law enforcement officers are taxpayers that perform such more essential service than any of you blowhards in the Capitol. I hope you and all your like-minded colleagues have their police details pulled. And finally, maybe someone needs to remind you that you'd also work for us. Typical hypocrite. One other thing. Your father would be ashamed of you." Law enforcement should remember that the uniform they wear is paid for by us, the civilians who you work for. 100% of the taxpayers pay for your uniform, your gear, your guns, your vehicles, and the police professional liability insurance that covers office in the event of civil rights violations. And I want the committee to keep in mind when they hear testimony today, that police departments are required to carry this liability insurance. And this protects police officers and their families from personal liabilities. Police departments carry professional liability insurance. I believe from the polls I've seen that a majority of taxpayers want qualified immunity reform, with 63% supporting the elimination of qualified immunity for police officers, according to the Cato Institute. The Cato Institute is a conservative organization. This week, the United States Justice Department Civil Rights Division initiated an action against the Louisville, Kentucky police departments, alleging civil rights violations, racial profiling, illegal searches, surveillance against constitutional protected activities, and unjustified use of force. Sound familiar? Just read the recent groundbreaking journalism of the Maine Press Corps that documents these systemic abuses right here in Maine. And what did the Maine State Police do to confront racial profiling in its ranks? They awarded John Darcy, the serial racial profiler, the Trooper of the Year Award, November of 2020. In Louisville, Mayor Greg Fisher said Monday that he will strongly welcome the Justice Department's review, saying that it will help the city become safer and more equitable. Good officers will welcome this announcement and see it as an exciting time to be part of reform and transformation, he said. And Louisville Police Chief Erica Shields called the federal probe an opportunity, in quotes, to speed up policing changes and build trust with the broader community. And I quote, "I think it's necessary because police reform, quite honestly, is needed near every agency across the country," she said. In closing, on April 25th, the National Council of State Legislatures reported that 4 states, Colorado, Connecticut, Massachusetts, and New Mexico, have already enacted a limited officer immunity from civil suit for misconduct. And on March 25th of this year, the New York City Council abolished qualified immunity for police officers in that city, a city with the strongest police union in the country. Criminal justice reform is sweeping the nation. The public's confidence in law enforcement is at a record low, and for good reason. Police misconduct must be addressed in an open and transparent process, ensuring accountability and protecting the civil rights of our people. LD214 represents a critical step in the reform movement. Governor Mills, Attorney General Fry, and my colleagues in the legislature, the criminal justice reform train has left the station, and Maine hasn't even caught the caboose. Let's get on board by adopting this critically needed reform. Thank you for your consideration. I'm happy to answer your questions. Documented proof and information is attached below my testimony. included are abstracts from Yale Law School, Georgetown University, and the New York State Bar Association, which explains the history of qualified immunity and the need to abolish it. Thank you very much.
Thank you very much, Representative Evangelos, for bringing this bill forward. And I do have a question before I open up to the committee. Has your testimony been submitted electronically? Because I've not seen it in the.
Yes, it was submitted, and Peggy wrote me about 20 minutes ago and said it's been put in.
Okay, I didn't see it in the list that I'm looking
Yep.
at, but that's fine. It'll probably be elsewhere online.
If it's not, it's coming. So yeah, but she confirmed it's in the system.
Okay, thank you very much. And
You're welcome.
before opening for questions, I did want to welcome Senator Keim, joined, I believe, after introduction. So I wanted to give you the opportunity to introduce yourself.
Morning, everyone. Sorry for the delay in joining. I was on other committee business. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is Northern Oxford County.
Thank you and welcome, Senator Keim. And now turning to questions from the committee, Representative Thorne.
Thank you, Mr. Chair. Mine is more not a question, just a statement. And out of respect to my colleague, Representative Evangelos, and a promise that I made to him and other committee members, I won't be asking any questions of him this morning. Thank you.
Thank you, Representative Thorne. Are there other questions from committee members?
Representative Harnett, we were just horsing around the other day. I'm not holding to Representative Thorne to that promise. He's free to ask me some questions.
Thank you, Representative Evangelos. I appreciate that gesture. Are there questions from committee members? Seeing none, what I'm going to do now is we have three members of the legislature who have signed up to testify, one in support and two in opposition. As a courtesy to our colleagues, knowing how busy their schedules are, I'm going to call them out of order, and then I will go to those in favor, those opposed, and those neither for nor against. And again, and you'll hear this hopefully not too often, other than the sponsor, everybody, including co-sponsors and legislators, will be limited to 3 minutes of testimony. And Senator Carney will be holding up the timer when there's to give you a warning, and then we will need to stop at 3 minutes. Senator Miramont, welcome to the Judiciary Committee, and begin your testimony when you're comfortable.
Thank you, Representative Harnett. Senator Carney, great to see you. Distinguished members of the Judiciary Committee. I am Dave Miramont, and I represent Senate District 12, which is Knox County, except the town of Washington, and the county seats Rockland. And I am here, I didn't change that one, but I'm here to support this bill. Before I get into what I wrote, I just wanted to point out that I just was in criminal justice talking about the change from 2000 when I was first elected to the select board and we were working on community policing because of issues that were going on. And we also had a lot of our community police in Camden and Rockport particularly, who had been over serving in the Middle East, and they brought back military policing techniques, and the departments had been moving to military policing, which introduces a lot of confusion and stress into a situation where they should be arriving and disarming. And they were trying to use that sort of model on our teenagers, and it was really causing problems. And the persons that suffered most were those who were just there, but then being confronted. And the police didn't, because there was this culture of keeping information within a department and not letting it get out. And then I see that continues today with the information about the state police and what they've been doing. And that comes from the top down. When you have a training academy that all officers of every type of law enforcement are required to go to, then you started at the top and go down. So some of my bills session have been about addressing that top-down mentality that has infected our police. So I don't have time because I'm not used to co-sponsored legislators not having more time, but I see what you're trying to do. So I'm going to go into my testimony and everything else will come out with the number of people. When this subject came up, it was in relation to the acts of certain police officers who had abused the public trust, and yet we're still working as police. It seemed reasonable that having given our police the authority and autonomy to enforce laws, they would also be held to a higher level of responsibility and integrity in using them. Yet it's proven not to be the case because of a concept called qualified immunity. In practice, this has turned out to have the effect of actually allowing police to have a standard of error and omission lower than any civilian would ever enjoy. It allows the police to claim that no matter what action they took, they did so from a belief that their thought about the action justified the action. Not that the suspect had actually done something, just that the officer believed that they had. This argument has been used even when there was the opportunity to verify their suspicions or when there was doubt as to the accuracy of information used to form the belief. We all know that there are many police who do their job within the law.
Senator Miramont, I apologize for interrupting.
Yes, sir.
But I do need to ask you to wrap it up. The committee will review your written testimony as submitted, but if you could wrap it up, and then I will open it for questions.
Okay. I always throw in, we have great police, most of them, and they shake their heads when I point out some of the issues like the Gregory Jackson shooting or the Jackman Select woman who was shot in her house, or some of these. You have my testimony and it's posted online. I'll stop.
Thank you very much, Senator Miramont. And again, the clock is just so we can manage our workload.
Absolutely.
Are there questions from committee members for Senator Miramont? Seeing none, thank you very much for your time today and for your testimony. And I assure you that your testimony that it has been submitted in written form will be reviewed by the committee. Thank you.
I trust that it will. I respect your work. Thank you very much.
Thank you. I am now going to call on representatives who registered to testify in opposition and would ask that Representative Pickett be moved over as a panelist. Welcome, Representative Pickett, to the Judiciary Committee. As you may have heard, you probably heard that we are running a 3-minute clock today, but I welcome your testimony, welcome you to the Judiciary Committee, and please begin testifying when you're comfortable.
Thank you, Representative Harnett. Good morning. Senator Carney, Representative Harnett, and esteemed members of the Joint Standing Committee on Judiciary. I'm Richard A. Pickett, State Representative for House District 116, which includes the towns of Canton, Dixfield, Hartford, Mexico, and Peru. And I'm here today to speak in opposition of LD 214, an act to eliminate qualified immunity for police officers. I'd like to begin my testimony with a few facts about the doctrine of qualified immunity that have been brought to my attention. The doctrine of qualified immunity is based in United States Supreme Court precedent and does not protect law enforcement officers who knowingly violate the law from criminal charges, internal investigation, discipline, or termination. Qualified immunity is not automatic and is weighed on a case-by-case basis relative to the facts of a singular case. It applies or is granted only in cases where an official, such as a law enforcement officer, is found to have acted within the law, departmental policies, and in good faith during the performance of their duties. Qualified immunity does apply to and protects a broad range of government officials and entities, lawmakers, firefighters, teachers, school administrators, and more, from civil liability for following the rules, policies, and regulations set forth by the laws they are sworn to uphold. It does not provide automatic or blanket immunity for criminal conduct. The proposed law LD 214 in the Maine legislature will eliminate qualified immunity for those in Maine law enforcement only, and no other group of public servants who are covered under the qualified immunity doctrine. This critical qualified immunity doctrine has been in place for many years and has served its purpose effectively. Do we really believe that any society can long endure without a healthy respect for the rule of law? I believe this proposed legislation is extremely detrimental to the law enforcement profession. If LD 214 becomes law, it will be the first step toward totally eliminating policing in Maine. If a citizen has the ability to sue an officer personally, if that officer has to pay any judgment out of his or her personal pocket, the profession will be put at serious risk of early retirements, as well as experience devastation to recruitment of future police officers. We hire these law enforcement professionals with the expectation that they will take risks and do the type of things that often puts them in harm's way while protecting and serving us. If they have to second guess their training and wonder if what they are doing can lead to a personal lawsuit, it immediately becomes a serious public safety issue. We have to ask ourselves what man or woman would consider a career in law enforcement here in Maine and risk the financial stability of their spouse or children to serve others as a law enforcement officer. I urge you to vote ought not to pass on the bill. We cannot have officers be held personally responsible for the outcome of each and every situation they encounter. This is a dangerous path to embark on in the name of public safety. Thank you for your time and consideration of my testimony.
Thank you very much, Representative Pickett, for presenting your testimony to the committee today. We greatly appreciate it. Are there questions from committee members for Representative Pickett? Seeing none, again, we thank you very much for your testimony and your time, and you'll be moved back to the attendee room. You're welcome to stay, but I imagine, like most of us, you may have other obligations you have to attend to as well. But thank you,
Thank
sir.
you very much, sir.
I will now turn to Representative Harrington. Welcome to the Judiciary Committee, Representative.
Good morning.
And begin testifying as soon as you feel comfortable.
Sure. Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. I am Representative Matt Harrington. I represent part of the city of Sanford in House District 19. I'm testifying in strong opposition to LD 214, an act to eliminate qualified immunity for police officers. When not performing my duties as a legislator, I am the only full-time active police officer in the legislature. I have been a police officer here in Maine for almost 14 years. Since this bill was submitted, I have had law enforcement officers from nearly every corner of the state reach out to me expressing their disappointment. I believe this bill is a solution in search of a problem. Maine simply does not have a problem. Our criminal justice academy is top-notch and our officers are very well trained. Rather than get into the legal details of qualified immunity, I simply offer you a boots on the ground perspective. When I began my law enforcement career, it was incredibly competitive. At the age of 20, I applied to multiple agencies to be a summer reserve officer, and thankfully was given an opportunity by the town of Kennebunk, but was turned down by several others. It was just that competitive then. When I began seeking full-time employment after college, I again applied to many departments. I recall going to physical fitness tests with 20 or more other candidates, all seeking a single opening. I again was turned down by many agencies, but was finally granted an opportunity. Over the last few years, we're lucky to receive 1 or 2 applicants for a job opening. My department has been advertising an opening since early January, if not received any applicants. The more unnecessary scrutiny this career faces, the harder recruitment and retention will be. This has been proven to be quite counterproductive to the apparent goals of the sponsor. Many quality candidates simply no longer are applying. It recently took over a year to fill an opening. That position was filled by an officer from another department, thus just creating an opening in another part of the state. With these desperate recruiting times, sign-on bonuses have become commonplace. We've essentially created a shell game of officers jumping from department to department. Take one look at the Maine Criminal Justice Academy website and you'll see the sheer number of police openings. I've never seen this many before. Simply put, Maine's law enforcement officers are exhausted. We go out there each day and do the right thing and are tired of constant scrutiny. We understand we must be held to a high standard. We undergo medical and psychological evaluations. We have to take a polygraph exam, physical fitness exam. There's virtually no other job in Maine that undergoes that level of scrutiny just to get through the door. Officers then attend the Criminal Justice Academy for 18 weeks, which is a high stress, high expectations environment. Qualified immunity does not allow police officers to go rogue. It simply provides protection against frivolous lawsuits when we've done the right thing during the course of our duties. Why stop at police? Why do we as legislators have qualified immunity? Many pieces of legislation put forth and passed here that have been damaging to main businesses. Shouldn't legal action be able to be taken against these sponsors for submitting that legislation? I think this is just food for thought, and I would strongly urge this committee to vote ought not to pass. Thank you.
Thank you very much, Representative Harrington, for your time today and for presenting testimony to the Judiciary Committee. We greatly appreciate it. Are there questions from committee members for Representative Harrington? And seeing none, again, we appreciate your time. You'll be moved back to the attendee room. You're certainly welcome to stay, but as I said to Representative Pickett, I imagine you might have other things on your plate today as well. Thank you very much for your time.
Thank you.
I now want to explain how we're going to move forward. Zoom presents some challenges. A few minutes before the hearing, I was presented with a list of people who registered to testify online. I will be operating from that list, going in those in favor, then to those opposed, then to those neither for nor against. I know that some people signed up after the hearing began. I rest assured you will have your opportunity to speak, but because we have so many people to testify, I will get to you after we go through our first round of people testifying. So I will call on people as the clerk moves them over based on that list, and the first person testifying in support of this measure is Dale Boyce. As soon as I see Dale on the screen, please unmute your mic, activate your video, and begin your testimony. And welcome to the Judiciary Committee.
Good morning, all. You don't know me, or maybe you do. I think I'm known by Augusta as Aunt Dale. I'm Jason Gora's aunt. He was killed on February 2nd, 2020. It was a tragic event. I'm going to try and make my statements short, but from a personal standpoint, I wanted you to know qualified immunity affects people's lives. It's difficult sometimes for me to talk about this, but I don't think the police got up that day and said, today I'm going to kill Jason Gora. But their actions created the tragedy. It was a wellness check. We were concerned for him. He had some suicidal thoughts. We reached out to the people that we had always grown up to say, you can trust these people, they will help you. We were up front, we said, we believe he has a gun. We didn't want anybody in jeopardy. We didn't want Jason to die that day. We didn't want anybody to die that day. But instead, what happened were their actions were wrong. Their training went out the window. 3 of these officers were trained to deal with mental illness. They spotted him on the road. They followed him for a distance. He did not break any laws. He did not have a warrant for his arrest. It was a wellness check. He started down the road, and what did they do? They escalated a mental health situation. They turned on the sirens. 4 of them chased him at 80 miles an hour down a country road. They not only put Jason in jeopardy, they put themselves in jeopardy. They put the public in jeopardy. There were cars on that road. It could have been a catastrophe for everybody. Instead of de-escalating, they escalated and escalated and escalated. And then they put another policeman in the harm's way by putting him in a position where he was going to put spike mats down. I believe he was too far in the road. They came on him too quick. Jason did not intentionally hit that car. He did not intentionally want to kill anybody. His only thought was he wanted to get away. He didn't want to go back to the hospital. He didn't want anybody to help him. His family wanted the help. So instead, what happened is they collided. He panicked. He got out of the car. He continued to run away. He wasn't threatening them. He was running away. They drew their weapons. They chased him. His hands were visible. He had nothing in his hands. He had no weapon in his hands. They chased him across the parking lot. He fell. They shot him on the ground. And AG Fry said that was justified. I have a hard time with that. I have a hard time with training and training and training. And then when they have an opportunity to use that training, they choose not to use it. Why? Because they have qualified immunity. No matter what they do, it's always justified.
Ms. Boyce,
Money?
Ms. Boyce, I'm sorry, and
Yes.
I apologize. I know how difficult this is to share, but the 3-minute time has run. That you
All right,
really-
I will just close and say, please, please make them do their training. Don't give them a shield that says you will never be accountable. The AG doesn't make you accountable. The state of Maine doesn't make you accountable. We are all victims. Thank you.
Thank you very much, Ms. Boyce, for taking the time to testify today. I cannot imagine how difficult it is to share this story. But thank you for being here.
Thank
Are
you.
there questions from committee members for Ms. Boyce? Seeing none, thank you very much for your time.
Thank you. Have a good day.
And I wish you peace.
I trust that you will do the right thing. Thank you.
And I will remind people, I sometimes neglect to do this. When you begin your testimony, please list your town of residence, your name and your town of residence.
My name
I
is
will-
Dale Boyce and I'm from Standish, Maine.
Thank you, ma'am. That was my fault. The next person to testify is Jerry Greenfield. Mr. Greenfield, as soon as you're ready, unmute your mic and activate your video. And I know that there may be 2 people testifying, sharing the testimony, but I will let you know that it's limited to the 3 minutes as I instructed someone who told me you would be here today. So thank you very much and begin your testimony when you feel comfortable.
Good morning, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. We are Ben Cohen and Jerry Greenfield, founders of Ben & Jerry's and co-chairs of the campaign to end qualified immunity. This campaign is a national coalition of business leaders, professional athletes, lawyers, former law enforcement agents, advocacy groups, and concerned citizens dedicated to holding cops accountable. We are here today to express our support for LD 214, an act to eliminate qualified immunity for police officers, sponsored by Representative Jeffrey Evangelos. If you want to build trust in public safety, support good law enforcement officers, and respect Mainers' civil rights, you have to vote yes for LD 214 and to end the unjust doctrine of qualified immunity. You know, there's people in America who see the trivial act of wearing a mask as victimization. Try being Black in public. Try hundreds and hundreds of years of racial hate and injustice. Try walking down the street and being harassed just because you're born Black. And try having a civil rights law that was created to allow you to sue a cop who abuses you, so distorted that now it makes an abusive cop immune from prosecution. You know, this is really about accountability. You can do all the training you want. You can have all the procedures you want. If you don't hold someone accountable, you're not going to get the result you're looking for. We learned that in business. And now I'd like to turn it over to my partner, Jerry Greenfield, the other co-chair.
Good morning. Freedom from malicious conduct, freedom to obtain justice, freedom from victimization has been turned into oppression. That is what qualified immunity is, oppression. People like to talk about racial equality and how we're making progress, but progress is always next session, next election cycle, next time it's politically convenient. Being victimized by the police isn't convenient. Being told through legislative inaction that Black lives don't matter isn't inconvenient. Some may say, oh, well, this won't affect me. You're right. If you're not Black, this probably won't affect you, because wearing a mask in public isn't victimization, but being Black in America while cops have qualified immunity is. Give these victims justice. Give the American people back their civil rights. Give the American people back their right to sue unlawful acts against bad cops, because it was already ours. We had that right, and the Supreme Court took it away from us with qualified immunity. It's just not good enough to have lawmakers say Black Lives Matter and not save Black people from being victimized. It's not good enough to sustain the status quo of policing in Maine. The status quo is unsustainable. Without accountability, there will never be trust in public safety. We urge you to stand on the side of justice and vote yes on LD 214, ending the unjust doctrine of qualified immunity. Thank you so much.
Thank you very much, Mr. Cohen and Mr. Greenfield, for presenting your testimony to the Judiciary Committee today. We greatly appreciate hearing from you on this important issue. Are there questions from committee members for Mr. Cohen or Mr. Greenfield? And seeing none, again, thank you very much for your time and for the testimony that I believe you submitted in written form as well.
Thank you very much.
I will now move to Diane Olterzewski. I'm sure I'm, yeah, okay. Welcome to the Judiciary Committee. This is part of the hardest part of the job, I think, is dealing with some names sometimes. Whenever you are comfortable, please feel free to begin your 3-minute testimony.
Thank you, co-chairs Carney and Harnett and distinguished members of the committee. My name is Diane Olterzewski. I live in Belfast, Maine. I thank the sponsor of this bill from the bottom of my heart. I believe it is essential that we pass LD 214 without delay and eliminate qualified immunity as a defense against prosecution and sentencing for any licensed officer as described in the bill. Our police, no less than our citizens, are subject to our law with its core principle that a suspect is innocent until proven guilty. We recognize that extensive and thorough screening and training is essential for police to guide an officer's action in the potentially dangerous situations he faces or she faces. But Americans have now learned that screening and training of recruits is woefully inconsistent and inadequate across the country. We've learned to our horror that where racial bias and de-escalation training is offered, it is often blown off by the police culture of assumed immunity that tends to prevail in these departments. Emboldened by police unions that manage to scrub the record of bad actors and the blue wall of silence, officers too often act as arrogant, lawless vigilantes. I refer you to the excellent discussion about how to reform policing, titled "Policing in America is Broken and Must Change, but How?" It was in the New York Times Magazine last June 21st, and it includes telling input from retired Camden, New Jersey Police Chief J. Scott Thompson. Please read Chief Thompson's account of the pervasive police culture he had to dismantle and begin again to build an intelligent, respectful team of neighborhood police. I begin to think that applicants should be required to pass a community review board before they can be licensed. What makes a bully? It is clear that too many applicants enter the force with hidden agendas, the promise of power and authority, compensating for a complex range of psychological problems, whether it be a sense of inferiority, a nagging resentment acted out inappropriately, a fear of impotence, the assumption or fear that anyone with a dark skin is inherently criminal. If we are to have law and order, we must be able to trust those to whom we grant deadly force. Failing that, we cannot continue to promise qualified immunity to individuals whose judgment is so questionable and who are daily committing hate crimes themselves. Please vote ought to pass for LD 214. Thank you.
Thank you very much, Ms. Oltaszewski. Are there questions from committee members? Seeing none, again, thank you very much for your oral testimony today, and we have received your written testimony as well, which we will all review. Thank you very much. I will now move to Hannah Musgrove. Good morning. Whenever you're comfortable, please begin your 3-minute testimony. Welcome to the Judiciary Committee.
Thank you very much. Thank you, everyone. I live in Biddeford, Maine. I wrote to all of you at the beginning of April on this issue, personally to your emails, and I am in favor of eliminating qualified immunity. To respond to what Richard Pickett said earlier in his testimony, if qualified immunity protects against lawful action, why is it that so many officers who kill unarmed civilians walk free? If a police recruit is scared of a lawsuit against them, they should be sure to follow the law and they will be okay. In response to Matt Harrington, no, Maine is not safe from officers who unlawfully rape detainees and unlawfully kill on impulse. There have been instances of both here in Maine. Stop the killing. Sadly, we all know what this means without saying. Police killing of Americans is out of hand and they must be held accountable by the law. Not only is murder by police rampant, but physical assault and rape as well. This is public violence and terrorism, and police know they can get away with it because of qualified immunity. If a child is not reprimanded for bad behavior, they will not stop the bad behavior. Simple as that. We in the United States must stop turning a blind eye to police brutality. Police killing countless Americans a year is a public health crisis and should be dealt as such in Congress. I am glad to see this act presented here. It is a necessary step, so thank you for that. The government must say that this violence is wrong by eliminating qualified immunity. That is the first step. Police officers are civilians. Being a police officer is a job, a profession. At the end of the day, they go home as civilians, just like the rest of us go home from our jobs. Nobody should be above the law, but with qualified immunity in place, our judicial system is saying that police officers are, in a way. Their job is to enforce laws, not to be above it and not to abuse its power. We are demanding accountability for this despicable perpetuation of racism and violence and just outcomes for victims, as well as much more after qualified immunity is eliminated. Thank you for finally writing up this act to end qualified immunity, and I look forward to its passing. Thank you.
Thank you very much for your testimony this morning, Ms. Musgrove. And are there questions from committee members? Seeing none, again, thank you for taking the time to testify today, and I know that you have submitted written testimony as well, and that will be reviewed by the committee. Thank you, ma'am. I will now move to the next person on my list, Michael Kibita. Nice to see you again, sir. You can begin your testimony as soon as you are comfortable.
Thank you, Representative Harnett, Senator Carney, and esteemed members of the committee. Good morning. My name is Michael Kibita, and I'm Policy Counsel for the ACLU of Maine. On behalf of our members, we urge you to support this landmark legislation because it would restore faith in law enforcement by reaffirming the central principle that no one is above the law. Where there is a right, there is a remedy. This simple concept has been a central feature of legal systems that recognize some measure of individual rights for at least 1,500 years. The idea that every right necessarily entails a remedy was celebrated by the framers of the Constitution and was extensively embraced in Marbury versus Madison, the Supreme Court decision, which forms the basis for our entire judicial system. Today, the idea that a right implies a remedy is the reason why you can sue federal officials if they unlawfully break into your home. It's why unconstitutionally seized evidence cannot be introduced against you in a criminal proceeding. And it's why you can sue for damages, even if the unconstitutional search doesn't yield anything incriminating or illegal. Sovereign immunity, an exception to the principle that rights require remedies in order to be meaningful, rests uneasily with the idea that no one is above the law. That exception shields the state itself from certain suits. That rule should not extend to public officials who use their authority to break rules that apply to everyone. Unfortunately, some United States Supreme Court cases have suggested that police somehow are above the law. The result has been an unvarnished disaster. In a recent case, the Fifth Circuit Court of Appeals held that corrections officers were entitled to qualified immunity when they intentionally tortured a prisoner by making him sleep in a freezing cell covered in feces for 6 days. Even though the Supreme Court reversed that particular case, egregious cases like that happen all the time, including in Maine. Some states like Colorado, New Mexico, and Connecticut have realized that constitutional necessities, like the Fourth Amendment right to be free from excessive force or the Eighth Amendment prohibition of cruel and unusual punishment, will not be realized if officers cannot be held liable for the damage they cause. We should have the courage of our constitutional commitments and follow their example. But this bill can be stronger. If this bill were enacted, corrections officers would continue to enjoy the qualified immunity defense. We urge the committee to amend the bill to include corrections officers, along with other types of officers covered by this bill. Such an amendment would help ensure that incarcerated people can also enforce their constitutional rights, the same as people outside prison walls. We urge you to vote ought to pass as amended in accordance with the amendment that we suggest. Thank you for your time and attention, and I'm happy to try to answer questions.
Thank you very much, sir, for your testimony today and for the written testimony that you submitted as well. The committee appreciates your participation in the process. Are there questions from committee members for Mr. Cabetta? Seeing none, again, thank you very much for your time and testimony today. I will now wait for the committee clerk to move the next person into the queue, from the queue. And Ms. Panett, I'm not seeing, I do now, thank you. I will now recognize Stephen Drew. Mr. Drew, whenever you are comfortable testifying, please unmute your microphone, activate your video, and begin your 3-minute testimony. Mr. Drew, if you can hear me, I need you to unmute your microphone and activate your video so that we can see and hear you as you present your testimony.
Tom, it looks like Ms. March is also ready to activate it and ready to go.
Thank you. I did note that, and I will, since they are on the line, I will begin with Ms. March, Tanya March. Whenever you're comfortable, you can begin your 3-minute testimony, and welcome to the Judiciary Committee. You just need to unmute your microphone. You're still muted.
Hi. I am here to speak because I am a mother. I have 6 children. I grew up in a white household where we were taught to trust the cops and believe that they have your best interest at heart, that they are there to protect and serve. And as I grew older and began to have children of my own, I have interracial children, and I started seeing cases like Tamir Rice and other, even the woman that spoke earlier today about her nephew. And those things began to kind of begin a fear in me that my children were not safe, especially if cops were around. And the last thing that I would do if they were in danger would be to call a cop to come save them, because they could in fact be the ones that would actually endanger my children. And I believe that qualified immunity helps protect cops in these types of situations from actually obeying the training that they have been given. And I think that we need to push this bill forward so that way these situations do not continue happening and our children can be more safe and everyone can be held accountable for what they do with great there's great responsibility when you have a position of power, and they have a position of power and they need to be held responsible for that. Thank you.
Thank you very much, Ms. March. Are there questions from committee members for Ms. March? Seeing none, I thank you for your testimony. And Mr. March, I noticed that you had registered to testify as well. Do you wish to proceed, sir?
Yes, sir.
Thank you. Welcome to the Judiciary Committee, and begin your 3-minute testimony.
So my name is Andrew March. I think something unique about me is that I wasn't born in this country. And so I had to pay extra special attention to the Constitution for obvious reasons. I did not grow up. I grew up as a child in the 90s, and I did not grow up viewing police in a negative light. I remember our favorite shows as kids was NYPD Blue. It was a grimy, gritty show about cops in New York City. And our other favorite show was New York Undercover. Just basically this black guy and this Latino guy get together and, become detectives to try to help their neighborhood type of thing. So I don't come from this from an anti-police, anti-cop perspective. The other reason I don't come as from an anti-cop perspective is that both of my brothers are law enforcement officers. And one of them risks his life every single day. The reason that I'm against qualified immunity just has to do with in my mind, the contradiction to the vision of the founding fathers of this nation. We all know the preamble to the Declaration of Independence. We hold these truths to be self-evident. All men are created equal, endowed with inalienable rights, life, liberty, pursuit of happiness. The next line says that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. And obviously it goes on to talk about how, we have the right to amend laws and change them when those laws are not supporting that principle. It is obvious to me, and I don't think I've ever heard anyone who supports qualified immunity argue against this. The founding fathers would turn around in their graves if they heard that the children, their children, the men who picked up muskets because of grievance 15 in the 29 grievances, where it talks about how British officers were protected in mock trials. And that's one of the reasons they took up muskets. It's incredible to me to believe that those same men would say, yeah, that's great. You've got a group of people now who've got immunity from the Constitution. Great. Obviously, that's not the case. Furthermore, some of the defenses I've heard against qualified immunity are strange. One is, if we remove this, then there will be frivolous lawsuits. Well, were there frivolous lawsuits in policing up to 1967? Colorado just passed their qualified immunity, and as of December 2020, and the first lawsuit was a mother whose 4 children were held at gunpoint by the Colorado police, and it was all mistaken identity. Whoops. That's not a frivolous lawsuit. Finally, the idea that we're having a hard time recruiting people because of this is concerning to me. Wouldn't we want to weed out those police who would not want to join the force if they're liable for prosecution for violating people's constitutional rights? Isn't that a good thing, that a person would not join the profession for that?
Mr. Drew, I apologize for interrupting you, but we are really trying to work the 3-minute clock. So I would ask you just to wrap up quickly if you could.
Yeah, that was my last point. I'm over time. You guys have been very gracious. Thank you.
Thank you very much for your testimony today, for the both of you, for presenting to the Judiciary Committee. Are there questions from committee members for for Andrew and Tanya, which is how I see your names up here? Seeing none, thank you very much for your time and testimony. Greatly appreciated. I will now turn to Stephen Drew. Glad you got the technology worked out. Welcome to the Judiciary Committee, and please begin your 3-minute testimony.
Yes, I think I've got it worked out. Can you hear me okay now?
Hear you just fine, sir. Thank you.
Okay. Well, first of all, we'd like to thank you all for allowing us to add our voice in support of this bill. What I'd like to do is I'd like to read a statement that I previously emailed to a number of you regarding our own personal experience at the hands of the Maine State Police Tactical Team. And with your permission and indulgence, I'll do that now. On March 20th, 2019, I called 911 upon the advice and instruction of my wife, S. Lynn Drew, physician, Dr. Kimberly Decker of St. Mary's Health Center in Lewiston, Maine, to request medical assistance in having my wife transported to the hospital for evaluation and treatment of an ongoing and worsening mental health crisis resulting from her suffering from withdrawal from her antidepressant, anti-anxiety medications, which she'd been without for some time. I called for assistance the previous evening, so it was known and recorded that there had been a prior response to our home by the deputies of the Oxford County Sheriff's Office very recently. Unfortunately, during that first response the previous evening, deputies advised that they could not respond to my request for assistance, as my wife stated to them when they questioned her that she was not a threat to either herself or to me. They advised me to simply leave her alone for the evening, and they left. The following day, the situation with my wife worsened and continued to do so throughout the day, prompting my second call to my wife's physician, and again upon her advice and instruction, her assistance in having her transported to the hospital. This time, however, as a result of my wife's worsening state of mind, it resulted in an 8-hour, what the police called a standoff, with the police surrounding our home almost entirely the time. My wife spent in a deep sleep as a result of having been drinking a lot through the day as a way of trying to cope with the effects of her withdrawal. The incident culminated in the Maine State Tactical Team making an assault on our home by first firing, by their own account, 48 CS 40 millimeter barricade chemical munitions rounds into our home, destroying almost all of our windows, both our doors, as well as causing substantial internal damage. One of these rounds, according to my wife, just narrowly missed striking her in the head, which in all likelihood would have severely injured or even killed her. The officers then violently breached our house, kicked open a door to the bedroom in which my wife was sleeping, apparently with enough force that the door got stuck halfway up one of the officers' legs when it went through. They then attacked my wife, who was lying on the floor where she'd been sleeping, with a canine dog, which severely bit repeatedly while the officers stood and watched, before removing the dog, according to my wife, which was left with now constant severe pain, terrible disfigurement to her leg, and scarring. The officers then proceeded to violently remove my wife from the home without even allowing her to put anything on other than light clothing that she'd been sleeping in. And they literally threw out into the yard a hard, icy, glass-covered ground. Okay, apparently I've run out of time, but I have sent this previously. I just wanted to try and read as much to this into the record as possible.
Thank you very much, Mr. Drew. And we do have a copy of your written testimony. I know you had sent it to me earlier. We appreciate your time and testimony. And your wife, Lynn, had registered to testify as well.
Yes, she's here.
Welcome, Ms. Drew.
Yes.
Begin testifying as soon as you feel comfortable. And I saw you keeping time as well. So you're familiar with the 3-minute clock. We appreciate that. Begin testifying as soon as you're ready.
Okay. My name's Lynn Drew. I'm from Waterford, Maine. And I am, I'm recording this as a victim. And I am not about defunding police. I'm all for them. Anytime I hear anybody get shot, I just pray the cops are all right. What I am about is the abuse of their power, and they severely injured a very innocent person for no reason. All I needed was to have my medication, which I was not refusing to take, but I did not have it. And all I do when I get into my depression is I just want to sleep and just be left alone. It didn't happen. All of a sudden, I'm being attacked by a dog and thrown out through my living room. My feet never hit the floor. My living room is 20 feet long. They threw me out onto the hard, cold, frozen ice, concrete steps, and proceeded to jump on me. I don't know how much they all weigh when they're all geared up, but I'm 5'1" and I weigh 123 pounds. I had a lot of tonnage on me. And when they did the knee strike to the kidney and the neck, there was an officer trying to cuff me, and he couldn't because of my bracelets that I wear 24/7. And he got mad and got up and jumped on me again. That's abusive. There was no reason. I wasn't fighting. I wasn't hollering. I never even spoke a word. They pick me up, then they start telling me, oh, do we have to carry you like a baby? Barefoot, frozen ice, with a severe dog bite with the blood running down my leg and down the road or down my pathway. And they're telling me, but we have to pick you up like a baby, carry you like, well, I wanted to say something, but I didn't. I didn't say anything to anyone to warrant the aggressive, violent reactions of these people that promoted their own actions for the violence. I slept through everything until there was a leg through my door, a dog attacking me. The only words I said was, what the, exactly. I never got anything else out. I had to glare at them because I was laying on the floor, pounding my hands on the floor because this dog is biting at me. And I look over at them like, what do you want me to do? I got no weapons. I mean, and then they just reach in, grab me, throw me, jump on me, can't cuff me, jump on me again, and then taunt me. Thank you. This bill has got to pass, please. This is ridiculous.
Thank you very much, Ms. Drew. We greatly appreciate your testimony and the written testimony that you submitted as well.
Thank you.
At this point, I am going to begin working from the list of opponents. If there are people in favor of the legislation that we're considering right now, rest assured, I will get back to you after we go through the opponents who have not had a chance to speak to this point, and then those neither for nor against, but everybody who wants to be heard on this bill will be heard. So I will now turn to those testifying in opposition to the bill, and I recognize and welcome back to the Judiciary Committee. It's Major Brian Scott. Is that correct, sir?
Good morning, sir. That is correct.
Thank you very much for being here again with the Judiciary Committee, and you can begin your 3-minute testimony whenever you're set to go.
Thank you, Representative Harnett, Senator Carney, members of the Joint Standing Committee on Judiciary. My name is Major Brian Scott, and I'm here today to testify on behalf of the Department of Public Safety, the Maine State Police, in opposition to LD 214. This bill has been one of the most talked about proposed statutes in the law enforcement community that I've been involved with during my entire career. This bill would have a negative impact on the law enforcement profession and result in a more dangerous state to live in or visit. It has already had a chilling effect, leaving a tremendous amount of morale issues for honest, hardworking police officers who put their lives on the line every day for complete strangers without hesitation. I have seen more officers resign or retire in the last year as a result of this pending legislation, coupled with the national defund the police movement, which has villainized all cops, not just the bad ones. Some proponents seem to think that the term qualified immunity means absolute immunity, but that could not be farther from the truth. Rogue officers who aim to cause harm and commit atrocious acts are not protected by qualified immunity. No one, and I mean no one, dislikes a bad cop more than a good one. They have no business in our profession. They should be fired, decertified, successfully sued, and when an officer has acted maliciously, all of those things happen now with our current statutes, with our current court cases. Qualified immunity does not protect bad actors. However, qualified immunity offers some level of protection for good police officers who act with the absolute best of intentions in accordance with their training, education, and experience while trying their hardest to do the right thing, but make a decision under the most stressful of conditions that is later determined to not have been the best way to have acted in a particular situation. Decisions that are made in fractions of a second, sometimes while facing life or death, knowing that any inaction can result in a third person being killed or injured themselves, decisions that are later evaluated by others in the comfort and security of their surroundings without any fear or danger, without any limitations on time, decisions that are deliberated by attorneys, judges for weeks and months, and sometimes they can't agree. A police officer can be doing the right thing at the right time for the right reason, and bad things can happen. If and when that day comes, they should be afforded some reasonable level of protection. Qualified immunity basically means that if, as a police officer, you do your job to the best of your ability and you make an honest mistake in the official performance of your duties, that you may not be successfully personally sued and lose everything that you have worked for. However, this LD appears to change those protections so that an officer places everything they own on the line every single time they are thrust into action and compelled to make a decision in circumstances that are tense, rapidly evolving, and uncertain. This law change would in effect require that a police officer, a human being, be absolutely perfect in the performance of their duties because an honest mistake could cost you everything that you have. This result, I will speed it up. I see the clock there. Thank you. This would result in many officers leaving the profession and those that remain on the job paralyzed for fear to do their job. I've submitted written testimony that has more information. I'd appreciate if you'd read that. But for the reasons that I've stated, I urge you to vote ought not to pass on LD 214. Thank you for your time. Happy to try and answer any questions.
Thank you, Major Scott, and it's nice to see you again. And we do have your written testimony and the committee will review it. Are there questions from committee members for Major Scott? Seeing none, thank you again very much for your time, the testimony you delivered today and the written testimony that you submitted.
Thank you all.
We'll now turn to, and welcome back to the committee. We saw you recently, Chief Deputy Rand Maker. Welcome back and begin your 3-minute testimony as soon as you're ready.
Thank you. Senator Carney, Representative Harnett, and all honorable members of the Joint Standing Committee on Judiciary. My name is Rand Maker, and I serve as the Chief Deputy of the Lincoln County Sheriff's Office. I'm appearing before you today on behalf of the Lincoln County Sheriff's Office to record our opposition to LD 2114, 214, an act to eliminate qualified immunity for police officers. We are concerned about the reasoning for targeting our profession and the impact of LD 214 will have on hiring and retentions, as well as financial impact to both the employee and the employer. We are concerned that LD 214 will not allow a reasonable law enforcement officer in the state of Maine to make a mistake. I wonder if anyone listening to me today can say they have never made a mistake. LD 214 will prohibit this even if a law enforcement officer is acting reasonably and within agency policy. What I really want you to hear today is how, if enacted, LD 214 will likely cost some lives. A recent example of this impact occurred less than a week ago in the town of Wiscasset. Lincoln County deputies were dispatched to a local hotel after receiving a complaint that a female in a hotel room may need assistance. When deputies arrived, they could hear a woman crying and were uncertain if they saw another male standing near a door. Deputies attempted to make contact with those inside the room for over 30 minutes before they could hear nothing inside. No crime was clearly being committed or even reported. They were left with a decision: make entry or just simply walk away. I'm happy to report the deputies on the scene made the life-saving decision to forcibly enter this room. Upon entry, they found 2 people in immediate need of medical care due to an apparent opiate overdose. These heroes were able to immediately administer Narcan before medical professionals were staged nearby could enter the room. The medical professionals later transported both these occupants to a hospital room for definitive care. Eliminating qualified immunity would not allow these reasonable law enforcement officers to make a mistake without subjecting our agency or each individual to potential civil liability. I am deeply concerned that LD 214, if enacted, would create a similar situation that we would likely cause some deaths. I can state with certainty that the 2 individuals found within this room would have died without the decision we made last week. Law enforcement by nature must make difficult decisions each day, often in a split second. If LD 214 is enacted, it will undoubtedly create more tough choices with life and death situations. Thanks for your generosity of your time, and I would be pleased to answer any questions you might have. Right on, Senator Carney.
Well done, Chief Deputy Maker. We love people who hit the target right on the nose. And thank you for your testimony, and thank you for the written testimony that you submitted as well. Are there questions from committee members for Chief Deputy Maker? Seeing none, again, thank you very much for your testimony today and the written testimony.
Thank you.
Appreciate it. Before moving on, I just want to remind all those in attendance that the chat function is for technical assistance. It is not part of the record, so comments in the chat will not be considered by the committee. Thank you. I will now turn to Chief Jared Mills for the Maine Chiefs of Police Association. Welcome, Chief, to the Judiciary Committee. It's nice to see you again, and please feel free to begin your 3-minute testimony when you're ready.
Thank you, Representative Harnett. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Jared Mills, and I'm providing testimony opposed to LD 214 on behalf of the Maine Chiefs of Police Association. A series of events over the past couple of years have led to a reckoning for Americans, including Mainers, over a collective response to injustices both real and perceived against racial and ethnic minorities and marginalized groups of citizens. Not the least of these events were the murder of George Floyd at the hands of a police officer and the insurrection of the U.S. Capitol, led in large part by a white supremacist group. It is not surprising, therefore, that these events have led to proposed legislation, some of which is designed to increase the accountability of law enforcement officers. The Maine Chiefs of Police has, in fact, already supported measures to increase police accountability, and we believe that an examination of what is known as qualified immunity is appropriate. But the question of what to do about it is much more complex and nuanced than simply deciding whether to keep it or do away with it. Therefore, we strongly oppose abandoning it, especially without a thorough examination of what it is, how it works, and how it might be changed. We note that Senator Carney is sponsoring another bill on this topic, LD 416, which recognizes that simply abandoning qualified immunity is not appropriate. Qualified immunity is called that because it is not absolute immunity, it's limited. Maine law provides immunity to hosts of occupations and entities depending on their role. This includes persons responding to natural disasters, Good Samaritans, and officers of charitable organizations who donate their time and skills are just some examples. In many cases, these immunities are qualified. That is, they are limited by the circumstance involved. Law enforcement officers play a unique role in our society. They are charged with enforcing the laws that are designed to maintain a civilized society. Law enforcement officers are asked to immediately rush to see the scenes of some of the most dangerous situations we can imagine, whether it is an active shooter in a building, the scene of a domestic violence disturbance, or an armed robbery. Many of our departments are struggling to find enough qualified applicants to fill vacant positions. We fully expect that if this bill passes, it will become even more difficult to fill these police jobs. How many people are going to choose a career in law enforcement if one of the first things they learn at the police academy is that any action that they take could result in a lawsuit against them personally with potentials for monetary damages? Doing away with qualified immunity will open the floodgates for much litigation against police officers in the state's courts, whether truly warranted or not. Most civil actions against law enforcement officers for violations of citizens' civil constitutional rights are brought in federal court pursuant to 42 United States 1983. But in the same decision cited above, the court also made it more difficult for plaintiffs to persuade a judge to waive qualified immunity. Some would say too difficult. The state of Maine has no ability to change that standard by the federal judge to make this determination. It can only change what happens in state courts. But there is a lot of daylight between the status quo and total abandonment of qualified immunity. We think it would be irresponsible to abandon this principle for those we send into danger with no examination of other alternatives. The Maine Chiefs of Police is prepared to participate in discussions about additional measures that increase accountability, whether they involve how law enforcement officers are hired and trained, the policies that guide the work of law enforcement officers, and how those engaged in misconduct are dealt with. In the meantime, we urge you to give LD 214 an ought not to pass.
Thank you, Chief Mills, for your testimony today and for the written testimony that you submitted as well. Committee appreciates your input. Are there questions from committee members for Chief Mills? Seeing none, thank you very much, sir. And I will now turn to Christopher Hansen. Welcome, Mr. Hansen, and please begin your 3-minute testimony as soon as you're comfortable.
Good morning. Thank you. Yes, my name is Christopher Hansen, and I live in Rockport, Maine. It has been said several times that getting rid of qualified immunity will not affect good police officers. And I really couldn't disagree more. However, the most affected group would be the citizens that our police serve every day. And for the record, I am a police officer currently. You see, the good police officers, they're not using qualified immunity to get out of a jam when they've done something wrong. QI doesn't protect an officer who's used excessive force or violated someone's civil rights. Police officers involved in shootings, they don't get qualified immunity. There's always a full investigation. QI is not the blanket get out of jail free card that people make it out to be. Obviously, some other folks have spoken much more eloquently about what QI qualified immunity really is, but it's not like diplomatic immunity. You know, a judge actually needs to qualify it, hence in the name qualified immunity. Qualified immunity, it simply protects good officers from civil liability when an unforeseen circumstance leads to a less than perfect outcome, even though the officer has used their best judgment, followed all of the federal, state, and local laws and policies, guidelines that they're supposed to be following. Police officers are human. We all are. And as we all know, that no matter how hard we try, sometimes bad things happen to good people. Taking away qualified immunity from these good people because of the handful of bad cops, and there are a handful of bad cops out there, we all know this. But if we take away the qualified immunity from the good guys because of the bad guys who have benefited from it, it just isn't right. It would be like us taking away all of your car insurance, all the representatives that are here today, because one of you had an OUI crash. That wouldn't be fair to you, would it? So anyway, there'll be a lot of really good police officers who leave the profession. They're calling, really. If you take away qualified immunity, they will no longer be there for the public to call on in their times of need. They cannot afford the risk their families are going to endure because of these, and someone had said it before, frivolous lawsuits. 12 seconds. Please don't put the public at greater risk by telling the good police officers you don't appreciate the sacrifices they make every day and putting them at even greater risk by taking away qualified immunity. I really appreciate all of your time today, and please vote against this. It's terrifying.
Thank you very much, Officer Hanson. And I don't know your titles. I apologize if I'm
a detective. That's okay.
Thank you. Thank you for your time and your testimony. And I believe you submitted written testimony as well. I turn it to questions for committee members. Representative Libby.
Thank you, Mr. Chair. My question was actually in regards to written testimony because I'm in the committee materials and I don't see it, but I and others do always appreciate being able to go back and reread testimony. So if you haven't submitted testimony, Detective Hanson, if you are able to, it would be much appreciated.
I will do that. Thank you.
Thank you.
Thank you. Thank you, Representative Libby. I misspoke. I just checked the list again and I do not see written testimony. Thank you for pointing that out. And again, thank you for being here today, sir. Seeing no other questions, I will move on to our next presenter and welcome Damon Lefferts to the Judiciary Committee. And please begin your testimony as soon as you're comfortable by unmuting your microphone and activating your video. There we go. Nice.
Good morning. Thank you very much. My name is Damon Lefferts. I'm a detective from Waterville Police. I've been in law enforcement for 15 years. I got in this profession to help people in need and hold others accountable for the things that they have done, not to take away anyone's civil or constitutional rights. I took an oath when I became a law enforcement officer that I will never betray my badge or the public's trust. A police officer that purposely breaches the public's trust, that violates their rights, crosses a line into becoming a criminal themselves, and should not be practicing law enforcement. Like every profession, some people lack commitment, true integrity, and work ethic, but that speaks for a person's individual basis, not the profession as a whole. For an example, according to a 2018 article from CNBC, the third leading cause of death in the United States is medical errors made by doctors, pharmacists, and surgeons. Only heart disease and cancer cause more deaths than medical errors. A study conducted by Johns Hopkins University states that more than 250,000 people die in the US each year from medical errors. Doctors and surgeons, just like the police, need to make split-second decisions, and human error may play a role in those decisions. but I certainly do not pin that profession as a negativity due to some inadequate doctors, surgeons, or pharmacists that made human errors that cost a person's life. Law enforcement professionals will make human errors as well. Violent and or life-saving events will happen and possibly turn on you in no time. One evening, I was at a rare dinner at a local restaurant. I was not on duty and was in dress clothes. The staff knew that I was a police officer and asked me to assist them with an intoxicated woman who has locked herself in the bathroom and was breaking glass inside of the packed restaurant. In my mind, I knew I had to act now for the responsibility to protect the woman breaking glass. Was she hurting herself? Was she making a weapon to hurt the staff or the 40 patrons in the restaurant? I also knew I had to protect the property of the restaurant, and I had to be careful about my own safety as well. I knocked on the door of the bathroom and told her I was a police officer and the staff wants you to leave. The female refused. While I can hear banging in the bathroom, I opened the door and the female punched me in the face. The staff saw it, the patrons saw it, and sadly my wife did, all on date night. I pushed the female back and she landed on the floor, and I told her to stay down with her hands on her back to keep her from assaulting me any further. At this point, the restaurant was empty, and sitting there was my wife, crying, obviously traumatized from witnessing the 3-minute event which took place, where she saw me get assaulted along with the mere chaos the female was creating. That night, I did not have my weapons or handcuffs in my person after my regular working hours. However, I am always working. I'm always a police officer no matter what. And I'm okay with that. I'm glad I was there to help the staff so they did not get assaulted along with any patrons. Qualified immunity afforded me to act that night, direct protection of others and property, which I promised to uphold my oath to my profession. If qualified immunity were taken away, that would enter my mind if I was ambushed in that situation again. My situation is an example of what qualified immunity does for the officers and the public. You hear about defunding the police, but what you really need to hear is that taking away qualified immunity will depopulate the police, who will want to do this job, knowing that every human error may potentially result in a lawsuit. If someone is in trouble and needs an officer is the only person that is coming, not the National Guard, not the Army, a police officer. If the police officer is not coming, no one else is. The police need qualified immunity to carry out their daily functions, not to defy one's rights. If an officer does that, they will be held accountable by their administration and the Criminal Justice Academy. Qualified immunity is not a free pass to betray your badge or the public's trust. Qualified immunity needs to remain for everyone's well-being.
Detective Lefferts, I apologize for interrupting, but I let you go quite a bit over the 3-minute time.
Okay.
I want to be respectful to all those waiting to testify.
I appreciate that.
If you could wrap up.
That's it.
Okay. Thank you very much, Detective. Are there questions from committee members for Detective Lefferts? Seeing none, again, thank you for your service, and the committee appreciates your testimony today.
Thank you for having me. Thank you, guys.
Next, I will call upon Danielle Lefferts. And Ms. Lefferts, you may begin testifying as soon as you are comfortable. I see that your mic is unmuted and your camera's activated, but I'm not seeing you, but we hopefully will see you when you begin to speak.
Am I good?
You are good. I'm not seeing you, but that's fine. You may begin testifying.
Thank you. Good morning. I am Danielle Lefferts from China, Maine. I speak to all of you today in support of my husband and law enforcement in opposition of LD 214. More importantly, I speak to you on behalf of our 3 children, ages 6, 9, and 11. Please think about what this looks like, not just for officers and our families, but for the safety of your families and communities. Officers put you and other families' needs before their own. My husband knew this was part of the career when he chose his profession, and I knew this is what I signed up for when I chose to marry him. We also had reassurance and qualified immunity and other protections for our family while he was making split-second decisions to protect yours. There are 2 key words we need to keep in the forefront today: qualified and frivolous. Qualified immunity protects my family from frivolous lawsuits that can easily arise while my husband is trying to protect and serve people in your communities. QI does not make him bulletproof, and it does not let him be treated above the law. Taking it away does not improve policing practices. It does not implement training for mental health crisis. It does not stop systematic racism. Again, it protects my family from frivolous lawsuits. His actions have to be 100% justified according to the Constitution, departmental policies, academy training, and state law. The removal of QI at the local levels is not the action or reaction to take against deeper systematic areas in law enforcement that our country struggles with. The general public impression is that police and their families get away with things and need to be treated equal to civilians. We are actually held to the highest of standards beyond civilians. I have been pulled over for speeding and issued a ticket as the officer and I laughed about what my husband was going to say. I was not treated above the law. My husband and I live under a microscope. We choose carefully who we allow in our inner circle, and we don't use our real name on sporting uniforms. We are constantly shielding our children and having hard conversations with them, like not to wear their thin blue line bracelet in a restaurant for fear of our order being tampered with. Can you imagine being woken up in the middle of the night with a phone call from work stating that someone who was just released made a serious threat to kill you and your family? Also letting you know the location of said person was unknown and the last cell phone ping was within miles from your home where your children were sleeping. The threats on officers' lives along with their families happen so frequently that officers become numb. Trust me, we want to be treated like civilians, but we are different. Our guards are always up and we are always censoring what we say, do, and where we go. My children should not fear sharing that their daddy is a detective who helps people. This bill is only singling out law enforcement and not addressing all of the public employees that it covers, such as you and even myself as a teacher. Keeping QI for officers does not mean supporting racism or allowing bad policing to continue. It allows them to protect you without hesitation. By removing qualified immunity, you are putting the public in danger. With recruitment rates already at an alarming low, attracting qualified new officers is going to be even more difficult with this protection gone, along with losing the qualified veteran officers. This discussion should be about providing appropriate resources, training, education, and support. Qualified immunity is only a qualified action, not a free pass. A protection.
Ms. Lefferts, I apologize for interrupting, but I did let you go over the 3 minutes.
Sorry.
And I need you to wrap up.
Thank you. Please vote ought not to pass.
Thank you very much for your time and testimony today. The committee appreciates it. Questions from committee members? Representative Thorne.
Thank you, Mr. Chair. Not so much as a question. I just wanted to thank Ms. Lefferts for showing up today and providing testimony. And it's not my desire to thank every applicant that provides testimony today, but having my daughter married to a sheriff's deputy who is a detective, and she is also in education, I can certainly appreciate your position and the courage that it took for you to come and provide testimony today. Thank you.
Thank you.
Thank you, Representative Thorne, and thank you again, Ms. Lefferts. Seeing no other questions from committee members, I will turn to our next person registered to testify, Daniel Turtelot. Please begin your 3-minute testimony when you feel comfortable, sir.
Thank you very much. Senator Carney, Representative Harnett, and members of the Judiciary Committee. I am Daniel Turtelot speaking today on behalf of the Maine Law Enforcement Coalition, which proudly represents approximately 3,000 Maine state, municipal, and county law enforcement officers to testify in opposition to LD 214. After months of negative media coverage, both at the national and state level, the Maine Law Enforcement Coalition made a decision to have critical insights, conduct a poll to determine how Maine citizens viewed law enforcement. The coalition was confident that the majority of Maine citizens were supportive, but were not completely sure where the number would be given the barrage of negative media. Here are the results of the poll. First question, how much of an impact do you think law enforcement in Maine has on the state's ability to remain one of the safest states in the country? The results, 8 out of 10, 81% of surveyed voters believe law enforcement contributes to the high level of safety in Maine, with many voters believing law enforcement has a major impact on safety in the state. Question 2, in general, how would you describe your view of Maine law enforcement? Results, 8 out of 10, 81% of Mainers have a positive view of law enforcement in Maine, including 4 out of 10 who hold strongly positive view of law enforcement in the state. Question 3, recently Maine law enforcement has been experiencing a shortage of new candidates and a difficulty retaining existing officers. How much of a priority do you think this shortage of law enforcement officers should be for lawmakers in Maine? Results, 9 out of 10, 88% voters of the voters in Maine believe state shortage of law enforcement officers should be a priority for lawmakers. Well over half, in fact, believe this shortage should be a major priority. So if there was a gold standard for measuring the performance of law enforcement officers in Maine, then it has to be the opinion of people of the state of Maine. In this poll, it is obvious that Maine people are demanding that lawmakers maintain and do what they can to keep the level of protection that keeps Maine, the state of Maine, #1 in the safest state in the country. That being the case, then it seems that LD 214 would certainly go against the will of the people of our great state because of the impact it's going to have on retention and recruitment of current and future officers. I do have one other number on the heels of National Law Enforcement Appreciation Week. There's another number I want you to consider, 87. This number represents the number of law enforcement officers on the Maine Law Enforcement Officers Memorial that have given their lives while protecting our state. And I thank you very much for the time that you've given me today, and I'll answer any questions.
Thank you very much, Mr. Turtelot, for being before the committee today and for submitting your written testimony as well, which will be reviewed. We appreciate both types of input. Are there questions from committee members for Mr. Turtelot? Seeing none, thank you very much for your time and your testimony today. I will now turn to Edward Tharp. Mr. Tharp, when you are ready, unmute your microphone. I'm sorry, did Representative Poirier have a question? So your hand.
I just wanted to ask real quickly if the previous testimony, if he could send us that polling data. I do not see that in his written testimony.
Did you hear the request?
I did, Representative Harnett, and yes, yes, I can. I'll submit that as soon as I get off here.
I appreciate that. Thank you.
Okay, thank you.
Thank you, Representative, and I apologize for missing your hand. There's a lot of boxes up here. Mr. Tharp, just begin your 3-minute testimony when you feel comfortable, and welcome to the Judiciary Committee.
Yes, sir. Can everybody hear me?
Yes.
Okay. Well. I got a picture now. That's good. First of all, I want to say that I'm just amazed at the testimony of our law enforcement community, in particular, I apologize, Peggy, or Danielle rather. Her profession as a teacher is a calling, as so is her husband's. I'm a and they do these things because they're called to. It's not just because they do them as a job. That's what a police officer does. That's what a teacher does. I would like to say that I am a former firefighter. I have worked with police officers, not just alongside them, but with them. In one case, one family of a police officer in a mental health crisis that they were dealing with. And I know them intimately and well over 30 years. And I can tell you that they have lost something that they used to have when I was a kid, which was that they were highly respected as a teacher is in the community, with all of this disting of so much, that I hear so much, even from the people that are opposed, these emotional stories, and they're very emotional. And, the most honest part of what you're hearing from the law enforcement side is, yes, there are some bad apples, okay? There always have been, and I've actually known a few myself. But I just want to read a statement very quickly, and I'll leave it at that. I have friends in law enforcement right now locally and down in the Portland area. I can tell you that these people do their jobs. They go into the job wanting to do the right thing, and they need all the support we can give them. So our law enforcement leadership from the local and state levels have done very well in speaking against proposed bill to end qualified immunity for police officers. All of them have presented ironclad points and truthful examples as to why LD 214 is a disaster for the state of Maine. They have spoken to you with the utmost professionalism, politeness, as they should in their possessions, and I will add honesty. You've heard it today. As a citizen and not a member of the law enforcement community, I intend to speak to this issue a bit more forwardly and harshly, so here I go. Maine's finest need to know, when risking their lives every day for you and me, just as a combat soldier, that we, the public, have their backs. Now, and a lot of times, a law enforcement officer, doesn't have, he can leave his profession, or she can leave her profession. A combat soldier can't. I've been there, okay? I have not been in combat, but I've been a soldier. This current social trend to be down on cops is disgusting and dangerous, as is LD 214. It is a hard fact that young people are not signing up to be law enforcement officers as they have in the past, and there's currently a severe shortage of officers statewide. This is a huge problem, but not the biggest by far. They are quitting in other states, in some cases by the hundreds.
Mr. Tharp, Mr. Tharp, I apologize for interrupting, but I need to do it to be fair to all you. 3 minutes is up. If you could wrap up your testimony.
Okay, very quickly. I just want to speak out for our law enforcement. They need us. When you're in trouble, they are the first on the scene. They're there to help you. Please vote against this dangerous bill, because crime will rise, as it has in New York and other cities, and we're going to see it here. We need our police. They need our support. Thank you very much.
Thank you, sir. And I failed to hear, I know you registered as a resident of Woolwich. Is that correct?
I apologize. Yes, I am a resident of Woolwich. Yes.
Thank you. And I see questions from committee members, and I'll do my best to call on you in the order that I saw your hands. Representative Sheehan.
Actually, Mr. Chair, Senator Carney has asked me to be in charge of the timer. So
Okay.
I'm just putting my hand up so that I'll be visible.
Thank you. And I should point out that I was not ignoring Senator Carney. We leave the hand up of the timer so that that box can be seen in our Hollywood Squares Zoom meeting. Representative Libby.
Thank you, Mr. Chair, and thank you for being here, Mr. Tharp. I just wanted to ask Mr. Tharp if you were able to submit written testimony as well. I know you hadn't quite finished what you had hoped to say, and I would love to read the rest of what you had to say in a written testimony.
Absolutely. I'd be glad to do that. If you could somehow let me know where to send it, I'll send it.
When you signed up to do spoken testimony, there was a box where you could either write your testimony in there, or you could attach it as a linked document. So if you go back to where you signed up to testify, that's right where you can submit written testimony as well.
Thank you for the advice. I'm a technological moron, so I appreciate your guidance. I will do that. Thank you.
Thank you so much.
Thank you. Seeing no additional questions, thank you very much, Mr. Tharp, for your testimony today. I'll now turn to the next person registered to testify, and I hope I get the last name right, Elgin Physic.
You did get it correct.
Welcome to the Judiciary Committee, sir. Please begin your 3-minute testimony when you're ready.
Thank you. Good morning, committee. I'm speaking out against LD 214. My name is Elgin Physic with the Maine State Police. I have been employed by the agency for 13 years, and I am the first Black state trooper in the history of the department. Like many of you, we have all witnessed recent police incidents and encounters with Black men and women on the national stage, and watched as the evidence of police use of force has been on full display, excuse me, through videos within social media and a plethora of news channels. When I have watched these time and time again, my core aches as a Black man, my core aches as a father of Black children, my core aches as a police officer. Through our history, I'm fully aware of the mistreatment of Black and brown communities, beginning with those first ships that traveled to this country in 1619, to the lead up and aftermath of Civil War, to even the ultimate Supreme Court decision of Plessy versus Ferguson. Black and brown people in this nation have been severely harmed, hated, and uncared for through laws, violence, and culture of embedded racism. Not to include the era of the Jim Crow, the law and order era of the 1970s, the war on drugs in the 80s, and the most recent tragedies of Rodney King in 1992, the crime bill in 1996, and the killing of Trayvon Martin, which started the Black Lives Matter movement. I reflect and recognize my own personal history is affected by each of these things. Yet I stand here knowing that lawmakers are trying to make a good faith step in preventing any further hatred, violence, or misdeeds coming to Maine and its own police force. There is no denying the level of racism that is in Maine, just as it's in other parts of the nation. I too have experienced that in and out of uniform, and there are still pockets today where the lack of knowledge of Black and brown culture lacks. There is fatigue growing with the Black community due to perceived and felt racism. But as you consider the aspect of qualified immunity, changing this or getting rid of it won't fix the problems of racism that manifest themselves here and abroad. It may seem like this is a great step, but it really starts with a mindset of collaboration, of not making the situation about us versus them, but a collaborative effort with lawmakers and departments to burrow down to the nature of day-to-day policing and tightening misunderstandings and seeing where the gaps are located. This would certainly come about if lawmakers were able to ride with law enforcement and see firsthand what those around the state are dealing with in their communities every day. And this doesn't mean I am offering an open invitation to have a ride along with me. My hope is that a more collaborative effort will be an option before we start stripping down aspects that have offered reprieve for officers to engage in their difficult job. We as officers agree there needs to be reform both within and outside of departments. This should be something police and lawmakers work out together before recondition policing for the future. Thank you for your time, consideration, and may we set an example for how we can eradicate racism in Maine.
Thank you very much, Trooper Physic. I hope I have your title correct. If I don't, I apologize. The committee appreciates your taking the time and your testimony today. Are there questions from committee members for Trooper Physic? Seeing none, again, thank you very much, sir. We appreciate you being here today.
Thank you. Have a great day, committee.
I will now turn to the next person on my list. Before doing that, I'd like to recognize that we've been joined by Representative Newell. If you would like to introduce yourself to those in attendance, Representative.
Thank you, Mr. Chair. Good morning, everyone. I am Rena Newell. I serve as the tribal representative for the Passamaquoddy tribe. Please excuse my delay in joining you this morning. I was providing testimony to another committee. Thank you.
Thank you, Representative Newell, and welcome. I will now turn to Jason Levitt. Welcome to the Judiciary Committee, sir, and please begin your 3-minute testimony when you're ready.
I want to thank the members of the committee for the chance to speak today. My name is Jason Levitt, and I'm the Vice President of the Maine State Law Enforcement Association. In my 14 years as a law enforcement officer here in Maine, I have served as a field training officer, a Maine Criminal Justice Academy certified instructor in firearms and interactive use of force. I have worked with local colleges and the university on programs to help students interested in careers in conservation law enforcement. I can attest firsthand that the training provided to all law enforcement officers in Maine is second to none, and I am proud to have a small role in it. Law enforcement is a life of service to your fellow citizens and service to the greater good. Every law enforcement officer who puts on a vest and a gun belt and goes to work understands the risk of the next call. Families of these officers, troopers, and wardens know the risks, not some abstract, faraway idea, but a real and horrible possibility experienced by families all over the country every year. A loss of qualified immunity will add a huge financial peril to these already burdened families. The results of this increased burden will be catastrophic to the profession of law enforcement. You can't make $50,000 a year and pay $40,000 a year in legal fees to defend yourself against lawsuits. This will be the reality if we lose immunity. There's been a nationwide narrative at work in our country that all police officers are evil, racist men. As hard as our media is trying, this is not a narrative that works here in Maine because it is simply not true. Real hardworking Maine residents support law enforcement. These are people who will suffer the most without law enforcement. These are the tradesmen who have to replace thousands of dollars of tools every year because they are stolen and sold to pay for drugs. They are the mill workers who work their whole lives to afford a camp on a Northwoods pond, only to have it broken into every year. They are the commercial fishermen who cannot find crew for their boats because drugs have taken such a hold in these towns. They are the families of over 500 people who had a loved one die of a drug overdose last year. I urge you not to let a small group of loud voices steer our state down a path that cannot recover from. There is no path to a better police force that begins with a loss of qualified immunity. There is only a path to no police. The fact that law enforcement officers will have to choose between the career that they love and the long-term financial security of their family. It will be a brutal choice to make, but I am afraid there is only one option. Some officers close to retirement may roll the dice and try and keep their heads down until they can go. My fear is that the good young officers we have fought so hard to recruit and retain will make the only reasonable choice and leave. These officers deserve better. They deserve the best from the communities they serve. When they are gone, what options will we have? Who will answer the call? Who will find the missing child? Who will respond to a desperate call for help? Who will protect the $500 million in natural resources? Who will be the calm voice in the chaos? And who will fight the monsters? I assure you the national media has no answer to these questions. They will need to be answered here and now.
Sir,
vote against.
Excuse me, sir, I'm sorry, you've gone over the 3 minutes. So I just
LD
need
214.
Thank you very much for your testimony, sir.
Happy to answer any questions.
Thank you. Are there, and thank you for your written testimony as well that I see that you submitted. Are there questions from committee members? Seeing none, thank you very much for your time, the testimony you provided and the testimony that you submitted. Greatly appreciated. I will now turn to Jeff McCabe. Mr. McCabe, welcome to the Judiciary Committee. Please unmute your mic and activate your video and begin when you're ready to deliver your 3-minute testimony.
Great, thank you. Good morning. It's been a powerful morning already. I really appreciate an opportunity to listen to all sides of this issue this morning. Also to recognize the moment that we're in the state and also in the country. So Senator Carney, Representative Harnett, and members of the Committee on Judiciary, my name is Jeff McCabe and I serve as the Director of Legislation and Politics for the Main Service Employees. And I'm here in opposition of LD 214. MSCA represents law enforcement supervisors within the executive branch. And I've had the opportunity to speak with some members this week who reached out to ask for help. This bill, as proposed, would only affect law enforcement officers. No other public sector workers, public officials, elected or appointed, are included in this bill. Personally and professionally, I've interacted with folks carrying out law enforcement duties associated with our state's natural resource agencies. These folks protect people, the natural resources, and those interactions may be due to my hobbies, my educational background, or my work over the last 20 years, including as a Maine guide. So today I find myself looking through that lens and thinking about this bill and how it may affect those folks. It is important in the discussions around this bill, you consider things associated with the roles law enforcement officers play in protecting life, natural resources, and property around the state. For the folks we represent, many of them are involved in using equipment like aircraft, ATVs, snowmobiles, and other items while carrying out their duties. Much of this work is done while traveling on unpaved road, trails, and varying types of water, including the ocean, rivers, ponds, and lakes. They plan and carry out search and rescue on land, water, and air. They work in remote areas, often alone. In doing so, they make split-second decisions, and that is what we require them to do. This bill will be a deterrent to law enforcement to respond and act decisively at a time when they are being asked to do more with less resources. We're concerned this proposed measure would actually create further recruitment and retention issues. Currently, labor as a whole is struggling with conversations around which laws should continue to be enforced, how we enforce those laws, and how folks responding to crisis. Too often, law enforcement officers find themselves left responding to a crisis that could have been prevented by other means. It's clear we need to raise wages and invest in a broader, deeper social safety net to prevent the disparate conditions of poverty. We need to expand our addiction and mental health support and response infrastructure. We need to invest in restorative and rehabilitative practices in our correctional system. We look forward to working with legislators on which we believe there is increasing momentum to address. We believe that things leading up to a critical incident are important, not just the actions of an officer responding in crisis. This bill and many other issues this session are challenging without the face-to-face interaction and deeper dialogue not broadcast via Zoom and YouTube. I look forward to the day that we can return together, and I'm happy to take any questions that you might have for me at this time.
Thank you very much, Mr. McCabe, for your testimony today. And you may have heard committee members love to have written testimony as well. I did not see any written testimony submitted. Is that something you could do after the hearing, if you have not already?
Absolutely, Representative. I plan to upload that shortly. I sort of took some notes, and I sort of struggle with, being part of a hearing as a former legislator, sitting and taking notes and seeing if there's additional things that I may want to add. So I'm working on my final edit, and I will get that to you folks momentarily.
Thank you, and totally understood, and welcome back to the body in which you used to serve.
Thank you. I appreciate all your time.
Are there questions from committee members for Mr. McCabe? Seeing none, again, thank you for your time today and for presenting your testimony. I will now turn to Jessica Ramsey. When you unmute your microphone and activate your video, feel free to begin your 3-minute testimony.
Good afternoon, Senator Carney, Representative Hartnett, ladies and gentlemen of the Judiciary Committee. I'm here to speak in opposition of LD 214, an act to end qualified immunity for law enforcement officers. My name is Jessica Ramsey, and I'm a lifelong resident of Southern Maine. I am currently a police officer for the city of South Portland and have been in public safety for almost 20 years. I have also served as an advanced emergency medical technician and a 911 dispatcher. As I hope you have been able to tell, I'm prideful of my profession and the men and women I have worked with in my career. Though I'm here in front of you today for a reason that is not only vital to Maine law enforcement, it is critical in sustaining the quality of individuals we maintain in our ranks. Imposing legislation to eliminate qualified immunity based on a national agenda that is without merit and is harmful to maintaining the safety and security of Maine citizens and the communities we work in would be a great disservice to the citizens of Maine and detrimental to Maine law enforcement as a whole. The purpose of qualified immunity, as you know, is to protect government employees from frivolous litigation. Qualified immunity protects a broad range of government officials, and yet Maine law enforcement officers are the sole target of LD 214. We take an oath of honor and become law enforcement officers because we believe we have a job to do within our communities. For some of us, that's enforcing traffic laws to prevent fatal accidents and impaired driving. For others, it is maintaining a sex offender registry and trying to ensure there are no other victims. Sometimes our passions lie in community policing and providing services to the citizens. For most of us, no matter what our specialty, we are constantly striving to build positive relationships throughout our communities. Qualified immunity is not an automatic privilege. It does not protect me as a law enforcement officer from criminal charges or internal investigations and discipline. If I break the law or act outside of city or departmental policies, it simply protects me from civil litigation and unwarranted lawsuits for doing my job and upholding the law. As you all know, we leave our families at all hours of the days and nights. We miss vacations and holidays. Our suicide and divorce rate is substantially higher than most other professions. We see things no one should have to see or hear. And lately, we've been subjected to a generalized view of our profession that is radically unwarranted and frankly disheartening. I love my job. I love the people I help. And sometimes, yes, I hate the things I have to do as part of my profession. But don't we all have something we don't like about our jobs? Should I be worried that the parent of a child I take away from them due to an alleged allegation of abuse can later come back and sue me personally if it was deemed that abuse never occurred? Law enforcement officers are already under a microscope. Our heads are constantly on a swivel. Should I be fearful every day when I go to work that I'm going to be sued for doing my job when I'm acting within the law and our departmental and city policies? I'm confident when I say that if LD 214 passes, you will see a mass exodus of amazing, compassionate, trustworthy human beings who just happen to put on a law enforcement officer's uniform every day in our communities to keep them safe. Though we love our jobs, our families come first. My 9-year-old son and my 10-year-old daughter should never have to worry that mommy isn't going to come home, and yet they do. It's the nature of the job. Not only do they have to worry about me making it home, they have to worry about their father making it home as well. Please don't make our jobs harder as parents and force us to leave a job we love or risk losing our houses, my kids' education investments, or worse. Please look at LD.
Officer Ramsey, I need you to wrap up. I've let you go over a bit. Thank you.
Okay. Please look at LD 214 from a point of view of a Maine lawmaker, not based on a national political agenda. Maine law enforcement officers are remarkable individuals and should be treated that way. We continue to support you every day by going out and doing our jobs to the best of our ability, and we don't want to have to make decision to leave law enforcement in fear that we will be subjected to unwarranted, costly civil litigation. Please support us.
Thank you. I'm sorry, but I've let you go over quite a bit, and we do have a lot of people still to testify. We greatly appreciate your time and testimony, and thank you for your decades of public service as well.
Thank
Are
you.
there questions from committee members for Officer Ramsey? Seeing none, thank you for your oral testimony today, and I know you submitted written testimony as well. We will review that. Thank you for.
Mr. Chair, I have my hand up.
Oh, I am sorry. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today. Detective Ramsey, Officer Ramsey?
Just
Sorry.
officer.
Officer Ramsey. Thank you for being
Thanks
here.
for the promotion.
I know, it happens here sometimes on our committee. I wonder if you could just finish your testimony, please, is my question.
Yeah, sure. I just closed it. Hold on one second. It was just very brief and short. I essentially, the only part that I didn't finish was that as law enforcement officers in the state of Maine, we're scrutinized, and that the Maine Criminal Justice Academy has set into place requirements that most other states do not have. MCJA requires hiring individuals to a place through rigorous hiring process, which includes polygraph examinations, extensive background checks, psychological exams, and prior to being allowed into the basic law enforcement training, we all have to go through that. We're required to go through hundreds of hours of basic training and privileged to have the opportunity to attend multitude of advanced trainings throughout our careers. All of these things are done to ensure that officer that graduates the Maine Criminal Justice Academy is a well-rounded law enforcement officer, an individual with the utmost professionalism and integrity who serves their community with honor and compassion to weed out those that cannot uphold that standard. We taken, the only other thing that I had to say was that I hope that you support us by not implementing LD 214 to end qualified immunity for law enforcement officers. And I'm happy to try to answer any questions the committee may have. Thank you for your time.
Thank you for your time, your commitment to our communities, and your testimony.
Thank you.
Thank you very much, Officer Ramsey. Appreciate your time. I will now turn to Joanne Mason and then Justin Huntley. Ms. Mason, nice to see you again. Welcome to the Judiciary Committee. And
Thank
please
you.
begin your 3-minute testimony when you're ready.
Do my best. Senator Carney and Representative Arnett and the esteemed members of the Judiciary Committee, thank you for allowing me to testify today. I am Joanne Mason from Reedfield. I have been married for nearly 38 years to a career law enforcement officer. So I'm speaking today as a wife. Criminal acts done while acting as a law enforcement officer does not qualify anyone for immunity from criminal prosecution or civil action. The axiom that the law enforcement will be more responsible to the public if there is a personal financial risk assumes that the police find their own finances more important than their freedom. I highly doubt that theory. Putting the risk of civil lawsuits directly on an LEO will create a situation where split-second life and death decisions will not be made by muscle memory and training because doubt will creep in, and people will die because of it. Community members and public servants will die because of it. If you are okay with that, then caring for human life only extends to those who are not in charge of protecting the laws that you politicians write. Then be clear to those around you that you do not support law enforcement officers. If any law enforcement officer is trained correctly, vetted correctly, and managed and monitored correctly, they are unlikely to make serious mistakes and intentional acts against people's rights. We need a dramatic change in the system of vetting and certification management. Society needs a centralized clearinghouse of improper or non-sanctioned behavior. This will ensure that cops who are below standard in any department will not be able to go to another department without fear of full history following them every time. Keeping in mind that the law enforcement in Maine is not a career that anyone believes they'll become wealthy. Low starting pay for certified officers is common, especially in the rural parts of Maine. Removing qualified immunity will make it even more difficult to hire, retain well-suited, qualified people to law enforcement. We will lose experienced and well-trained officers because they will not want to put their families at risk. Making substantial changes need to start with how we recruit, hire, train, and monitor officers, not how we punish those who do wrong. If you start ending the protections to officers that stop the removal, what is to stop the removal from other public officials, public servants? Immunity such as for firefighters, paramedics, corrections officers, or dispatchers. Any public servant personally liable beyond what is already written in the laws is a downhill slope and will not help the public feel safer. I encourage you not to make rash decisions due to the nationwide angst and think through the repercussions of this type of law. Because when you write the laws, you expect them to be followed. And when they are not, we have law enforcement to protect the public and enforce them. When we have justice system to punish and rehabilitate those who do not. Law enforcement officers who do not abide by the laws or their standard operational procedures are not protected by any greater standard, and removing qualified immunity will not dissuade anyone from doing wrong. It will only create a situation where people can file a multitude of frivolous lawsuits, which will clog the system and create an enormous cost to the municipalities.
Thank you, Ms. Mason. I've let you go over the 3 minutes, and I'm trying to be fair to everyone by keeping that time.
Absolutely. I'm here. I'm available to answer questions now or at any time, and invite law enforcement, invite you all to join a law enforcement officer on a ride along and understand better what they do.
Thank you very much, and thank you for submitting testimony today. Representative Libby.
Thank you. I simply wanted to ask Ms. Mason if she could please submit written testimony as well.
Yeah, again, I wanted to make sure that I had everything I wanted to say put down prior to this before I got on here, but I will type it up and send it off. I think I can just go to that same site and
spot.
read
Yep,
that.
exactly.
Thank you.
For your time.
Thank you very much, Ms.
Thank you.
Mason. It was nice to see you again as well.
Nice to see you too, Tom.
Our next call on Justin Huntley. Mr. Huntley, when you are ready, just unmute your mic, activate your video, and begin your 3-minute testimony.
Sure. Can you hear me okay?
Perfectly.
All right. Greetings, and thank you for giving me the opportunity to appear in front of you today. My name is Justin Huntley, and I've worked in law enforcement for the past 16 years. I currently work as a detective with the Maine State Police and wanted to offer you my insight as a rank and file line level law enforcement officer as you consider the ramifications of LD 214. To say that LD 214 would threaten public safety in Maine is an understatement. When a police officer is asked to step in and resolve a highly stressful and evolving situation, the police officer must have the peace of mind to act in accordance with their training and in good faith, knowing that if something goes wrong, they will not have to forfeit their personal assets. I have heard from colleagues in states that have eliminated qualified immunity for police officers, and the aftermath is troubling. I have heard police officers in these states quote unquote, look the other way and work hard to make sure they are in no position to have to make an essential arrest. Sadly, these police officers have learned that it is safer for them, liability-wise, to show up and take a report from a victim than to put any attempt into trying to stop crime before it happens. The skyrocketing crime rate across urban America is a testament to this. I am convinced that we have some of the most dedicated law enforcement officers in the world working right here in Maine. However, if LD 214 is signed into law, I am aware of an alarming number of Maine law enforcement officers who have said they will resign. For them, the substantial risk to their livelihoods has outweighed their desire to serve. I work with a number of men and women who volunteer for specialized high-risk assignments, such as working on a tactical team, a bomb team, and a crisis negotiation team, just to name a few. These are the people that we, the rank and file, call when we need to call 911 for an emergency that is beyond our capability. I have heard many of these people discuss their plans to resign from these assignments if qualified immunity is eliminated. Many of these teams barely have enough members to operate as it is. I would ask the legislative members of this body to consider, God forbid, a crisis in their districts in which these specialized law enforcement officers are needed but unable to respond because they no longer exist. Qualified immunity is not a free pass for law enforcement officers to act egregiously. The courts routinely deny qualified immunity to police officers when they deem it appropriate. Furthermore, I can almost assure you that if the legislature wants to have a conversation about designing a mechanism to punish legitimately bad police officers, the law enforcement community would be happy to have that conversation. I respectfully ask all of you, not as a law enforcement officer, but as a constituent and a citizen who enjoys the safety and security provided by our dedicated police officers, to oppose this legislation and open a dialogue about sensible improvements to the criminal justice system that protects the rights of all Mainers. Thank you very much, and I will note I have not submitted my written testimony, but I promise to do that as soon as possible.
Thank you, Detective Huntley, for your testimony and for eliminating the question I was about to ask you. Greatly appreciate your time, and we look forward to receiving your written testimony as well. Thank you for being here today. I will now turn to committee members and open it up for questions. Representative Thorne.
Thank you, Mr. Chair, and with the indulgence of Representative Evangelos giving me his permission to ask a question, I'll ask a question of Detective Huntley that will hopefully serve its purpose to other committee members. You mentioned, Detective, that other states had enacted these eliminating the protection of immunity. And might that have something to do with when we see images and pictures of vehicles that are burning and things that are being looted and smashed, that first question we ask is, why is there no law enforcement there stopping these people from doing this? Might that be that maybe those states have that elimination of protection from immunity that just allows cops to stand back, let it happen, and take a report rather than get involved?
Well, sir, in the circumstances you're describing, and again, talking from colleagues in other states, my understanding from them is that a lot of times in that situation, when you see that stand back and hands off approach, their chief complaint is sometimes they're harnessed at the will of the politicians that are in charge. Again, that's one of their chief complaints. When I was speaking about officers not taking action in other places, this alarmingly is things I'm hearing from places that have eliminated qualified immunity, because they're just weighing out the risk versus the reward. And sadly, they're choosing not to take action in order to save themselves financially.
Thank you for that answer. Thank you, Mr. Chair.
Thank you, Representative Thorne, and thank you again for being here today, Detective Huntley. I will now turn to the next person on my list, and I welcome to the Judiciary Committee, Kristen Gay. Please begin your testimony after you've, well, as soon as you're comfortable. So go ahead, please.
Thank you very much. Good morning, Senator Carney, Representative Harnett, and other distinguished members of the Joint Standing Committee on Judiciary. Can you hear me okay?
Yes, we can.
Okay, thank you. My name is Kristen Gay. I live in Jay, but my husband is Detective Christopher Gay of the Augusta Police Department. I am opposed to LD 214. My husband started in the Augusta PD in 2006, and like most new officers, he has sort of run the gamut of all of the shifts, nights, afternoons, or evenings and days. He's now a detective. But in the last 15 years, he has missed birthdays, holidays, vacations, anniversaries, parent-teacher conferences, Little League games, you name it. But there have been no questions asked, as my kids and I know he's committed to protecting and serving for 15 years. And for 15 years, I have become an expert at holding my breath, because every single time he walks out our door, I hold my breath until he walks back in, or until I get the phone call, I'm okay. And for 15 years, I've listened to him whimper in his sleep, knowing he's probably having nightmares about the suicide that he was called to, the child abuse case, the rape, or the unattended death that he was called to investigate. For 15 years, he has told me very little. He tries to keep me from worrying about him, while his shoulders carry the worry of not only me and our kids, but of the missing woman that he searched tirelessly for 2 years, or for the elderly veteran who he knows is all alone, or the drug addict that he hoped would recover. Now there is a new fear, the fear that qualified immunity, a term that I never even knew existed until recently, would be removed. The fear that in doing his job, a job that he was called to, that he refuses to give up, that we can be sued and lose everything we have been working for. Sued in a frivolous lawsuit by someone who does not know him or me or our 3 kids. The very person that my husband rushed to help, rescue, or protect would be able to rip away our lives, even if he did everything within the established rules and training and acting in good faith to serve the public. So I ask you to consider this. If you have an emergency, an accident, or someone is invading your home, or you are being attacked, sorry, will you call the police? Will you pray that they arrive as soon as they can? I think the answer is yes. And I would love to say that without qualified immunity, you might not get that protection, that quick response, that rescue you are so desperately praying for. But I know that my husband and all of the tenured cops that I know are still going to get to you. They're sworn to protect you and serve you, and they will continue to do just that, despite the efforts to take away this protection. As for me and all of the families of these brave men and women, we will go on worrying. And should we lose our livelihoods because of a lack of qualified immunity, well, at least we know you'll still be safe. Thank you for your time and letting me present. I'm opposed to LD 214. Thank you.
Thank you very much for your testimony, Ms. Gay. The committee greatly appreciates it. Are there questions from committee members for Ms. Gay? Seeing none, again, thank you very much for your time and sharing the personal details of being married to a law enforcement officer.
Thank you so much.
I will now turn to Russ Taylor. Mr. Taylor, please feel free to begin your 3-minute testimony as soon as you are ready. You still need to activate your video, but you're set to.
Okay.
You can begin with your testimony.
Okay.
In the interest of time. Thank you.
Am I on now?
We can hear you. We can't see you, but we need to proceed. Well, I think that's about to change. There you go. We can see your shoulders and your red tie. Thank you.
Thank you. Senator Carney, Representative Harnett, good morning, committee members. My name is Russ Taylor. I'm a representative for the New England Police Benevolent Association. NEPBA represents over 4,000 police officers throughout New England, including the hardworking and brave police officers in Aroostook County Sheriff's Department, Presque Isle Police Department, Madawaska, and Caribou Police Departments. I'm here today to speak against LD 214. Qualified immunity does not protect illegal actions by police officers. Rather, it safeguards all public officials in situations where the law is unclear and doesn't give them adequate guidance. Abolishing qualified immunity will have a negative, unintentional consequence for all Maine citizens, courts, public officials, and police officers. I served as a police officer for 35 years. One day, as working as a narcotics detective in plainclothes, I received information from an informant that a person was selling a carload of stolen guns at a certain location. As I was pulling into the location in an unmarked car, I observed a male in his 20s sliding a rifle into the back of the car. 3 people were together. 2 ran off, and I took my service weapon out and saw the young man, about 22 years old. He had a pistol in his hand. At his side, partially covered by a hoodie. I announced that I was a police officer and ordered him to drop the weapon. He did not. I pointed my weapon directly at him, ordering him to drop the weapon. He did not. I was calculating in my mind, trying to figure out if he starts to move his gun up, will I have time to shoot first? He just stood there with the gun in his hand at his side. I kept ordering him and telling him that I would shoot if he moved. As other units were arriving, he dropped the gun, was arrested. As he was being put in the wagon, one of the other officers told me he wanted to talk to me. When I approached him, he said, "Thanks for not killing me." I then asked him, "Why didn't you just drop the gun?" He replied, "I could see in your eyes, you were ready to kill me. You said if I moved, you were going to shoot me." A lot of things went through my mind that day, trying to keep myself alive and not having to take someone's life. I would hate to have some police officer under the same circumstances have to make a split-second decision worrying about, will I get sued? Will I lose my house? Will I lose my job? Because the bad guy didn't see in his eyes. And by the way, I think to this day, he was trying to make up his mind if he had the chance to shoot me. If we are going to put officers in this position of having to make life or death decisions, they have to know that society has our back and is not going to let some ambulance chasing lawyer torment the family for years afterwards.
Thank you, Mr. Taylor. I've let you go on over the 3 minutes, and I need to be respectful of all of the folks that want to testify. Greatly appreciate you being here today. Do you plan on submitting a written copy of your testimony?
Yes, I will, sir. Thank you.
Thank you. Are there questions for Mr. Taylor? Seeing none, thank you very much for your testimony today.
Thank you.
I will next call on Shane Stevenson. Mr. Stevenson, welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you're.
Thank you. I think some of the members are familiar with me. My name is Shane Stevenson. I'm a resident of Saco. I am a police officer in Maine, here representing many officers throughout the state. In the beginning of last year, I remember people waving to us and being extremely supportive when COVID hit. It was amazing to see everyone thanking us for having the courage to show up every day despite the lockdowns and risks to us and our families. A lot has changed over the course of a year. All of that stopped after tragic events that officers in Maine had nothing to do with. I can tell you that last year was my most challenging year in law enforcement. It has felt like an all-out attack against the majority of excellent officers that serve the community daily. I've had urine thrown at me during protests and people flipping me off while crossing the Casco Bay Bridge to notify a family that their loved one committed suicide. I take pride in serving the public, despite the hatred I experienced simply for wearing a uniform. This bill will not provide the intended result Representative Evangelos is intending. It will be detrimental to the citizens and the good in the law enforcement community. It will make recruiting compassionate, capable, and intelligent officers even more challenging. The experienced officers and leadership that foster some of the nation's best law enforcement practice will vacate as soon as they possibly can. This will leave massive voids in the profession and their historic work will be lost. Look at the Maine Criminal Justice Academy job postings before deciding on this bill. There are vacancies all over the state. I constantly, in my travels, ask for those calling for change to join me in this career. I ask for them to be the change and serve their communities. I very rarely find anyone willing to be that change, especially in today's climate, which is extremely challenging. Look at the cities paying excessive amounts of money to undo the damage that's been done in other states that have passed this. Law enforcement in Maine is how law enforcement should be in the rest of the country. If you look at all the other locations where qualified immunity was taken away, you'll see that violent crime is up. This is not what Maine citizens deserve. Representative Jared Golden did the work before he voted. He asked the Somali population of Lewiston what they wanted, and they told him a better relationship with police and less crime. I think this is something everyone can agree on. I condensed down my testimony. I will submit written testimony to you. And I also want to include a letter from Chief DeLuca from Holton. This reaches all the way in southern Maine, all the way to way up north. And I'm scared of what lies ahead. I did leave law enforcement and came back, and I'm hoping that the Maine legislature does their due diligence and does what they need to do.
Thank you very much, Officer Stevenson. And I apologize if I don't have your title correct. The committee appreciates you being here today and looks forward to receiving your written testimony. Are there any questions for our last presenter? Seeing none, again, sir, thank you very much for taking time out of your day to talk with us and share your experience.
Thank you.
I will now turn to the regular person who appears regularly before the committee, and welcome back Sheriff Morton for your 3-minute testimony, sir.
Good morning. I apologize. I'll get the document in front of me. Senator Carney, Representative Harnett, and honorable members of the Joint Standing Committee on Judiciary. My name is Troy Morton, and I am the Sheriff of Penobscot County and President of the Maine Sheriff's Association. Maine Sheriff's unanimous position is to oppose LD 214, an act to eliminate qualified immunity for police officers. To approach a decision on whether or not qualified immunity should be eliminated in Maine, it's critical to understand how this protection works for law enforcement officers. I hope to illustrate that in this essential tool by sharing a story. An elderly woman hears somebody entering her home at night. She lives alone, and acting on her fear, she dials 911 and reports the break-in. The young officer who is on duty receives the message from dispatch and heads towards the address provided. The officer is a husband, a father of 2 children, and their family has just bought their first home. En route to the break-in, the officer does not exceed the speed limit, but unfortunately, he is involved in an automobile accident. At the time of the accident, the elderly female calls the police and tells them that her son had stopped in to surprise her, and there was in fact no break-in. If qualified immunity were to be abolished, this well-meaning officer could face devastating charges as he was no longer heading to the scene of a crime. The devastation of a lawsuit could destroy the officer's financial stability, and his family could lose their home. Proponents of qualified immunity limitation wrongly claim that nearly all judgments and settlements would be paid by the government's employers or insurers. In Colorado, the only state in the country that has abolished QI, the officer would be personally liable for up to 5% of the judgment. In Maine, where a majority of sheriff's offices are facing staffing shortfalls, the beginning salary, some entry-level positions as low as $28,500. Maine ranks 43rd in our country for law enforcement salaries. Eliminating qualified immunity would undoubtedly impact our efforts to recruit and fill vacancies. The national movement to abolish qualified immunity is in response to the events that have unfolded across the United States. Maine sheriffs acknowledge that many of these tragic, horrific events should have been prevented. We detest police brutality, and we stand together in our efforts to find reasonable ways to prevent these toxic scenarios from finding their ways into our state. It's important to remember that abolishing qualified immunity would not change the outcomes you've heard about. Qualified immunity does not protect an officer whose actions fall outside their agency's policies. The men and women who wear the badge in the state of Maine commit to serve and protect each and every day of their careers. Those who carry out their duties with integrity and honor are the most devastated when one of our own missteps. It's a reflection on all of us. Those who dishonor the badge can and must be held accountable for their actions. The misconception that eliminating qualified immunity would prevent a victim of law enforcement misconduct to cover from the actions of an offending officer. This is simply not true. Qualified immunity only protects.
Sheriff Morton, I apologize. I'll let you go over the 3 minutes, but I do need you to wrap it up if you could, sir.
I have 2 sentences, sir, and I appreciate that. Qualified immunity only protects an officer who performs their jobs within the parameters of the policy set forth. If an officer violates the law, he is not protected from qualified immunity. I appreciate your consideration, and it's my pleasure to answer any questions. And as an officer, I'm sorry. Representative, I'd only add, I have to add this part. As an officer for more than 30 years, I can't think of a more important bill that we oppose. I appreciate your time.
Thank you, Sheriff Morton. And I will turn to committee questions. Representative Moriarty. Steve, you're muted. Representative Moriarty, you're muted.
Of course I was, sorry. Sheriff Morton, what sort of liability insurance coverage does your department carry? And are you aware of a carrier ever asserting an exclusion based upon the particular conduct involved?
So I can speak specifically for the county sheriff's offices. They're covered by a county risk pool that provides coverages to all the county sheriff's offices. As to their statistics on whether, to answer your question, whether they paid out on something that's extended, I wouldn't have the answer on that.
Well, do you know of any deputy or officer who in fact has ever become personally responsible for a civil judgment?
I'm not personally aware of that, and I think that's our point behind if qualified immunity goes away, that will become a reality.
Good, thank you.
Thank you, Representative Moriarty. Are there additional questions for Sheriff Morton? Seeing none, thank you for your time again, Sheriff Morton. It's always good to see you. We appreciate you taking the time to testify today. I will now turn to
Representative Poirier has a question.
Thank you, Mayor Carney. Representative Poirier.
Thank you. Sorry, I tried to get it in there a little sooner. And thank you, Sheriff Morton, for coming to speak with us today. I just wanted to get your opinion on costs if this bill were to go through. Is it your assumption that costs for counties or municipalities insurance-wise, that you would see a great increase without qualified immunity in insurance costs?
So certainly, I think there would be impact on the government's insurance. But to be quite frank, Representative, I look at the wives and husbands that testified today. I worry more about the officer's family and the liability that's being put on them. Who pays for their individual insurance and coverage if that is removed? And so, while to answer your question and representing the county, I probably have to say the right thing. Yes, there'll be an impact to the county government, state government, municipalities, but I worry too about that man or woman who serves in that role and their protection.
And Mr. Chair, may I ask a follow-up, please?
Yes, you may, Representative.
Okay. And Sheriff Morton, do you think there is also a chance that without qualified immunity that those officers may even have difficulty actually obtaining those type of policies at all?
That's an interesting question, one I haven't thought. Tremendous question. I hope that somebody perhaps during work session could answer from the risk pools or from insurance providers or whatnot. But tremendous question. I appreciate you asking.
Thank you very much for your insights.
Thank you, Representative. And again, thank you, Sheriff Morton, for being with us today.
Thank you.
I will be a little slower. I am trying to move things along, but if there are other questions from committee members, if you could raise your electronic hand. Seeing none, thank you again, Sheriff. I will now turn to Thomas Pappas. I hope I've pronounced that correctly. Welcome to the Judiciary Committee, sir. And please begin your 3-minute testimony whenever you're comfortable.
Thank you, Representative. Good morning to the members of the Joint Standing Committee on Judiciary. My name is Tom Pappas. I'm the current president of the Maine State Troopers Association, representing 270 troopers. We too are also members of the Maine Law Enforcement Coalition. So today, as I speak before you, I am proud to be one of the voices representing over 3,000 state, county, and local officers in our great state. I am testifying today in opposition of LD 214. I am an active member of the Maine State Police and have been a certified law enforcement officer since 2006. I grew up in New York City. However, once I became an adult, I chose to plant my roots here because of all the things Maine has to offer. One of the most important attractions to me was safety. Along with several other attributes this great state has to offer, the elimination of qualified immunity would strip that from your constituents. Largely due to the national dialogue that at first trickled into this state, but has now flooded it, I have seen police officers leaving at alarming rates. They have either resigned after serving between 5 and 15 years or retiring when they had no plan to do so. In fact, the most recent example was a fellow officer buying back less than 1 year of prior service time at an astronomical rate so he could retire 9 months early. There are many police officers that are teetering on the edge to seek other employment. Why? Because mentally and physically, they cannot take this job as it stands now, let alone what's potentially on the horizon with the passage of LD 214. If LD 214 passes, we are left with officers that do stay or the ones graduating from the academy, but you can't accelerate experience and maturity. How many frivolous suits can those people sustain while following the Constitution, the law, all academy endorsed techniques, and staying within all department policies and procedures? I know you've heard about recruitment and retention. Maine currently has some of the highest trained individuals in the nation, thanks to our Maine Criminal Justice Academy. Among those ranks, we have members with additional training that respond to the most serious incidents in the state. This is not in their job description. These are extra duties above and beyond their assignments. I have met with a number of those individuals. The message to me was loud and clear. If this passes, they will not put themselves at any extra risks to face, again, not the criminal suits, but the civil suits that are frivolous, that are stripping of qualified immunity would open them up to. They would abandon those units to avoid any extra chances of being sued. Lastly, I want to touch on proactive policing. This is policing in which there is not a 911 call, but in fact, a police officer in an area doing community policing who sees something out of place and investigates it before a crime occurs or during the commission of it. But the police officer's proactive actions mitigates the risk of victimization.
Trooper Pappas, I apologize for interrupting, but I've let you go over the 3 minutes, so I need you to wrap it up if you could, sir.
Sure. I got about one paragraph left. The foundation of case law has been built on these types of cases. If you have played sports, you know that the best offense is a strong defense. As it stands now, currently with the national narrative, this group of officers are extremely hesitant to do this type of work without the traditional 911 call where there's a victim screaming for help. The passing of LD 214 would eliminate any type of proactive work, as these highly trained officers would want the backing of a victim of a crime on their side in court during these frivolous civil suits that LD 214 would open us up to. I am proud of the members that I represent and stand shoulder to shoulder with them every day and love the state of Maine and all its attributes. I speak for all of us when I say we are terrified for all our families and friends as to what the state looks like if the passing of LD 214 happens. Please vote ought not to pass LD 214.
Thank you very much, sir. Are there questions for Trooper Pappas? Seeing none, again, the committee thanks you for your time today. Do you plan on submitting written testimony, sir?
I will, sir, immediately.
Thank you. Thank you very much for that. That takes me to the end of those who had registered to testify in opposition. I will go through the room again later, but right now I'm going to turn to people who have testified, who have registered to testify neither for nor against. And I would ask that, Soupy reads my mind. Ms. Menhart, you please begin your 3-minute testimony as soon as you are ready. Welcome to the Judiciary Committee.
Thank you very much. And I know you guys have a long day already. So I have submitted my written testimony, and I kind of bring a different perspective to this in the sense that I was the deputy director of the Police Community Relations Task Force when Abner Louima, the Haitian immigrant that was beaten and sodomized in New York City, when that task force wrote its recommendations. Then I spent 7 years running NAMI Maine, which meant I spent over 8 hours alone, often the only non-cop, with 1,000 police officers across the state of Maine. So I do not think that Maine's policing is perfect. I don't think our academy is perfect. I also don't think that removing qualified immunity is the right step to take right now, first step. You'll see that I outline a whole bunch of things that I think should be examined and considered before that very reactionary move is made, because it's true that I was a child welfare worker and I had qualified immunity when I removed a child, and whether that was the right decision or not, I couldn't be sued in that moment. And that is what it would do if we take it away from law enforcement. I also hold the unique role of being the sibling of a civil rights lawyer and married to an individual who's been a police officer in the state for 28 years. So I see inside of both perspectives. And there are challenges in our police force in Maine. There definitely is an old guard and a progressive guard. The progressive guys are really trying to transform law enforcement in Maine, and the old guard, not so much. So I absolutely think we need to look at things like the academy, how promotions are decided. We need to look at who does the misconduct reviews and how transparent are those. But we need to look at the systems, not demonize the individuals. You don't promote systemic change when you go after individuals. You promote systemic change when you evaluate from a very transparent and inclusive perspective the different aspects of our system. So I would just strongly advocate, and I am working on a dissertation on how to increase procedural justice and citizenship behaviors among law enforcement, because that's what we all want. The more procedural fairness that they are shown, the more procedural fairness they show the public, the more well they're treated by the departments, the better they treat their citizens. And that's not Jenna's opinion, that's a lot of research that says that. And so when we think about ways to transform law enforcement, there's a lot of things to look at. And just this reactionary get rid of qualified immunity is not what I would recommend as someone who has had plenty of battles with law enforcement and has stand toe-to-toe in support with some law enforcement across the last 25 years. So my testimony does list a whole bunch of things, but what I will close with is to say my strong recommendation is that you all think about passing legislation to create a committee to plan to modernize and professionalize law enforcement in Maine, and that you really include innovative thinkers on that group, and that we really look at how do we move the law enforcement forward and not just pass something that will drive folks out of law enforcement. It'll actually drive the folks who have more choices out. In my opinion, that'll be a really negative unintended consequences.
Thank you very much for your time and testimony today, and for the written testimony that you submitted as well. Are there questions from committee members? Seeing none, again, thank you very much for your time today, and thank you for your patience. I know this has been a long morning.
Thank you all very much for your time. Bye-bye.
I will now call on my final person registered to testify neither for nor against, and that is Rebecca Graham. Welcome to the Judiciary Committee again, Ms. Graham. Begin your 3-minute testimony when you're ready to go.
Thank you, Representative Harnett, Senator Carney, and distinguished members of the Judiciary Committee. My name is Rebecca Graham, and I'm here on behalf of MMA and at the behest of our 70-member Legislative Policy Committee. And I'm providing testimony neither for nor against because I've submitted a substantial bank of material that pertains to both of the bills that you'll be listening to today, and we find 416 more workable. Summary judgments or qualified immunity is not always available or granted to police, contrary to what you've heard here today. And I encourage you to review the materials I submitted with my testimony for some evidence of that. Those materials also include efforts from our neighboring states to address these matters, which include model policies from the committee to understand what systems for behavioral accountability already exist here in Maine, and that there's an opportunity for enhancement and change that's worth exploring there. We can have well-trained, kind-hearted, ethical employees, but they're always going to be human, and the law has evolved to understand and address this fact. Qualified immunity is one of those tools that recognizes that these employees in particular are called on to make split-second decisions under extreme stress in rapidly evolving, dangerous scenarios, and those decisions have consequences for everyone. When they've acted with due regard to their training and the policies of the agency they represent, they and their families deserve our protection to the same degree that those on the receiving end of those decisions deserve justice. And QI doesn't remove other paths of civil recourse for those individuals. Granting employees in these circumstances as a summary judgment is an opportunity for system change, because it's at that point that the injured party can and does return the onus back onto the agency to determine if the policies that they were adhering to require review or are in line with accepted practice. Removing this option means that the focus is going to be entirely on the individual and not the system. The committee should consider, is it the responsibility of the individual or the system to drive the change? As the Supreme Court recognized in Harlow versus Fitzgerald, there's a cost to our social fabric for opening public officials up to unchecked litigation. Qualified immunity was constructed to strike the balance between the competing values of vindicating constitutional rights and protecting public officials from meritless suits. And municipal police find themselves in these situations daily, and because of this, they're far more likely to attract suits. And it's for those reasons that officials find the proposals that are under LD 214 entirely unworkable as drafted. We share the desire to eradicate bad cops from our ranks. However, legislative reforms have to be proportional, informed, and evidence-based to protect the existing workforce and attract and retain the brightest community-oriented officers. And that requires unified bipartisan investment. And you should ask yourselves if you want to pay for litigation, or do we want well-paid, well-trained, ethical employees? Officials want to work together with our state partners to do better with our partnership on reform. And the national conversation arrived here through a system of underfunding a wide set of tools that included defunding community policing programs, health and social programs, and then it asks our law enforcement to be the stopgap for that fallout. And with that, I see my time is almost up. So I will be testifying again on 416, and I'm happy to answer any questions or bring back any material or additional information that you may desire for your work session.
Thank you very much, Ms. Graham. We appreciate your time and testimony today. Are there questions from committee members? Representative Moriarty.
Thanks, Mr. Chair. Ms. Graham, I'm a little puzzled about your several references to summary judgment. How does that play into your view of the impact of this bill?
Summary judgment is the process to which qualified immunity is arrived at. So it is the judicial review of the set of circumstances around an incident in which a qualified immunity case can be brought. And it's at that point where they decide whether or not there are merits to that, whether or not there's clear established law, and whether or not those expectations of that activity, given the circumstances, either would be reasonable or objectively feasible under existing or another trained individual would react in that same way. Where it isn't clear or there are questions about that, qualified immunity isn't granted. And the Druin case that I included in my testimony is an example of where it wasn't included. However, the officer also prevailed, and that is the piece that I don't think that folks really understand.
If I could follow up, if there are intensely disputed factual issues in a case, as there would likely to be, summary judgment is not likely to be granted on behalf of either party, correct?
Correct. And it frequently is not.
Right. So cases go full length to trial, and then it is determined whether or not there is a violation or not.
Correct.
Okay. All right. Thank you.
Thank you for that question.
Thank you, Representative Moriarty. Are there additional questions from committee members? Seeing none, thank you very much, Ms. Graham. We appreciate your taking the time and being here today with us. That ends the list of people that I'd had signed up when the hearing began at 9 o'clock, but I know that some people signed up after that. So I am now going to turn to the attendee room and ask if there are any persons who wish to speak in favor of LD 214. If you could raise your electronic hands. And I am seeing 2, 3. So I will begin by asking, Subi is always ahead of me. I would now recognize Lori Boxer-Makeover. Welcome back to the committee. And please begin your 3-minute testimony as soon as you're comfortable.
Okay, thank you. I'll get started right away. Thank you, Senator Carney and Representative Harnett and members of the Judiciary Committee. I've enjoyed actively listening to everyone's testimony this morning. I've been taking notes, and I think that the best use of my time is not to reiterate everything that's in my written testimony. I urge you all to look at that, but I did want to respond to some of the questions that I've heard some of you asking, as well as some of the things that I've heard other people testifying about. So let's start with Representative Poirier's questions about insurance. One study that I did not include in my written testimony is a study that has been going on at the UConn Center for Insurance Law, and they're looking at an act that was enacted in Connecticut on police accountability that's not directly a qualified immunity exemption or an act to end qualified immunity, but it does hold police officers accountable in a different way for civil rights violations. And the UConn Center for Insurance Law is looking at whether there would be ramifications in the way of costs in increased insurance premiums for municipalities, which is what Representative Poirier was asking about. And I believe that their preliminary findings suggest that there won't be exponential increases in insurance costs. So I'd definitely refer you to that study, preliminary study. Happy to get you all a copy of that as well. well so that it's readily accessible to you. I've also heard a lot about people's lives being lost if we were to, as a state, decide that this was an appropriate course of action to end qualified immunity. And I just urge you all to think about the fact that right now, people's lives are already being lost due to the fact that there is wide discretion for officers about their acts and wide and very narrow accountability for officers. I'm testifying here today as someone who highly respects many police officers. And some of the people that you heard from today are people that I work alongside regularly, and I respect. However, I'm a big proponent of the fact that we need to do something about the system that's not working, and we need to start applying our laws equally across the board and holding officers accountable the way that we hold other professionals accountable. Which leads me to that discussion that we've heard from some others about split-second decisions. We as a society have a number of professions where people are required to make split-second decisions, and they do not have the benefit of qualified immunity. Let's think about some of the people that we heard cited today: emergency room professionals, surgeons, air traffic controllers. Those people have to make split-second decisions too, as do I, an attorney, a trial attorney in the courtroom. And I'm not exempt. We're in a pandemic right now, and I'm still held accountable, and so should our law enforcement officers in all different types of settings be held accountable. I recognize that those officers are faced with life and death situations, and we want them to be able to act responsibly and not question their actions, but it's the same thing with respect to surgeons. There's really no difference, and there's no qualified immunity there.
Ms. Buxton-Maycumber, I'm sorry, I need to interrupt you because I've let you go over the 3 minutes, but I need you to wrap it up.
Okay, all right. I just also, because I'm an attorney, I want to speak just very briefly to the fact that there will not be a flood of frivolous lawsuits, because attorneys are bound by rules of ethical and professional conduct, as well as the main rules of civil procedure. And many of us turn down many cases every week that don't have merit. And it's highly unlikely that people are going to waste their time and resources on cases that are frivolous. So thank you. Yeah.
Thank you very much. And I failed to ask you at the beginning, could you please identify where you live and who you represent?
Correct, sorry. Lori Boxer-Macumber. I'm a resident of Portland. I work throughout the state, and I am testifying today on behalf of the Maine Trial Lawyers Association. I'm the president of the Maine Trial Lawyers Association.
Thank you very much, and thank you for your patience today. Are there questions from committee members? Seeing none, thank you very much for your testimony, and thank you for submitting the extensive written testimony that you did as well.
Sure. Thank you all for your time and service.
Thank you. I will now call on Catherine Martinez. Ms. Martinez, as soon as you're ready, just unmute your microphone, activate your video, and begin your 3-minute testimony. And welcome to the Judiciary Committee.
Hi, thank you for having me. Unfortunately, I don't have video available today.
Okay.
Good morning, everyone. My name is Catherine Martinez, and I'm a New York City-based activist, advocate, and founder of the Ending Qualified Immunity Project, which was started last spring to advocate for legislation to end qualified immunity at the federal, state, and local level, so victims of police misconduct have a viable path to justice when their rights are violated. Across the nation, law enforcement have continued to escape accountability from criminal prosecution when they commit constitutional violations against the public. And again, when they're victims of police misconduct, attempt to seek justice in Section 1983 actions. Congress passed this law during Reconstruction to empower newly freed Black Americans with a cause of action against official misconduct. The Supreme Court then gutted the Civil Rights Act by inventing the doctrine of qualified immunity and imposing an almost insurmountable burden on Section 1983 plaintiffs whose rights have been violated, unless they can prove with a case almost with the exact facts that their rights were at issue were clearly established at the time of the violation. Qualified immunity shields police officers from accountability, obstructs the pursuit of justice, incentivizes a police culture of lawlessness, undermines the constitutional rights of every person in this country and Maine residents, but particularly marginalized communities of color that are already over-policed and underprivileged. What started out as an intention to avoid frivolous lawsuits has developed into what Justice Sotomayor wrote is an absolute shield that tells police they can shoot first and think later. Last year, George Floyd's death shocked the nation and sparked protests, triggering calls for police reforms, including the end of qualified immunity. About 1,000 people are killed each year by law enforcement. Less than 2% of fatal police shootings are criminally prosecuted, and only 8 officers have ever been convicted since 2005 of murder. Black and Latinx Americans are disproportionately impacted by the lack of police accountability. Black Americans in particular are more than 3 times more likely than their white counterparts to be murdered by the police. I'd like to also address some comments that were made. New York City actually did not abolish qualified immunity. They limited the doctrine for unreasonable search and seizure only. And of course, we know that law enforcement do not limit themselves to only violating our 4th and 14th Amendment rights. Also, holding police officers accountable is absolutely not a step towards eliminating policing, but a commitment to ensure equal justice under the law and for all Maine residents. Police are not held personally accountable due to indemnification clauses, and so city and taxpayers actually foot the bill for police misconduct. We agree with the ACLU that correctional officers should be included, and so we support that amendment. To Danielle Lefferts, police are not held to a higher standard. In fact, they're held to a lower standard. Ignorance of the law is not a defense to liability unless you are a police officer. To Jessica Ramsey, championing Black and Brown lives is absolutely a movement with merit, and to say otherwise is an exercise of incredible privilege. Law enforcement need mental health resources to deal with the stress of their job, not a blanket shield to kill with impunity. And to Jenna, we absolutely need systemic changes like ending qualified immunity at the state, federal, and local level to address systemic issues, including racism in policing. Anything less is a disservice to Maine residents and all Americans. Thank you very much for your time, everyone in the committee, and that is my time.
Thank you very much for your testimony, Ms. Martinez, and thank you for submitting your written testimony as well. Are there questions from committee members for Ms. Martinez? Seeing none, again, thank you for taking the time to be here today, and I will now move on to Lauren Bonds. Ms. Bonds, welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you're ready.
Thank you, and good afternoon, Chairs Carney, Harnett, and members of the committee. My name is Lauren Bonds. I'm the legal director of the National Police Accountability Project. Thank you so much for allowing NPAP the opportunity to testify before you today. NPAP is a national nonprofit organization dedicated to holding police officers and correction officers accountable to constitutional and professional standards. We strongly support the passage of LD 214, a bill that will eliminate qualified immunity and provide victims of civil rights abuses with the opportunity to sue police in state courts. The doctrine of qualified immunity has created a nearly insurmountable barrier for communities to hold police officers civilly liable in federal and state courts when they encounter civil rights violations. We've heard a lot today about qualified immunity doesn't protect people who act outside of the law. That is blatantly false. It categorically only protects people who act outside the law. So qualified immunity is a 2-step process. First, the court considers whether a constitutional violation occurred. Then it considers whether the constitutional violation was in contravention to clearly established law. We only get into qualified immunity if the court recognizes that a constitutional violation has indeed occurred. So the clearly established law requirement has developed to essentially require a plaintiff to be able to identify a factually analogous case within the jurisdiction where the person is suing. You can think of a number of really problematic outcomes this would have, and I could tell you about all of them, but I'll talk to you just about one case. In the case of Corbett v. Vickers, a deputy sheriff accidentally shot a 10-year-old child who was lying on the ground after he repeatedly was trying to shoot a family pet that was on the scene that was posing no risk to anybody at the site. Even though the court found that the deputy sheriff indeed violated the child's constitutional rights, it found that he was entitled to qualified immunity because no other police officer had been sued in that jurisdiction for accidentally shooting a child while trying to shoot a dog. There are dozens of other equally ludicrous and unjust outcomes that have resulted from the doctrine of qualified immunity. But I won't go into all of those. I will add them to my written testimony, which I intend to submit after this hearing. One of the core policy functions of permitting people to sue for their civil rights violations is to deter future violations. If government officials know that they can be held accountable, they're more likely to act in a more judicious and careful manner when they're carrying out their duties. By enhancing opportunities to hold police officers accountable for misconduct, LD 214 will deter future constitutional violations and will make Maine communities safer. We urge you to pass LD 214 and remove immunities that undermine police accountability. I'm happy to answer any questions, and we'll send you along some more extensive written testimony because I know we're short on time.
Thank you very much, Ms. Bonds. You wrapped up 1 second ahead of the 3 minutes. Well done. There are questions from committee members for Ms. Bonds. Seeing none, thank you very much for taking the time to testify today. We look forward to receiving your written testimony, and thank you for your patience in what's been a long morning. I will check the attendee room one more time to ask if there are any persons who wish to testify in support of LD 214. To please raise your electronic hand. Seeing none, I will ask if there are any persons in the attendee room who wish to speak in opposition to LD 214 to please raise your electronic hand. Seeing none, I will ask if there are any persons in the attendee room. I'm sorry, Representative Libby.
Thank you, Mr. Chair. I believe that there is at least one person waiting who had contacted me, a Corey Reynolds, who wishes to speak in opposition of.
If Mr. Reynolds is in the attendee, all right. If the committee clerk, thank you, Representative Libby. I did not see an electronic hand come up. If could committee clerk Ms. Panett please move Mr. Reynolds into the panelist room. Mr. Reynolds, good afternoon. As soon as you are ready, please feel free to present your 3-minute testimony.
Good afternoon, Senator Carney, Representative Poirier, and all the other members of the Judiciary Committee. Our law enforcement is there to protect us when bad things happen like crime. We need to support our law enforcement. Yes, there is some bad cops, but there's also some bad governors. So we just need to support them. The police officers are there to protect us. They need to do better at training, and nobody deserves to die, an officer or any subject of the community. If you take away our law enforcement and you need assistance, someone is breaking into your home or whatever is going on, you need them to help you. Or if someone that don't agree with your liberal agenda goes wrong, you always need police there to protect you. So I am not in support of this bill. Thank you for your time.
Thank you very much, Mr. Reynolds. Could you please state your residence and if you are representing anyone here today?
Waterville.
Okay, thank you very much, sir. Yeah. Are there questions for Mr. Reynolds from any committee members? Again, thank you for taking the time to testify today and for sticking it out through this rather lengthy hearing. We appreciate your time. I will check one more time in the attendee. Is anyone who wishes to speak in opposition to LD 214? Seeing none, I will ask for the final time if there's anyone who wishes to speak neither for nor against LD 214. Seeing none, having received testimony from those present, Tracy Gregoire, if she could be moved over. Ms. Gregoire, welcome to the Judiciary Committee. If you could state your name, residence, and the capacity in whether you're speaking in favor, in opposition, or neither for nor against LD 214.
Sure. My name is Tracy Gregoire. I live in Topsom, and I'm speaking as a citizen and a mom.
Okay. Okay. Can you activate your video, or is that not possible?
Oh, maybe if I switch screens, it goes away. Sorry about that.
That's okay.
So yeah, I'm speaking now just because I have a son at home due to COVID cases. So I'm a mom of a 12-year-old who is Black. He identifies as having brown skin. He's adopted. He also has autism and ADHD and anxiety. And, I think, as a mom, we tell our kids they need to have consequences for their actions, right? If they do something, there's a consequence. We support law enforcement. Most of them are great people and do a good job, but there needs to be consequences for the ones that are taking lives or harming people and not following the rules. And I don't have all the answers, whether it's limited immunity or something else. I think we just need to step up as a state and figure this out. And I'm happy to, be a part of those conversations. I can tell you it's really hard as a mom to have a 12-year-old who is afraid of the police, and literally over the past few months gets worse and worse and actually starts to bolt, even though he's very verbal and intellectually does very well academically. He just cannot deal with the news, even if we're not watching it, the news coming from his friends about more Black people being shot or people of color being shot or harmed, and some of them are kids. I will say that, I think there's less of this in Maine, but there's still racism. I grew up in Lewiston. I was a part of the anti-racism rally when the KKK came to Lewiston. I was in meetings with police who denied that there was racism in the city. I think we need to acknowledge the problems with the system and work on it together. And like I said, I don't have the answers. I just think we need to figure it out together. And I appreciate the committee listening to all of these bills. I know it's going to be an even longer day for you than for me, but thank you for the time.
Thank you very much, Ms. Gregoire. Do you plan to submit written testimony?
Yeah, I'm happy to do that. I wasn't sure if I could do that later today or tomorrow, or if there was a time limit on that.
There's not a time limit. The sooner you get it in, the sooner it will be before the committee members, though.
Okay, great. Thank you.
Thank you. Are there any questions from committee members for Ms. Gregoire? Seeing none, Representative Thorne.
Thank you, Mr. Chair. And again, less of a question, but more of advice. Thank you, Ms. Gregoire, for showing up and providing your testimony. And I feel compelled to offer you some advice, and I know you can't shield your son from his friends and so forth, but I would definitely shield him from the news, because as a result of local news showing national news about a lot of these incidents, it does fan the flames of those that are trying to put our trust in our police force. So that would be my only advice for you, if you could.
Right, certainly. And like, as you know, like middle schoolers are all on the news and listening to it. And the reality is he's not always probably going to live in Maine, and there's racism here too. And I can't, as a mom of a child of color, like deny that, right? Like, so we have had to have those, tough discussions with them, but also have reached out to local police who are very supportive, and we're really thankful for that.
That's great. Thank you. And I wish you the best of luck.
Thank you very much. Are there additional questions? Seeing none, thank you very much for taking the time today to share your personal experiences with the Judiciary Committee. It's greatly appreciated. This, I hope, is the last time I ask this question, but are there any members in the attendee room who wish to be heard in any capacity on LD 214? If so, please raise your electronic hand. And seeing none, I now, having received testimony from those present today wishing to testify, I will now close the public hearing on LD 214. I thank the committee members. I thank all of those who participated in our 3 hearings this morning. Given the time, we do have one more public hearing to go, but in fairness to particularly our staff on these hearings, I am going to recess the hearing until 1:15. I would ask people to be back as close as possible to that time so that we conclude our final public hearing on LD 1416 and then move into our work sessions. I would advise all members to mute their microphones and shut off their videos, and we will get together at 1:15. Hey, Jeff. I just emailed you. If you could take a look at it.
Okay, Tom, I will.
Thanks.
Hello.
Hi, Peggy. Hi, Chris.
Hi, Peggy. Hi, Tom.
Do we have a plan for this afternoon? We're just gonna keep. I like his sense of humor there.
Work in progress there.
Okay.
We're going to stay with the schedule we have. It's not sustainable. I don't know what to say.
Okay. I think that you have a great committee that can try to figure that out. See how long the hearing takes and then start moving into the bills.
Yep, that's the plan.
Right. And I think the first bills you're going to take up are the ones that you didn't get to on Tuesday, right?
That is correct.
All right.
I got your email and
you might, can you call me? I don't think you want to, I think we're on Zoom.
This is innocuous. I would prefer to see if we can develop an amendment at work session, and failing that, would look at your suggestion, but I don't want to, it seemed like there was overwhelming support for it amongst the prosecutors and stuff, so.
And there is on the committee, it's a question of where it goes.
If we're floundering in the work session, then I'd be open to the suggestion, but I want to give it a try.
Okay.
And I am open to the AG's office part of it, but only if there's a firewall, like an Inspector General.
And they know how to do that. They know how to do that. All right, committee members, as you return, if you could please activate your cameras so I can know who is here. Make sure we can start up. We did say we would start at 1:15, and I'm counting 1, 2, 3, 4, 5, 6, 7. We're good to go. And I know that people may be joining us late, but we have too much work to do, so we need to start.
Excuse me.
With that,
Tom,
yes, Senator
before
Carney?
we get started, I'm wondering if either Peggy or Soupy could post in the chat the order of the work sessions this afternoon. I was starting to do it, but realizing that it was my turn to introduce my bill.
Sure. Peggy is saying
I
something.
will take care of that. I will take care of that. Thank you.
That helps all the folks who are waiting. Thank you very much, Peggy.
I'm just going to post LD numbers. I hope that's enough.
Yes.
Okay, great. Thanks.
Thank you very much, committee members and members of the public in attendance. Welcome back to the Judiciary Committee. We will now hear our last public hearing of the day before moving into work session on a variety of bills, and the order of the work sessions will be posted in the chat by our analyst. And I will now open the public hearing on LD 1416, an act to limit qualified immunity of law enforcement officers in Maine Civil Rights Act claims. And the bill will be presented by my co-chair and our colleague, Senator Carney. Senator Carney, welcome.
Thank you.
Public hearing.
Thank you. Good afternoon, Chair Harnett and esteemed colleagues on the Judiciary Committee. As you know, I'm Ann Carney, representing Senate District 29, South Portland, Cape Elizabeth, and some of Scarborough. It's an honor to be before you today to introduce LD 1416, an act to limit qualified immunity of law enforcement officers in Maine Civil Rights Act claims. The Maine Civil Rights Act prohibits intentional interference or an attempt to intentionally interfere with rights under the US and Maine constitutions and under federal and state laws by using force or the threat of force to harm people or property. And if you look at my testimony, committee members, you'll see a hyperlink to the Maine the Maine Civil Rights Act. So under the Maine Civil Rights Act, the Attorney General could bring an action on behalf of an injured party to get injunctive relief and civil penalties. An injured party could also bring his or her own civil action for damages. Maine Civil Rights Act claims can be brought against private parties or against government actors. So it's a little different than the federal civil rights law. LD 1416 actually only applies to claims against government actors and a particular type of government actor, that is law enforcement officers. The act itself, the act itself does not mention qualified immunity. That comes into the picture through the federal case law that established immunity for a government official unless the rights they violated were clearly established at the time of the violation. You heard much testimony this morning that qualified immunity is too broad and that law enforcement officials should be held accountable in situations where they have instead been granted immunity from liability for a violation of rights. And you also heard a lot of testimony from members of the law enforcement community about the importance of qualified immunity within, the importance of qualified immunity. LD 1416 would deny qualified immunity in those egregious situations if 4 factors are met. First, the officer's conduct in fact violated constitutional or statutory rights. Second, the law enforcement officer used or threatened to use physical force or violence in the violation of rights. Third, the officer was required to receive training under Maine law. And fourth, that the agency employing the officer was also required by Maine law to have policies concerning the use of physical force. An officer who has received training and works for a department that has use of force policies, yet still violates constitutional rights, would, under this proposal, not be able to argue that those rights were not clearly established. This bill strives to focus on the most egregious situations and to deny qualified immunity when all the factors point to the right being clearly established, the officer having received training on the use of force, and the officer's department having policies prohibiting unlawful use of force. The bill limits liability in these cases to $10,000 per violation. And here I want to go off the script of my prepared testimony, because I think what we saw this morning was that this is an extraordinarily difficult issue. Understanding qualified immunity just from a legal perspective is really challenging, and then understanding how it applies in real life to the hard work that law enforcement officers do day in and day out is also complex. And I think actually the most challenging thing is figuring out how we can rework qualified immunity so that it provides the protection that law enforcement officers need, and yet doesn't allow those egregious situations that horrify all of us when we see them unfolding. I don't think, honestly, that 1416 achieves that balance. I learned a lot from the testimony today, both by the proponents and opponents speaking with regard to Representative Evangelos' bill. And I thought that it was actually an incredibly powerful hearing and has given me a lot to think about. I do feel that it's really important for us as a state and as the community of Maine to work together to figure out how we can improve the qualified immunity standard and have a really serious conversation about when law enforcement officers should or shouldn't be liable, and how we can kind of elevate the quality and also still provide protection to those who do put their lives on the line when they work as law enforcement officers. And so with that, I'll thank you for your attention. I'm happy to answer any questions you have.
Thank you very much, Senator Carney, for bringing this bill forward and presenting it to your committee. And I will now open it up to questions from committee members, beginning with Representative Gallagher-Reckitt.
Senator Carney, I, like you, was listening to the testimony all morning, and I wondered if the person who mentioned that I don't even remember whether it was a pro or con, who mentioned that they thought that corrections officers should be included as well as law enforcement officers in whatever the procedures ended up being. Have you thought about whether or not corrections officers would be a reasonable addition to your bill?
I haven't thought about it. I do think that it's something that should be really carefully vetted. I can see that that might very much be appropriate, but I didn't give it any forethought. And as I said, I think that this proposal needs more work and needs more thoughtful consideration, and that would be part of that process. Thanks.
Thank you.
Are there additional questions for the bill sponsor, Senator Carney, from members of the committee? Seeing none, thank you very much for presenting LD 1416. And I will now move to those persons who have registered to testify in support of LD 1416. And I will point out that I do have quite a few people on the list, but I think some people may have decided, may have touched on both bills in their original testimony. So I'm not certain we will hear from all that I have. But I will begin, and we will still use the 3-minute clock, which I will run. And I will begin by recognizing Mr. Cabetta from the ACLU of Maine. Welcome back to the Judiciary Committee, sir. And you can begin your 3-minute testimony whenever you're ready.
Thank you, Representative Harnett, distinguished members of the committee. Good morning, and thank you to Senator Carney for sponsoring this important piece of legislation. I'm Michael Capetta, Policy Counsel for the ACLU of Maine. And on behalf of our members, we urge you to vote that this bill ought to pass as amended. The abolishment of qualified immunity would restore faith in law enforcement by reaffirming the central principle that no one is above the law. The notion that where there is a right, there is a remedy was directly translated from the Massachusetts Constitution of 1780 into the Constitution of Maine when Maine became a state in 1820. As a result, Article 1, Section 19 of the Maine Declaration of Rights explicitly guarantees that every person shall have the right to redress when their rights have been violated. Qualified immunity works to undermine this right. In the words of United States Supreme Court Justice Sotomayor and the late Justice Ginsburg, the Supreme Court's, quote, one-sided approach to qualified immunity transforms the doctrine into an absolute shield for law enforcement officers, gutting the deterrent effects of the Fourth Amendment. The court's decision sends an alarming signal to law enforcement officers and the public. It tells officers that they can shoot first and think later. And it tells the public that palpably unreasonable conduct will go unpunished, end quote. That was from the 2018 case of Casella versus Hughes. Qualified immunity has repeatedly served to shield extremely harmful and unconstitutional behavior. Abolishing it is absolutely the right thing. Abolishing it in Colorado and New Mexico has not led to a rash of frivolous lawsuits there. With or without qualified immunity, frivolous litigation is illegal and unethical. It is in the inherent and statutory power of courts to sanction people who bring frivolous lawsuits. Nor has the abolition of qualified immunity led to an exodus of officers from the law enforcement profession in those states. If anything, it'll lead to an exodus of the bad apples we hear so much about. This bill would cap the personal liability of police officers who are found guilty of violating civilians' constitutional rights at $10,000. We believe that such a restriction is unnecessary and could create unjust outcomes. Consider, for example, the recent widely publicized trial of Derek Chauvin, the officer who killed George Floyd in Minnesota. Although he's been found guilty, Chauvin could still receive a pension of more than $1 million. Although pension forfeiture is extremely rare, capping liability at so low a number could deny justice to aggrieved families. And in any event, in almost every case, indemnification clauses in the contracts that unions negotiate for their police officers require the state to foot the bill and not police officers personally. We recommend that the committee amend the bill to remove the section limiting liability. And with that amendment, we urge you to vote to pass as amended. And I thank you for your time and attention, and I'm happy to try to answer questions.
Thank you very much, Mr. Cabetta. Appreciate your testimony, and I believe you submitted it in writing as well. Thank you for that. Are there questions from committee members for Mr. Cabetta? Seeing none, again, thank you for your time. I see you were optimistic when you drafted your testimony, starting with good morning. I've made that mistake regularly on this committee, but we appreciate your being here and always welcome your input. So thank you. I do have a few more people signed up as testifying in support, but I do not see them in the attendee room. So I would ask if they are there, if they could raise their electronic hand. Is there, I do see, okay. It's not on my list, but if we could move Lori Boxer-McCumber over to the panelists, that would be great. And Ms. Boxer-McCumber, proceed. Welcome back to the committee, and you may proceed with your 3-minute testimony as soon as you're ready to go.
Okay, I'm ready to go. Thank you, Representative Harnett and Senator Carney and members of the Judiciary Committee once again. I appreciate the opportunity to have a couple more minutes to extend some of the testimony previously offered. Many of the points that I was just about to raise were raised by the ACLU. I'm here testifying today as a resident of Portland and also as the president of the Maine Trial Lawyers Association. And we're testifying in favor of this legislation if it could be amended to remove the cap. We do not see a reason for having a cap in this legislation, particularly where victims shouldn't be forced to suffer the cost of the trauma that they suffer if there is an abuse of power by a law enforcement officer or anyone else. And so it seems illogical to put that type of a cap on this legislation, and I would love to hear more about why that was done. As we've heard from others, and as I reiterated before, in many of these cases, insurance contracts or employment contracts or union contracts are going to protect the individuals if they're acting in the scope and course of their employment, and often insurance companies will defend these individuals or pay settlements if the person is involved in litigation. And so some of the concerns that we heard the spouses of law enforcement officers expressing to this committee about going bankrupt or being personally exposed simply don't exist or are very minimal. And I think the academic studies that have been done on that support the fact that these families actually are not bearing the costs of litigation, whereas victims are regularly bearing the costs of bad acts against them. So it just seems like it's not a balanced piece of legislation when it has a cap. So we would like to see that removed. I do think it's interesting. There's been mention of a couple of other states that have adopted an elimination of qualified immunity. There aren't a ton that have done this. I know there are a number of states that are in the process of trying to eliminate qualified immunity, but we did hear earlier that there were problems in other states. And I would urge this committee to make sure that they actually do the research on that, because I don't believe we have enough data that's being in place from other states to actually make those statements. So it would be helpful if we all had solid data before such statements were relied on by the committee. The last point that I wanted to make was perhaps this committee may want to consider doing what others have suggested and actually broadening who it applies to, because in New Mexico, for example, the legislation actually applies to all government actors. And so that is something that perhaps this committee also wants to consider. Thank you.
Thank you very much, Ms. Boxer-McCumber. Am I correct that the testimony you submitted earlier on LD 214 also included a discussion of LD 1416? Is that right?
That is correct. And I believe I submitted it under both bills. So everyone should have received it for both LD 1416 and for 214.
It may be the system's not updating as quickly as we might like. We're using lots of technology these days.
Sure.
Thank you. Thank you very much for your testimony. I will now open it up to questions from committee members, beginning with Representative Moriarty.
Thank you, Mr. Chair. Attorney Boxer Maycumber, I wonder, in your experience, how frequently do liability insurers either decline to defend or decline to indemnify based upon a policy exclusion?
Well, my experience is that often defense liability insurers are defending, and that's been the default. That's my experience, but I admittedly do not do a lot of these types of cases. Most of my practice is with people who have been injured as the result of bicycle or pedestrian crashes.
I see. Okay, thank you.
Are there, excuse me, additional questions from committee members for Ms. Boxer Maycumber? Seeing none, I do have just a few. You
Sure.
said you were troubled by the $10,000 cap. Did you, and I may have missed this, did you have another number in mind, or did you think that it should not have a limit at all?
You know, in other situations, there are no caps for this type of egregious behavior. And so the question here is, why place a cap on someone? In fact, especially in a situation where someone has received all of the training and has had access to policies, and if they still are violating civil and constitutional rights, why should we actually limit it for that person? And I understand that the limit pertains to their personal liability, but if they are acting in that scope and course as well, or apart from their government position, there's no reason that they should be treated differently than anyone else in our view.
Thank you. And my other question, and I don't have your testimony in front of me, and I apologize, but I believe in it, you talked about the fact that we don't even consider qualified immunity until after it has been established that a constitutional right has been violated. Is that your understanding as well?
Correct. Yes, I think someone else mentioned that, but I would affirm that statement.
Okay. Thank you very much. Are there other questions from committee members? Seeing none, again, we thank you for your time and testimony this morning and this afternoon.
And I thank you for yours. Thank you.
And I believe we have another person who's indicated an interest in testifying in support of LD 1416. And I would recognize, welcome back, Catherine Martinez, to the afternoon session of the Judiciary Committee. And whenever you are set, you can begin your 3-minute testimony.
Hello again. So I didn't have plans to actually testify on behalf of this bill, but I just heard something that I'd like to correct on the record. The way qualified immunity works under the Supreme Court precedent is 2 steps. 1, you need to answer if it's a constitutional violation. 2nd step is whether the law is clearly established at the time. Each circuit has its own rules based on how they conduct their business in their circuit. The Supreme Court has actually decided that you no longer have to answer the first question of whether there is a constitutional violation. You can skip that step and you can go straight to determine whether there was a clearly established law or not. So in fact, what we're having is we're stalling civil rights precedents and the establishment of clearly established law. And it's a cycle of it's a cycle where if they're not clearly establishing the law because they don't have to answer whether there was a constitutional violation. So therefore the violations don't get clearly established. So it's not the case that first they have to go into whether there was a constitutional violation. The circuit courts are actually free to skip that step and go right ahead into determining whether the law was clearly established at the time, which is part of the issue and why we need to create a state remedy across all state legislatures to provide victims of police brutality with a viable path to justice. And that's what we can do here with either of these 2 bills, amending it so that it does include correctional officers. And so that's the end of my testimony. I just want to establish that.
Thank you very much, Ms. Martinez. There are at least one member of the committee that would like to ask you a question. Representative Thorne.
Thank you, Mr. Chair. And since having this morning had 2 messages left for me, one from Missouri and one from California, about what Representative Reckitt asked about including corrections officers. I was curious, Ms. Martinez, if you practice law in Maine?
I do not practice law in Maine. I'm a law school almost graduate, and I intend to practice civil rights litigation, but I'm the founder of the Ending Qualified Immunity Project. I have taken civil rights litigation, and I am well-versed on the clearly established rule and qualified immunity doctrine in general.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Are there additional questions for Ms. Martinez? Thank you very much. Thank you for being here today, and best of luck with the rest of your legal education.
Thank you very much, everyone, for allowing me to speak.
And I will check one more time. Are there any persons in the attendee room who wish to speak in support of LD 1416? Seeing none, I will now turn to those who have registered to testify in opposition. And my first person I will call is welcome back, Major Scott. And please begin your 3-minute testimony as soon as you're ready to go.
Thank you, sir. Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Major Brian Scott. I'm here today to testify on behalf of the Maine State Police and the Department of Public Safety in opposition to LD 1416. Maine law enforcement officers are amongst the best trained officers in America and work tirelessly around the clock 365 days a year, placing ourselves at great risk of injury or death to protect others in the performance of our duties. On average, 174 police officers are killed in the line of duty and another 56,504 are assaulted annually. We put on our uniforms and go to work each day, hoping to make a difference in the communities that we live in. We pray to make it through an entire career without having to take a life or lose our own. However, we do know that in order to uphold the law, we at times must use force to defend others or ourselves or to effect an arrest. Officers are not robots. We are human beings. We have weaknesses. We feel pain, fear, vulnerability, and we will make mistakes in determining exactly what course of action to take when we are thrust into perilous situations. We will bleed when we are cut. We will bruise when we are kicked or punched. And we will suffer from PTSD after seeing things no person should ever have to see. As humans, we will not be perfect and should not be expected to operate flawlessly in an incredibly stressful and dangerous situations. Even with the best training, no person can be expected to never make a mistake. However, the vast majority of the time, officers' actions are without doubt conducted with great professionalism and are error-free. There are thousands of times every day where interactions between the public and officers are conducted without any issues whatsoever. This bill would remove the protection of qualified immunity for police officers only, but not all of the other governmental entities that are also currently protected by qualified immunity. The ones that are most likely to need this protection are the only ones targeted by this bill. This seems quite unfair, especially when the bill removes the defense the defendant did not violate a clearly established statutory or constitutional right of which a reasonable person would have known. In other words, if a police officer unknowingly violates a statute or a constitutional right that is not clearly established, we can be sued for up to $10,000. As an example, several years ago, police officers in Maine were required by law to collect blood from every driver involved in a fatal crash in Maine with or without probable cause to determine their blood alcohol concentration. Recently, the Maine Law Court decided that law enforcement must have probable cause to require the driver to submit to the blood draw. Maine law enforcement immediately ceased the practice to ensure that we were not violating anyone's constitutional rights. If this bill were to pass, officers could be sued for up to $10,000 for every time they required a driver involved in a fatal crash to sit to a blood draw if the driver did not consent without probable cause prior to that ruling. This proposed limitation of qualified immunity is yet the latest attack on what is an honorable profession. The warranted protections provided by qualified immunity shouldn't be limited for all of our professional Maine law enforcement officers because of the actions of a relatively small number of terrible national examples. This is going to result in fewer officers on the job and those who stay too fearful to do their jobs. Maine will not be safer with fewer officers. As I stated earlier, officers are human beings and therefore will never be perfect. But if we work hard to do the job to the best of our ability, operate under our training, education, and experience along with departmental policies, we should be protected under the law for those very rare times when we make an honest mistake and do not perfectly execute our duties. For these reasons, I urge you to vote ought not to pass on LD 1416. Thank you for your time. Be happy to try and answer any questions.
Thank you very much, Major Scott. I will now turn to committee members for questions, beginning with Representative Thorne.
Thank you, Mr. Chair. Welcome back again, Major Scott. Thank you for your service and what you do for our state. I'm not sure if it was you that may have mentioned it earlier on 214, which ironically 214 is the DD form for discharge from the military. But how many times has qualified immunity been exercised, I guess? Are you aware of that on a police officer?
Good afternoon, Representative Thorne. Thank you for the question. I don't know. I don't collect those types of statistics at the Maine State Police, so I wouldn't know how many times officers have been sued and then later ended up with qualified immunity after summary judgment. I have no idea on that, sir.
Okay. Yeah, a follow-up statement, if I may, Mr. Chair.
A question or a statement?
Statement.
Briefly.
Most of my questions are brief, Mr. Chair. Thank you for reiterating.
I'm just reminding the committee members this is a public hearing. It's not a time for committee members to make statements, but go ahead, sir.
In respect to your position, I won't make my statement. Thank you, and we'll move on. Thank you, Major Scott.
Very welcome, sir. Thank you for the question.
Are there additional questions from committee members for Major Scott? Seeing none, thank you again for your testimony. Thank you for being here both this morning and the afternoon, and thank you for the service, your service to the people.
You're welcome. Thank you all.
I will now turn to Jared Mills. Welcome back, Chief Mills. I will start the clock when you begin your testimony after you've unmuted yourself and activated your video.
Thank you, Representative Harnett, Senator Carney, and distinguished members of the Judiciary Committee. My name is Jared Mills, and I'm providing testimony in opposition to LD 1416 on behalf of the Maine Chiefs of Police Association. In our testimony on LD 214, we explain why it is our position that the concept of qualified immunity should not simply be abandoned. This bill does not do that. We respect and appreciate Senator Carney's and Representative Morales' introduction of a measured approach to this complex matter. It is the Maine Chiefs of Police position that it is premature to establish in Maine law an alternative to the court-established concept of qualified immunity without a closer examination of that concept and possible alternatives. With respect to the particulars of LD 1416, it is not entirely clear to us the effect of the first criterion contained in the proposal 4686, subsection 1, subsection A on lines 8 and 9 of the bill. As an example, if the law enforcement officer puts a subject on notice that they will be handcuffed and taken into custody, if they do not cease and desist their offending activity, would that constitute a threat of violence that would cost the officer the benefit of the doubt in a court's decision whether to grant qualified immunity? Given that some degree of physical force may be employed in taking someone into custody, this is a reasonable question. It is because of these questions like this that we believe LD 1416 should not be given the committee's support at this time. Instead, we request that this bill be carried over to the second regular session, that in the meantime, some sort of study group be established to examine the implications of abandoning or modifying qualified immunity, and to come back to this committee with recommendations for further action. The Maine Chiefs of Police Association would welcome the opportunity to participate in such a study. Thank you for having me, and I'll entertain any questions.
Thank you very much, Chief Mills. The committee appreciates you spending so much time with us today. Are there, excuse me, questions from committee members for Chief Mills? Representative Poirier.
Thank you, Chair Harnett. Chief Mills, thank you very much for joining us again. My question basically is, we've previously had bills come through our committee that discuss having studies done to combat, possible racism within police force and biases, basically. And do you think seeing the results of those sorts of studies first before going forward with any bills like this would be useful before implementing a bill such as this one before us?
Thank you for the question, Representative Poirier. Yes, I do concur with that. I think I think we all agree, and you've heard testimony today, that we all agree that we need to affect positive change and move in the direction of the systemic issues that we're having and correcting those. But to do so with just eliminating certain things that we've had for years without a close analysis and looking at how we can improve certainly is I think, remiss at this point. You know, in my tenure as a police chief, I've been doing this for 23 years. When we deal with issues, when we deal with discipline, when we deal with correction or anything, a policy change, we don't just rush to judgment on something. We look at all angles of something on how we can improve regularly, you know, and that type of thing. So I would concur with that I would like to look at the overall, because even as a police chief, you know, qualified immunity is a very difficult subject to wrap your head around. You know, even your legal professionals who do this on a daily basis. So I think we all need to take a step, look at the entire qualified immunity and how we can move forward to improve.
Thank you.
Thank you very much, Representative Poirier, and thank you for your response, Chief Mills. Are there additional questions for Chief Mills? Seeing none, thank you very much for your time again this morning and this afternoon. Committee greatly appreciates your input and your willingness to work on these issues moving forward. I will now return to the list of persons that I have signed up to testify and that are in the attendee room. And the next person that I have is Sheriff Troy Morton. Welcome back, sir. And please begin your testimony as soon as you're ready.
Thank you, Representative. I appreciate it. Good to see you, and I appreciate all the hard work your entire committee is doing today. My name is Troy Morton. I am the Sheriff of Penobscot County and President of the Maine Sheriff's Association. Maine Sheriff's unanimous position is to oppose LD 1416, an act to eliminate qualified immunity for law enforcement officers in Maine. LD 1416 is personal. This bill targets law enforcement officers only. Many of you, as well as lawmakers and other committees, are friends with your police officers and sheriffs you represent. Not a day goes by that sheriffs aren't contacted for our positions on a bill while legislature is in session. We work closely with the Maine Chiefs of Police, Maine Department of Public Safety, Maine State Police, and other invested law enforcement partners. To take a moment and think of the chief of police in your community. Think of the officers who conduct checks on the elderly during the winter. Think of the sheriffs who come to each of you to find solutions for some of Maine's toughest issues. Who is the first in the line to demand better mental health resources? Law enforcement collective voice has been working tirelessly to address Maine's opiate crisis. Those faces, the officers and sheriffs you have relationships with, those are the people being most impacted by this legislation. Your respected friends and your colleagues. Many of you have been motivated by the events unfolding across the country. When you read the language of LD 1416, many of you are taken back to June of 2020 and the despicable actions of a former police officer, Derek Chauvin. As lawmakers, you feel compelled to use your position to ensure that there are no more George Floyds or Breonna Taylors. We stand with you in that endeavor. Police misconduct has no place in Maine. LD 1416 is not the answer you seek this session. We've made some important decisions on law enforcement accountability. We need to invest in those discussions and find solutions that meet the ongoing and real issues in Maine. LD 1416 targets the very allies that many of you call friends. Please recognize the wake of devastation this bill will leave and vote ought not to pass. I appreciate your time again, and I look forward to answering any questions that you might have. Representative Harnett, I do have an answer to Representative Poirier's question. I'm not sure if it was appropriate to answer now, though the bills are similar.
But no, that's fine, sir. You can answer that now. You mean the question from this morning regarding insurance?
Yes. And so quickly, we'll have much more in detail for the work session, but one of my detectives monitoring this morning quickly made 2 local phone calls to insurance carriers right here in the Bangor area and was told in both cases that there was no such insurance available to provide to cover that officer. independent insurance for the officer or their family. And so we look forward to trying to bring some of that to work session, and hopefully I answered your question.
Thank you very much, Sheriff Morton and Representative Poirier. Since it was your question, was that helpful?
Very much. Thank you.
You're very welcome. Committee members with questions, Representative Evangelos.
Thank you, Mr. Chair, and hello, Sheriff Morton. Sheriff Morton, I don't want anyone to be misled. Police departments do carry professional liability for their officers, do they not?
Right. The risk pool provides, as a government agency, and that's kind of our concern, if qualified immunity is to go away and the burden put back on the officer individually, there wouldn't be insurance for the officer or their family.
Well, no, qualified immunity, whether it's there or not, the insurance policy doesn't change. The insurance policy that you have is required to come to the defense of the officer. Isn't that correct?
Well, I don't want to dispute that. I'm not an insurance specialist, as you know, Sheriff, but the concern, Representative, and by the way, we greatly appreciate the discussion. I think that's the most important thing that occurs here today. But we are concerned that you are opening up these officers, their family, their livelihoods to lawsuits that come at different angles other than simply going after the insurance carrier or the risk, and in the case of sheriff's offices, the risk pool.
I think you should, for the work session, and I'll do the same on my end, but I think you should check on that because we've had these discussions around insurance on other issues, and the answer is always the same. The one that was the campground owners, the insurance policy is, and the insurance company is required as part of the stipulations in the policy to defend the officers.
Thank you, Representative. I believe that the risk pool has provided written testimony. If they haven't, I will make sure that they did. They do. That helps.
Thank you. Are there additional questions for Sheriff Morton from committee members? Seeing none, again, thank you very much for spending maybe more time than you wanted to today with the Judiciary Committee, but we always welcome your input, sir.
We appreciate important discussion. Thank you.
Okay, that ends the list of persons that I know who wanted to testify in opposition to LD 1416 that registered, but I will check again in the attendee room to see if there are any persons who wish to testify in opposition. And I do see a hand come up and I see somebody being moved over, perhaps. Okay. If we could move Shane Stevenson in as a panelist.
So,
welcome back, Officer Stevenson. And
thank you.
If I'm getting your title wrong, please correct me.
No, that's correct. Thank you.
And you are welcome to begin your 3-minute testimony as soon as you're ready to go.
So I'm constantly hearing that bad apples will be the ones that leave if qualified immunity is taken away. I can honestly tell you all that that is not going to be the case. You know, the things that we are doing in public is almost unimaginable for things to work out the way they do many times. I know for me personally, very recently, I've had 2 life and death situations that could have resulted bad, but by fortune, luck, or some other process, I was able to get through it all and successfully avoid a deadly force encounter or some sort of complication. Qualified immunity is something for officers to strive for. It's an incentive for people to do the right thing. If they do the right thing, then they qualify for immunity. I agree with Lori, what she testified to earlier. She thinks that we need to research how everything is going in all these other cities. I agree. This needs to be researched until it's passed, because I think it can be detrimental to what Maine is doing and the satisfaction rating among the people of the survey that was mentioned earlier in earlier testimony. Officers will be afraid to go above and beyond without protection of putting themselves out there. People are leaving the profession now to go mow lawns because the demand on us is becoming too great. Representative Poirier also asked if additional research is needed. And I agree that we should research this more. In regards to the personal insurance plans, these insurance policies cover representation, but sometimes that representation is one, the lowest bidder, and also it doesn't protect the person. Doctors and other professionals can carry professional liability insurance, and that professional liability insurance will cover them, so they're not going to be personally out of money. So I think these are very different things that we need to look at. This bill is extremely complex, and I think it's going to ruin law enforcement and the good things that we've done. And I'd like to be a part of the process to try to make things better in the state.
So thank you very much, Officer Stevenson, and we appreciate you taking the time out to testify before the committee both this morning and this afternoon. Are there questions from committee members for Officer Stevenson? Going to give another second. Seeing none, again, thank you for your time this afternoon and this morning. Greatly appreciate it.
Thank you.
Seeing no other persons with their hands up to testify in opposition to LD 1416, I will turn to those who registered to testify neither for nor against, and welcome back to the Judiciary Committee, Rebecca Graham from MMA. Ms. Graham, when you are ready to begin your 3-minute testimony, just unmute yourself, activate your camera, and have at it.
Thank you, Representative Harnett and Senator Carney. My name is Rebecca Graham, and I am testifying neither for nor against LD 1416 on behalf of MMA and at the behest of our 70-member Legislative Policy Committee. As I indicated in my earlier testimony in the last bill, municipal officials do want to work with our state partners and do better on partnership with reform. While there is a more balanced approach with LD 1416, the limits on personal liability are welcome. We support the Maine Chiefs of Police suggestion to take a deeper dive on these issues to better inform this committee and ultimately the public around something that is an extremely complex process that is being touted as a silver bullet, when in reality, it's going to divert fiscal resources away from investing in results-based reform. We also share the Maine Chiefs' concerns with regard to language under section 4686 and opening up the officer to liability for an alleged violation where the involved person is using a threat to physical force or violence against a person. Officials are concerned that that language and its possible interpretation of the legislation might be limiting personal liberty rather and unconditional movement and sometimes life is essentially a job requirement of law enforcement. The threat of physical force is a necessary element of everyday duties of law enforcement. So while the goal is all voluntary compliance, that threat of physical force and restraint is an element of every arrest and necessary to respond to protect life and property. So officials don't want our officers to second guess using that threat of physical force to detain an individual when responding to a domestic assault or a bar fight or removing an individual from a business presence or residence. Not all police are represented by unions, and there is a risk pool for police officers. And as you have heard, they are unable to obtain private insurance. So we do think this is one of the areas that needs a deep dive in its intersection with tort claims. And also creating a two-path process between state violations and federal violations will certainly enrich and trial lawyers, but it might leave genuine violations a greater challenge to pursue for an individual and twice as costly for communities. So we would like to continue to work with the committee and stakeholders on this process. And if you choose to carry this over, as has been suggested by the Maine Chiefs of Police, we'd be happy to work with you on that as well. And with that, I'll entertain any questions.
Thank you very much, Ms. Graham. We appreciate your time and testimony on both bills today. Are there questions from committee members for Ms. Graham? Seeing none, again, thank you very much for your time and for the testimony that you submitted. We appreciate your effort. So I will take one more look at the attendee room to ask if there are any persons in attendance who wish to testify in support of LD 1416. Please raise your hand. Seeing none, I would ask if there are any persons in attendance who wish to speak in opposition to LD 1416 to please raise your electronic hand. And seeing none, finally, I would ask if there are any persons in attendance who wish to testify neither for nor against LD 1416 to please raise your electronic hand. And seeing none, I want to thank all those who came to testify on this bill this afternoon, and having received testimony of those present today who wish to present, I will now close the public hearing on LD 1416. And with that, I will return the virtual gavel to my co-chair, Senator Carney, and I will have to deactivate my video for a while, but I will be back shortly. And thank you again.
Thank you very much, Chair Harnett. And I'm just going to mute you. I muted you as well, Representative Harnett. Good afternoon, everybody. We're going to begin our series of work sessions, and I think that our analysts put into the chat the order in which we are going to take up the bills. And our first one is LD 879. And Peggy, thank you for joining us or appearing. I know you're here all the time listening. Could you please, let's see, so we'll open the work session on LD 879. And for those who are in the attendee list, typically we will ask the bill sponsor to join the panel. But for others who have joined us and are in the attendee space, we'll actually only invite you to join the panel if we have specific questions for you. And so LD 879 is, and I'm changing gears here, so give me just a moment. LD 879 is Senator Kimes' bill, and she is already on the panel. Did you wish to speak, Senator Kimes? Okay. So Peggy, if you would like to give us kind of a top level bill analysis, and then we can do a deeper dive, please.
Yes, thank you. So this bill amends the Human Rights Act. It actually amends the definition of unlawful discrimination. In the definition section, it says unlawful discrimination includes, and this is paragraph G of that subsection 10, and it says discrimination in employment, housing, public accommodations, credit, educational opportunity on the basis of sexual orientation or gender identity, except that a religious corporation, association, or organization, under current law it says, that does not receive public funds is exempt from this provision with respect to employment, housing, and educational opportunity. And what Senator Kimes' bill would do is strike out that qualification that the exception for a religious corporation, association, or organization in those instances wouldn't be limited to ones that do not receive public funds. So if there's a religious organization that receives some sort of federal grants or municipal grants, or some kind of is involved in some kind of government program, they would not lose their ability to make employment, housing, and educational choices based on the affiliation with the religion. They can make those or on the basis of sexual orientation or gender identity. In those three areas, as long as they're focused on their religious activities, I believe. So that's what her bill would do, is take out that limitation. So it would mean that a religious corporation, association, or organization would not be violating the Human Rights Act if they made choices on the basis of sexual orientation or gender identity in employment, housing, and educational opportunity, that when those are functions are of the religious organization.
Thank you, Peggy. Committee members, are there any? Well, first of all, Senator Kimes, do you wish to be heard on this, to speak with us about the bill before we move into questions of Peggy?
No, I don't. I think I shared everything in the public hearing. Thank you.
Great, thanks. Okay, committee members, are there questions for Peggy? Not seeing any questions. Committee members, are we ready to vote on this bill? Oh, go ahead, Representative Libby.
Thank you, Madam Chair. I would like to move ought to pass.
We have an ought to pass motion. Is there a second? Seconded by Representative Poirier. Any discussion on the motion? Not seeing any. All right, the committee is ready for the vote. Thank you very much, Ms. Panett.
Thank you, Madam Chair. Senator Carney.
No.
Senator Carney votes no. Senator Sanborn. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
No.
Thank you. Representative Harnett votes no. Representative Babbage.
No.
Representative Babbage votes no. Representative Galgay-Reckitt.
No.
Representative Galgay-Reckitt votes no. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
No.
Representative Sheehan votes no. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos. Representative Newell.
No.
Representative Newell votes no. I will call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Representative Evangelos. Representative Evangelos is absent. Sorry. Madam Chair, I have 4 members voting in the affirmative, 7 members voting in the negative, and 3 members are absent.
Thank you very much, Ms. Panett. And for those who voted no on the motion, the report is ought not to pass. Representative Harnett?
You took the words right out of my mouth, Madam
Trying to
Chair.
get better at remembering that.
Thank you.
Thank you. And with that, the motion, the votes on LD 879 are 7 ought not to pass, 4 ought to pass, and 3 absences. And with that, we'll close the work session on 879 and move on and open the work session on LD 982, an act to protect against discrimination by public entities. And I just want to give everyone a status report on this, I believe, and Peggy, you can correct me if I'm wrong, but we were waiting for some amended language on that. And has that arrived?
I do not have amended language. I hadn't actually seen anything official that there were folks who were working on this. It's amending the public accommodations chapter, and I think that there was a concern that that wasn't really the right way to address this question.
That was my
understanding. And I don't have an amendment, sorry.
Okay, so I think at this point, it makes sense to table this matter until we actually have the sponsor's proposed amendment, so that we're not taking up time that we don't need to spend. And so, Representative Sheehan, do you have a motion?
Yes, I move to table in light of this.
Senator Kime? No. Is there a second on the motion to table? Seconded by Representative Harnett. And we'll move on to the vote on the motion to table.
Excuse me, do you want to call the roll, or are you just going to raise your hands on a table?
We can try raising our hands. Let's use our electronic hands and let Ms. Panett register it that way.
Got 8. And 8 with, oops, it's changing.
Wait a minute.
Can we just quickly do a roll call, please? Because I think that's very confusing the way we were doing it.
I'm happy to do so, Madam Chair.
Thank you so much.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime.
Sorry, no.
Senator Kime votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Representative Evangelos. Representative Evangelos is absent. Madam Chair, I have 7 members voting in the affirmative, 4 members in the negative, and 3 members are absent.
Thank you very much, Ms. Panett. So the tabling motion carries. So LD 982 is tabled. We'll close the work session on 982, move on to our work session on 1180. This is an act to prohibit discrimination in housing based on a person's participation in a rental assistance program. And Peggy, if you could please give us the top line analysis, and then we can do a deeper dive as necessary.
Yes, thank you. So this bill adds a new subsection to what's considered housing discrimination and is therefore prohibited under the Human Rights Act. And it's for anybody who is renting or selling housing to refuse to rent or negotiate for rent because the person's source of income is public assistance program, or because of the requirements of any program providing the source of income, or refuse to participate in or comply with any federal, state, or local requirements of a tenant-based rental assistance program. And it's worded that way about the requirements because currently it is illegal housing discrimination for a decision to be based on because the individual is a recipient of federal, state, or local public assistance. But the law court has gone back to look at like the original application section of the Human Rights Act to talk about business necessity, and that a business would not have to comply with limitations in the act if it was consistent with business necessity to not go along with those things. And there was a law court case that said the burden on housing providers to comply with all the requirements of different housing assistance programs made it a legitimate business necessity to avoid renting in those situations where it could. They housing owner could choose not to rent based on that reason. So the language of this bill is intended to overcome that interpretation of the existing law.
Thank you very much. Committee members, are there questions for Peggy? I'm not seeing any. I had a question for you. Oh, there's a couple committee member questions. We'll start with those. Representative Libby?
I actually don't have a question. I have a motion, but I'd be fine with letting questions proceed first.
Okay, thank you. Representative Reckitt? Oh, we can't hear you.
I was saying I had the same statement as Representative Libby, so she's welcome to go first.
Okay, so let's go back to you, Representative Libby. You may make your motion.
Thank you very much. I move ought not to pass.
And is there a second? Senator Keim seconds. Any discussion on the motion? I have a question that I would like to ask you, Peggy. Could you please review for us what the Maine Human Rights Commission testimony was on this bill?
I believe the commission testified in favor. Let me look through my pile real quick. It's not really organized.
That's all right. And I'm also wondering if the commission had proposed any amendment.
I did not note an amendment. I know that the commission counsel is in the attendee room if you have a question.
Okay, I think what I'll do is bring the commission counsel over to the panel just to answer that question. I think I might be misremembering, and I just wanted that clarification. So Ms. Archer-Hirsch, I'm going to bring you over for the purpose of answering that specific question. And we are, there's something, I think, blocking your video, Ms. Archer-Hirsch. Maybe another computer screen. Ah, there you go. Thank you for joining us. I think I'm probably misremembering, but did the commission propose any amendment to LD 1180?
We did not, and we did testify in favor.
All right. Thank you very much.
My pleasure. Thank you for having me.
Thank you for being there.
Any other? Okay, I'm going to return you back to the attendee list. Any other discussion before we move on to a vote on the ought not to pass motion? Representative Libby?
Thank you. I do wish to speak to my motion, so I will do that now. We already have a housing crisis here in Maine. We've heard all about that. And this is not, in my opinion, the way to fix it. We've heard extensive testimony against this bill. And I think it shows clearly that this will increase the housing crisis rather than decrease it. If landlords don't want to participate in the program, they should not be mandated to. This solution is looking to fix a government problem by mandating that private businesses participate. It's an incredibly lazy way to attempt to bolster up a government program that needs a fix through mandating private business participation rather than actually fixing the program. And I will be voting ought not to pass.
Thank you, Representative Libby. Committee members, is there any other discussion before we move on to the vote? Not seeing any. And Ms. Panett, I think we're ready for the vote. And this is on the Representative Libby's ought not to pass motion. and which was seconded by Senator Kime.
Thank you, Madam Chair. Senator Carney.
No.
Senator Carney votes no. Senator Sanborn. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
No.
Representative Harnett votes no. Representative Babbage.
No.
Representative Babbage votes no. Representative Galgay-Reckett.
No.
Representative Galgay-Reckett votes no. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
No.
Representative Sheehan votes no. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell. I will call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 4 members voting in the affirmative, 7 members voting in the negative, and 3 members are absent.
Thank you very much, Ms. Panett. And for those who voted no, the report would be ought to pass. And is that correct, everybody who voted no?
Yes.
That's our report. Okay. Thank you very much, Ms. Panett.
Thank you.
And that closes the work session on 1180. And we'll open the work session on LD 1294, an act to prevent discrimination against domestic violence victims. And Peggy, if you could again give us the analysis, and then we'll see if the bill sponsor wishes to be heard as well.
Thank you. So this bill amends the Human Rights Act in 2 subchapters, one on housing discrimination and one on employment discrimination. And it adds in the status basically of the either, so the first section is employment. So either the applicant for employment or later on the employee herself or himself, because the applicant sought and received an order of protection from abuse under Title 19A, Chapter 101. So that would kind of classify that as a status in an employer or a labor union or a hiring entity would not be able to discriminate against a person based on the fact that they have sought and received a protection from abuse order. So that applies in the employment context. And then starting in, I believe it's section 3, section 2 would be in the unlawful housing discrimination. So the same thing, somebody offering housing or once housing has already been secured, they would not be able to discriminate against somebody, take any kind of action because the person had sought and received an order of protection from abuse under Title 19A. It's the same language repeated over and over and over. This kind of status based on activity is rather than religion or gender is parallel to that for a person who has filed a workers' comp claim or is protected under the Whistleblowers Protection Act. So those are also kind of protection for an activity that somebody engaged in that this law already protects.
Thank you very much. And was there a suggested amendment relating to it being a think a final protective order, perhaps?
You had different suggestions. I know that some people, I think the commission did recommend that it be limited to a final order of protection as opposed to an ex parte order, to make sure that there was an opportunity for a hearing in that situation. I'm not saying that the landlord or the employer would be the defendant in these cases, but that there would have been an opportunity for a full hearing on the claims, and the order was then issued. So there was that suggestion. There were some other folks who said it shouldn't be based on having a protection from abuse order at all. But the commission thought it would be clarifying to say it was a final protection order. And we would do that by cross-referencing the specific section of 19A as opposed to the chapter.
Thank you. And just to reiterate, so the final protection order that the protection under the Human Rights Act would be connected to would be an order that had not just the preliminary hearing, but the final hearing where all of the parties to that protective order could be heard.
Right, that there would be an opportunity for such hearing, yes.
Yep, okay, thank you. Representative Harnett?
Thank you, Madam Chair, and this is for Peggy as well. I believe there was a second suggested amendment from the Maine Human Rights Commission that the relief only be available to plaintiffs in PFA cases and not to respondents when there are sometimes issues when there are mutual orders of protection that are issued. Is that correct?
That is correct. And I'm trying to remember the exact ability of a court to issue a mutual order of protection. I'm thinking that that's no longer permitted, but
I think that. Yeah, I think that's correct. If it's a protection from abuse order, it can't be mutual.
I do think that is something that the commission had recommended, and that law was changed so there you can't have a mutual order of protection.
Okay, thank you. Thank you very much. So the Second Amendment is not needed. Is basically.
I will double check, but yes, I think that's correct.
Okay, thank you.
I don't know whose hand was up next. Representative Sheehan or Senator Keim? Do either of you, whoever was first, please speak.
I think I was first.
Okay.
I just, after hearing about the two amendments, I would like to make a motion ought to pass as amended the First Amendment. Sorry.
Thank you. So the First Amendment relating to the order being a final order. Thank you. Is there a second on that motion? Seconded by Representative Harnett. Senator Keim?
Thank you. We heard testimony in opposition from the Maine State Chamber, and I was wondering if they were here and could speak to the amendment.
Is there somebody in particular who you?
Well, it was Peter Gore who actually submitted testimony.
And I am not familiar with everybody who might be representing the Maine State Chamber. Can you take Mr. Gore is not in the
Right.
attendee list. Are you able to access that attendee list, Senator Keim?
Yes, and I don't see anyone there from the chamber that I recognize.
Okay, all righty. Let's just ask the bill sponsor for her reaction to the proposed amendment as well. Welcome, Senator Bailey.
Thank you. Thank you, Madam Chair. I am fine with the proposed amendment to make it a final order. Thank you.
Yeah, thank you very much. Representative Sheehan, your hand is still up. Did you have another question? Okay. Representative Libby?
Thank you, Madam Chair. I'm trying to figure out, I haven't seen the amendment yet. Is that the piece at the end of the analysis? No, that's current law. Where is the amendment that I can access that?
That isn't drafted yet, but the way, no.
Okay, I thought I was missing
what we would do
something.
is, no problem. Instead of saying Title 19A, Chapter 101, we would say Title 19A, Section 4007. Because
okay, so it moves where this is?
Right. Instead of saying any order issued under that whole protection from abuse chapter,
changes that.
Focus it to just Section 4007 because that's the final order. The temporary orders are issued under Section 4006.
Only final order. Okay, and then I have less of a question and more discussion. I understand the intent of this bill, and I think it's extremely well intended. My concerns more lie in, we had a bill, and I realize this is a completely different type of bill, but we had a bill that was going to add disclosing pests as a requirement on a real estate disclosure. And the reason that I think we unanimously didn't support it was that the concern was a couple-fold, and I think those apply for me here. One, that by starting to add things to the list, it might make folks think that things that aren't specifically on the list are then excused. And I don't want to see any form of discrimination excused because it's not listed. And so that is one concern that I have, that as we get more specific, it actually excuses other discrimination or is seen to. And my other concern is that I wonder if it is the actual, and maybe other folks could lend some help to help me understand this. Is it the order itself that folks are perhaps being discriminated against? Or is it the circumstances surrounding the order? Is it the fact that someone with an order might have undergone economic abuse and might not have a stellar credit score or something like that? I just am wondering if there's some nuance there, and if anyone else has these same types of questions.
Go ahead, Representative Rackett.
I understand your concern, Representative Libby, but I don't believe economic abuse is an issue that would arise in a final protective order in the same kind of way that the risk of continued abuse might be. I think that I just don't think it's going to expand in that kind of way. At least I've never seen it expand in that kind of way. So I think that the concern is really that if someone is trying desperately to find a place to live, and they would not necessarily on an application for rental disclose the information that they had a protective order. I'd never seen a rental agreement that asked that question. But somebody I could see a time when a respondent in a protective order might endeavor to have the person against whom they have done wrong. They might want to keep them from getting an apartment, and they might disclose to a landlord in order to try to keep them in their power. I mean, I have watched that happen with people trying to establish a new life, that people would try to undermine that possibility. And I think that's what this is trying to prevent, is someone who is literally trying to start a new life in a new place doesn't get undermined by innuendos or actuality that they had a protective order at some point.
Yeah, I would just like to add that you had said, Representative Libby, something about, types of discrimination that are not listed in the Human Rights Act being kind of excused if we add too many things to the list. And the way the Human Rights Act functions is that only those things that are listed are protected. And so it doesn't present that kind of danger because there are lots of reasons that you can legally discriminate against somebody. It's just if it's listed in the Human Rights Act, then those are the narrow set of reasons why you couldn't discriminate against someone. And I think that this is a really important piece of legislation. I think it's very similar to the two anti-retaliation protections in the main Human Rights Act. And as Representative Reckett said, I think it helps people who are trying to start a new life free of a situation that's really personally dangerous to them, that this legislation helps them start that new life. See a couple of other hands up. Senator Keim.
Thank you. One of the issues brought up by but in Peter Gore's testimony was the question of how long the status of the recipient being, having got a order of protection, how long does that last? So if you ever get a court order for protection, you then become part of the protected class for the next year, the next 5 years, the next 25 years. How long does this put you in a protected class? Does anyone have an answer to that?
I do, if you.
Yeah, and I can
basically the order is used to be 1 year. Then the orders were extended so that many were 2 years. And after that, you have to go back to court to extend it. And it's very unusual for them to be extended. I think I've only heard of one lifetime protective order ever. So, and I think it's likely to be maybe 2 years would be a safe bet.
But this language, just to maybe clarify my question a little bit, this language just says, a person who has sought and received an order. So it doesn't say it has to be a current order or that they still have to have one. It just says they've sought one and received it.
I think the limitation happens in a different way, Senator Keim, because it prevents somebody from being denied a job or housing specifically because they've received a protective order. And so it's not like somebody who has received a protective order has this kind of lifetime shield. It's just that can't be the motivation for denying somebody of a job or denying them of housing. And so
but it is a lifetime shield at that point.
Well, only if the prospective employer knows about the protective order and bases the decision on that order. And,
right, but it's lifetime, I guess, after that. It is lifetime.
Probably so. I mean, we probably don't want people to not get jobs because 50 years ago they had to get a protection order from a court. I mean, I guess that's where I would come down on that one. But yeah, I guess if in that extreme situation where somebody knew about it decades later, yeah, I think it would apply. Representative Reckett?
No, sorry, I'm a slow hand lower, sorry.
That's okay. Any additional questions or discussion? Are we ready for the vote?
Sure.
Thank you, Ms. Panett.
Madam Chair.
Actually, yes, we do have a motion. I just didn't write it down. So we had a motion by Representative Sheehan ought to pass as amended with reference to the specific section so that it would only apply extend protection to somebody who gets a final protection from abuse order. And it was seconded by Representative Harnett. Okay, thank you.
Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 7 members voting in the affirmative, 4 members voting in the negative, and 3 members are absent.
Thank you very much, Ms. Panett. For those who voted no, could you please let us know what your report is?
Ought not to pass.
Thank you very much. And with that, do you need any additional information, Supi, on that one? Okay. With that, we'll bring the work session on 1294 to a close and open the work session on the last bill that we were supposed to have a work session on Tuesday, and that's LD 1374, an act to extend the time period for filing a complaint under the Maine Human Rights Act for discrimination based on an alleged sexual act, sexual contact, or sexual touching. And Peggy, we are ready for you when you're ready for us.
Well, thank you. You just described the bill basically. So under current law, if somebody wants to file a complaint with a complaint of discrimination with the Human Rights Commission, they have to file it not more than 300 days after the alleged act of unlawful discrimination. This would extend that to 2 years in only the cases where the complaint is based on an alleged sexual act, sexual contact, or sexual touching. So it would give them 2 years after the act, contact, or touching happened.
Representative Libby?
Thank you, Madam Chair. Peggy, a quick question was trying to figure out the timeline on this. So is this, I'm trying to figure out how things fit together with civil and criminal in this case. So if there was sexual contact or sexual touching or whatever case may be, and it were handled in a criminal matter, obviously that can take some time. So would this statute of limitations be affected by that? As in, if there were a criminal matter and it took 1.5 years to resolve with that person, then the statute of limitations would be up and they couldn't take any civil action. That's what I'm trying to figure out. If a delayed criminal case, if it were taken up, would delay.
Right. My understanding that the fact that there is a criminal case pending or whatever would not affect the running of this statute of limitations. This is really the first step is to resolve what the problem is, and they try to do a lot of conciliation, and so people can continue their relationships without the discrimination. And if that's not resolved, then there can be a civil suit That's after either the Human Rights Commission finds reasonable grounds, or if they don't reach that, then somebody can go ahead for, and in that case, it would probably be damages and maybe injunctive relief, as opposed to a criminal case, which would be a separate prosecution and would be by the state, ending up with, you know, some kind of criminal penalties.
So this complaint, this discrimination complaint, could be ongoing simultaneously with potentially criminal and civil, and this discrimination complaint could all be going on at the same time. Is that correct?
I don't know of a reason why that couldn't happen. I mean, I don't know what, you know, depending on the class of crime that those acts would be, the statute of limitations it varies.
Okay.
Right. And I don't know if the commission has ever run into cases before where the act of discrimination is also a crime, and that they were dealing with that.
Okay. Thank you.
Representative Moriarty?
Thank you, Madam Chair. So Peggy, just to clarify my understanding, the two statutes of limitations would run simultaneously, and one statute of limitations would not delay or suspend the other.
I don't believe there's any kind of, they call it tolling, when you stop the running of a statute of limitations based on the fact that there is a criminal case pending, or that there was, in a criminal case, that there's a human rights complaint pending. I don't think either one of those tolls the statute of limitations in the other case.
Good, thanks.
Senator Kine?
Thank you. One of the issues I want to bring up is that by extending this and then looking at the Human Rights Commission ability to, you know, they're given a couple of years to investigate things as well. So we could be looking at the human rights, asking the commission to look into details that could be as long as 4 years earlier than the alleged action. They could be looking back 4 years, and given the deterioration in memory of people, so the deterioration of evidence, basically, I just find that this is going to be really difficult for the person that's accused, difficult for the commission as well, but for everybody to just even prove that they're not, you know, to prove that they're innocent with this. So I just feel like this is opening something up, probably more than people have memory to back up is the problem here.
I would, Representative Reckett, I'm going to kind of jump the line here if you don't mind, but I kind of share your concern, Senator Kine, because I think one of the big policies underlying the Maine Human Rights Act is to try to get issues reported and dealt with through the administrative process quickly, so that people, you know, people who are subject to sexual harassment in the workplace, for example, get a quick remedy, and that it's really, that's kind of part of the framework of the Human Rights Act. And so I think I appreciate kind of the concerns raised by the bill sponsor, but I also think that that this change would impact the functioning of the Human Rights Act in a lot of ways that maybe don't achieve the benefit that's intended. Representative Reckett?
I'd like to move ought not to pass.
Is there a second? Seconded by Senator Kime. Is there any more discussion, committee members? I am not seeing any. Ms. Panett, I think we're ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Excuse me. Senator Sanborn. Senator Sanborn is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent.
Thank you. Thank you very much, Ms. Panett. So the ought not to pass motion carries, and that finishes the work session on 1374. And we can move on to the remainder of our work sessions that were originally scheduled to start at 1 o'clock today. I feel like we're making progress, everyone. And so we are going to, let's see, I just want to kind of refresh myself. Peggy or Soupy, do you remember if there was any bill that we needed to take first for various reasons this afternoon on this list? No? Okay.
I don't think so. I know Representative Warren was not going to be available until probably after 3. Yeah, so you're good.
Okay.
She just didn't want you to take it up earlier.
Okay, so let's move forward then with LD 54. And this is our colleague Representative Evangelos's bill, an act to amend the laws governing post-conviction review in order to facilitate the fair hearing of all newly discovered evidence.
Right, so this bill, if you were on the committee last year, looks like a repeat of the committee amendment. It amends the post-conviction review law to provide that there is no deadline for a defendant to file for post-conviction review if a claim is based on newly discovered evidence. Regardless of when the newly discovered evidence could have been obtained or discovered through the exercise of due diligence. So that's a big change from the current law. This also allows the court, allows the court to require the petitioner to provide additional information about the nature of the newly discovered evidence. That's intended to eliminate frivolous claims that somebody might bring up that really don't go to the heart of the case. The fact that a petition initiated pursuant to the old statute was dismissed as untimely filed or for the failure to exercise due diligence does not preclude the initiation of a petition for review under this subsection based on the same or different newly discovered evidence. So that what that is saying is, since the current law has a time period for newly discovered evidence to be brought forward, and the question was whether there was due diligence, could it have been discovered earlier? Some claims have been rejected and never got to the point of being reviewed. This would say this law allows those to be brought forward again. They'd still have to go through this process, but the fact that they had been brought up and dismissed as not being timely filed does not mean they couldn't be brought up for the substantive reasons now.
Thank you very much. Committee members, are there questions for Peggy? Go ahead, Representative Moriarty.
Thank you, Madam Chair. Peggy, I believe we have an amendment from Senator Kime.
you do have an amendment from Senator Keim, and I'm sure she will speak to that. This was actually her minority report last year. So this language has been around, and I can speak to it, or she can speak to
it. Go ahead, Peggy, sure.
Right, so if you don't have it, I can share the screen. Does everybody have it? Yeah. It's adding one more sentence in there that says the court may summarily dismiss the petition if it determines that the petitioner has not made a prima facie showing that the new evidence was material and would have affected the jury's verdict. So that follows if the court requires the petitioner to kind of explain what this claim is about. And if the court decides that there's not really a case there to go forward, a prima facie case is not a significant amount of information to put forward, that the court can dismiss it. I think that might be what is intended anyway, by allowing the court to require information in whenever the court thinks it's necessary. And this gives the court the ability, it clearly says the court can say, no, you're not going forward with this.
Yep, thank you. Committee members, are there, Senator Keim, Representative Evangelos, I know your hand has been up. Since we're on the amendment, we'll hear from Senator Keim and then we'll hear from you. Go ahead, Senator Keim.
Sorry, I actually don't mind waiting till after Representative Evangelos. Yes, so I do think that the change in this bill and considering this bill is important, and as a lot of you recognize, we did talk about this last session, and this was the minority report. I just think in some way we need to limit how much of this is brought forth, and this was an attempt to sort of make sure that we're being careful of court time, and that the issues that are brought forward have merit in a way that would limit the expenditure of time. I asked Stephanie Anderson if she could speak to us regarding this bill. She was the district attorney of Cumberland County for a great number of years and has sort of real expertise that I think would be helpful to this committee. And so I had asked if she could join us just to share a couple of perspectives on this with the committee, with the chair's permission. Thank you.
Thank you. I think that is fine. I would very much like to hear from Representative Evangelos first. And I actually also had a question for you, Senator Keim. The language that you're proposing, did that come from a representative of the judicial branch? And the reason I'm asking is because I had originally kind of envisioned that sentence about the court requiring additional information was something that gave the court enough leeway to create its own legal standards and process. And it sounds like the language you're proposing is sort of limiting the direction that the court would go in and creating a standard instead of letting the court do that. And so can you just give a little bit more information about where your language came from?
Yeah, absolutely. Well, yeah, so it was last session, and it was just in discussion with the Attorney General's office, actually, with me saying, I think this is really important, and how do we put in some language to make sure that it's safeguarded in some way around what could be just a huge amount of resources looking at all the cases. So it did not come from the courts, and I think it would be good to hear from them with that concern, because I think that's a valid question to ask.
Yeah, thank you. Go ahead, Representative Evangelos.
Thank you, Madam Chair. We've been working on this bill for 2 years, and the committee report was 9-2, with 2 not voting in the previous legislature. We did compromise with some of the people that had concerns, and with the assistance of Chair Carpenter, we added a sentence, the court may require the petitioner to provide additional information about the nature of the newly discovered evidence. So this is left already up to the judge. And this committee has heard overwhelming evidence regarding deficiencies in our criminal justice and defense systems. The likelihood that we have innocent people sitting in prison because they can't bring evidence forward, and because the prosecution claims that their first lawyer should have brought information forward and didn't. I mean, those are not adequate reasons to keep somebody in a cage. We want evidence heard. We do it for the cold case homicide squad. We don't put any limits on anything, and I don't think we should. But as Mr. McKee made clear, we shouldn't have a time limit on this either, because otherwise we end up with people sitting in prison. Now, the irony was, pleasant irony in this case, that 3 days before this bill was heard, we had the classic case of the Supreme Court coming out with a decision saying that the defendant would have prevailed in a case if he had been allowed to provide evidence, but he wasn't. And he ended up serving 3 years in prison because he wasn't able to get the evidence in front of a court. So with that all said, I'm going to get a motion out to pass. We've worked 2 years on this. We've heard overwhelming evidence, and I think we should vote on it. And if the minority members aren't comfortable with it, they can just vote on the minority report. But Senator Kine, we already have language in there. We tried to compromise and brought that language in. And I think Mr. McKee made a compelling case. So my motion is ought to pass.
Is there a second on the ought to pass motion? Seconded by Representative Babbage. Committee, is there a committee discussion? I have some discussion. Senator Kime, do you feel that if we were able to vet the benefits of to pose the question to the judicial branch as to whether the standard that's currently in the bill or the language that you propose is preferable to facilitating appropriate judicial review? Are you prepared to support this legislation? Because I do think that if we can report it out of committee with a unanimous committee report, it will go, the path of the bill through the legislature is much more assured. And I agree with you, Representative Evangelos, that the policy is really important. I just would I would like the bill to have its best chance at getting enacted. What do you think, Senator Kime?
I would like to hear from the judicial branch on the language of the two. And because I think the idea is, can they summarily dismiss? So yes, I would like to hear from them on that language. I'm fine with doing an ought to pass as amended today if we're wanting to just move this quickly. I don't know if there's someone here that can speak to this. But again, I will just mention that I was hoping to hear from Stephanie Anderson with the chair's permission.
Okay, if you can just ask her one question, because I know that Representative Evangelos also does have time constraints this afternoon, and we have another bill of his to do a work session on, and maybe I will multitask and see if I can reach out to someone at the in the judicial branch. So let me bring Ms. Anderson in, and you may ask her the question. Representative Harnett?
I would be happy to reach out to Julie Finn if that would help you to continue to chair.
That would be very helpful. Thank you so much. And Ms. Anderson, you have appeared on our screen. It's nice to see you again.
Thank you. Thank you. Can you hear me okay?
We can. Senator Keim has a question for you.
Okay. Thank you, Senator.
Thank you for joining us, Ms. Anderson. I was wondering if you could just speak to your experience and, what this would look like in terms of resources. And we talked about the courts being able to summarily dismiss something if it doesn't look like it has merit. So I just wondered if you could just speak to that based on your experience.
Sure, I'd be happy to. Thank you for the question. Well, these cases are very labor intensive. I think you heard testimony from Ms. Finn from the judicial branch that they do about 100 a year, if my recollection is correct. If this is opened up to everyone for any time length, people who have already submitted petitions before, it will be, at least initially, a very large burden on the court. These hearings also take a lot of time from prosecutors and from defense attorneys. And I think this bill, if I may, it ought to also be, you should consider it in tandem with 1273, which is the bill I believe you're taking up next, because the impact on post-conviction review and whether or not you open them up to more cases might have an impact. It might inform your analysis on 1273. Post-conviction review is designed for errors that occurred outside of the court, errors that occurred through ineffective assistance of counsel. Now, some types of newly discovered evidence already don't have a time limit. They don't have the 1 year. That's evidence based on DNA. That can be brought at any time. So I don't know if that answered your question. One thing you might consider doing is changing it from 1 year to a certain number of years, like 5. That would, that would reduce somewhat the fiscal impact that this bill would have. I mean, and it also, this was mentioned before in testimony that there is a policy.
Ms. Anderson, I apologize for interrupting. This is a work session, and so we're really trying to kind of hone in on this one sentence. And we appreciate you making other suggestions, but we're really working here toward answering one very specific issue to see if we can all come on board on this legislation. Thank you so much for being here today.
You're very welcome. Thank you.
Thank you.
Let's see. I think we have not yet heard from Representative Harnett. Representative Evangelos, your hand is raised. Would you like to speak with the committee?
I do want to speak with the committee, but let's hear from Representative Harnett, and then you can recognize me. Or whatever order you want to take.
Oh, here he has magically appeared.
Right, and I'm trying to get a link to Julie Finn so she can join us.
Oh, thank
it
you.
must have been up just residual.
Okay, committee members, this will just take a moment.
Well, may I speak then?
Yes, go ahead.
I do remember Julie's had some concerns when we heard the bill, around court resources. And then it was made clear that 90 or 95% of the people in prison pled guilty. They're not eligible for relief under this statute. This started out as a Innocence Project bill, and it was a 5-page bill that they helped me draft, and we whittled it down to 1 paragraph with the assistance of Mr. McKee and Mr. Maycumber to an extent. And I also raised with Justice Meade earlier in the year that when we're trying to get these criminal justice reforms through, we always have the resources to convict them, to try them, convict them, and to imprison them. We never get any concerns expressed around court resources. But if the court has to spend some resources to exonerate an innocent person, so be it. It's the way our justice system should work. We're not going to get, I think one state indicated that they only had like 5 additional appeals. So A, if you pled guilty, you don't have any coverage under this. And B, if we have innocent people in jail, I did discuss with Justice Meade, and he agreed with me that we've got to have the resources to address this. It may take a little bit more resource, but it's not going to be a lot because there aren't that many people that are going to qualify for pursuing the petition, and they can only do so after it's reviewed by a judge.
Thank you, Representative Evangelos.
Information credible. So but that's what Ms. Finn said. There would be some more pressure, but that was somewhat repudiated by the fact that the vast majority of people incarcerated aren't eligible for relief under this statute.
Thank you for raising that additional issue. We've been joined by Julie Finn, who's the analyst for the Judicial Department, the Judicial Branch. And Ms. Finn, we are, you probably recall LD 54, that's the legislation that we're talking about. Do you need to see the document or have any kind of a refresher on it?
No, I actually was watching on YouTube, so I didn't have a link. I just had to get in the right virtual space, I guess. So I was listening to your discussion, and I only just saw Senator Kimes' amendment, which I think probably gives the judges more latitude, but I have not had a chance to review it with them, which I really can't say yes, we love this amendment or not without doing that, which I could get back to you on fairly shortly, but I just can't, I can't say for certainty right now as I sit here.
Okay, and is that something the legislative process is moving really rapidly at this point? Is that some information that you could bring back to us on Tuesday potentially?
Yes, absolutely. And I will say another thing that I looked at, which was similar, because Representative Evangelos had mentioned Massachusetts Criminal Rule 30 has a similar provision in it. So I think that that is a model that I'm familiar with. It's similar to Senator Kimes' amendment. But yes, I would be happy to review that quickly and absolutely would be able to get back to you on Tuesday.
Representative Evangelos, if we were to table this until Tuesday and then take it up first thing Tuesday morning, would that be acceptable to you?
No, ma'am. No, Madam Chair, it's not acceptable because this is the identical amendment that was heard in the 129th. And Ms. Finn weighed in on that, it may take some limited amount of resources in the court. Of course, anybody that files a post-conviction review is going to take up some resources. But this is about justice and about allowing a pathway for an innocent person to get out of prison. And we put the language in to satisfy the minority to allow for a judge to review the evidence, and they would decide. And we had a former attorney general, draft that language, Michael Carpenter. He's the one that put the language in, a former attorney general representing the prosecution side. So I don't want to wait any longer. It's been 2 years, and Ms. Finn weighed in on the amendment. It's the identical amendment. There's no new news. There'll be a few cases, and it'll take up a limited amount of court resources. And I don't want to wait. There's a motion on the floor. I want to vote.
And does it matter to you? Because I, like you, am very concerned about the underlying policy. I'm so concerned that I feel that if we had a unanimous committee report, and maybe I should ask the committee if we're headed in that direction or not, but you understand as an experienced legislator that having a unanimous committee report would really help the bill work its way through the legislative process.
Well, the minority report is based on some additional language for the judge. And the question to Ms. Finn was in relation to the resources of the court. She's not going to weigh in on what the judges are going to do. That's not in her prerogative. She's just going to say that this is our concern about the resources. But again, and I'm going to reiterate this, we took this up with Justice Meade, and he agreed with me that the courts have to have the resources to adjudicate these cases. We don't have a choice. We've already been cited with this by the Sixth Amendment Center for not doing a good job. And this is just a simple bill that removes time limits. And it's, Julie, it's Rule 35B of the Maine, Massachusetts Criminal Code, not 30. I'm pretty sure of that. So no, I don't see any need to wait, because this is not a new amendment. This is an amendment that's been around for 2 years. And even if she comes forward and says, well, we're worried about the resources, well, I'm worried about innocent people in prison. Which comes first? If we're going to say that we cannot exonerate people because we don't have court space and time, but we've got the time to prosecute them and incarcerate them, it's the same argument I've been making all session, that the resources have to be distributed equally. We're not doing very good at that. We're having trouble with getting into legal resources. Now I'm running into trouble getting resources to help innocent people in prison. So whether her answer is yes, it will put a little extra strain on the court system, it's not going to make any difference. That doesn't mean the person. Can you imagine if you have a son or daughter stuck in prison and, well, we don't have the resources to hear the case, but next case, convicted, send them to prison. It can't keep working this way. So I want to pursue with a vote today. We lost 2 years on this.
I'm sorry to interrupt you, Representative Evangelos, but I really want to move the work session forward.
Well, I want to move.
The question to Ms. Finn was not, is it or is it not going to take up court resources? The question was, is the language that's contained in the original bill or the language that's contained in Senator Kime's proposed amendment, which language gives the court the flexibility it needs to develop the procedures to implement this statute? And I just wanted to clarify that. Representative Libby, you've had your hand up for quite a while. Go ahead.
Thank you, Madam Chair. I do have a few quick things to say. One is that I and a number of my fellow legislators were not here in the 129th. So anything that went on there is somewhat moot, as we are new to this bill. And so I appreciate the work that was done previously. I was not here for it, and it doesn't have any bearing on this bill before us today. There has been a significant change in circumstances. We've gone through a lot in those last 2 years, and I am very interested in Ms. Finn's analysis of this bill. And finally, I would say, certainly I can't promise anything as far as unanimous or not unanimous, but since I always start from a no, I am certainly more inclined to get towards a unanimous report when I have all of the information in front of me, including a report back from Ms. Finn.
Senator Kime?
Thank you. I appreciate what Representative Libby said. We do definitely start talking like we were all part of the discussions last time, and we weren't, and my apologies. But my question, Representative Evangelos, is it your assumption, are you saying that you believe the language that's in your original bill, your bill this time without the amendment, covers the same ground as the amendment that I'm proposing? Yes. You're saying it's not necessary, and okay.
I just it gives the judge the full discretionary authority.
Okay, I was unclear if that was what you were stating, and then so I understand your urgency to pass this. I would like the question asked, but I don't mind if, a vote is today. I would still vote ought to pass as amended, and I'd probably just throw my amendment language in, and then, we could always reconsider if it came to it, and that, we learned that was in the best interest of the bill and the vote. So I'd be fine approaching it that way as well. I understand Representative Evangelos' urgency, but I also think that we have to recognize that not everybody here has plowed this ground already.
Thank you very much, Senator Keim. And Representative Babbage, go ahead.
Yeah, thank you, Madam Chair. We are 14 independent thinking people, and I realize that the amendment that Senator Keim is offering is merely a sentence, but if it doesn't change anything, then it's maybe clarifying but not substantive. If it does change something, if it changes the threshold, then I may not be in favor of it. And so if a political consideration is unanimity, then if we had some sort of a commitment that if the court felt that that was, I don't know, I'm just not seeing a path forward where the time is justified to delay. So I'm just telling you that I think we spent a lot of time to achieve what I think everybody wants in that newly inserted, it was actually part of the original bill this year, but in that second sentence, and I'm comfortable with that, and fooling around with that, I agree with Representative Evangelos in this particular case. I'm not sure if delay is going to get us to yes. Thank you.
Thank you for raising that point, Representative Babbage. Representative Moriarty?
Thank you, Madam Chair. I know that if I had been involved with this for 2 years, I would also be extremely impatient at this time, but I haven't had that experience. I don't think that the additional sentence has anything to do with judicial resources at all, because either there's going to be a claim for post-conviction review or not, but the standard for sort of the evidentiary standard to be met by the petitioning party and the procedural action that a court might take, I think it would be interesting and helpful to have clarified. So if we're talking a delay of 5 additional days and no further, I would, out of respect for to Senator Keim, await the input from Julie Finn. And if the court or the judges haven't been able to speak or collaborate by that time, I'd be prepared to vote on the pending motion as it is. I frankly think she'll come back and say the judges find this to be helpful because it lays out a standard for review, which might preclude the full expenditure of resources in a case which isn't adequately based.
Mm-hmm. Yeah, and I actually kind of have the opposite feeling. I'm concerned that Senator Keim's language might be a little bit too restrictive for the courts. It's a conundrum, given the time pressure to do something today. I wish it was acceptable to the sponsor to wait. Peggy, can you answer a question for me? Because the other thing I know that Representative Evangelos had said that this review statute doesn't apply to anybody who pleaded guilty, and I'm not seeing that in the statute, and I just don't know the answer to that question. Do you know if the post that if this post-conviction review process is available to people who pled guilty, or just to people who were convicted after a trial?
Well, I don't have that exactly, but I have Rules of Unified Criminal Procedure Post-Conviction Review, Rule 67, and it refers to the petition shall be limited to the assertion of a claim for review or one or more criminal judgments arising from a single trial, or from a single proceeding for the entry of one or more pleas of guilty or nolo contendere, or a single post-sentencing procedure. So I understand that Representative Evangelos has information that it doesn't apply to people who have pled guilty, but I don't have that same information. So if he could share that source, that would be great. That would definitely put my mind at ease. And then we could go on with that. I don't think it says anything in the statute about it. And so in looking at Rule 67 of the Uniform Criminal Procedure, it appears to authorize somebody who has filed a plea. And I found a form that looks like that is an option that you check off, that it was either a plea or jury trial or a bench trial.
Okay. Representative Evangelos, can you shed any light on that for us?
Yes, Mr. McKee had told us that it would just be a very small pool of people that would be eligible for relief under this, because obviously if you pled guilty, you're not going to make a post-conviction plea for innocence. You pled guilty. So that information came from Attorney McKee, representing the Maine Criminal Defense Lawyers Association.
He is here.
Okay. I'm going to bring him over because I do feel like this is such an both urgent and important matter, and I would like us to get
one other thing briefly.
Yes,
the reason why this committee waited 2 years is because we were promised a stakeholder group that was going to weigh on this, and it never happened, and it frustrated the progress on the bill. So if you think I want to finish up on this today, I have good grounds for that. Madam Chair, this was 2 years that potentially innocent people sat in prison because of a delay in the committee. So that's why I think it's time to vote. And Mr. McKee is here, so let's hear from him.
Good afternoon. So I'm just joining in. You all moved very quickly on some of your previous bills. So I caught the last bit of the question, which is, can a person who has pled guilty bring a post-conviction review, just in the general process, so separate from this bill? First of all, exceedingly rare, right? You pled guilty, so you're kind of done. But there are, to be frank, there are situations where a person could do that because of information or details or whatever that their attorney did not provide to them. And they pled guilty under, some idea that, that they were guilty, but in fact, there was other information that their attorney, failing in their representation, did not give to them. And so in that situation, they say, well, geez, I didn't know, but there was another eyewitness who said that this never happened. I want to be able to challenge my attorney because they really didn't do a very good job. If I'd known that, I never would have pled guilty. And in that situation, they would, try the case and potentially be found innocent. So there's that piece. But having been involved in post-convictions 28 years now, those are not the cases we see. We see it's after trial. Or after some sort of a preliminary proceeding where they say that mistakes were made by the attorney. So I do agree, very narrow class of cases, but there is that rare exception where that in fact could happen.
So there's no legal reason why you would be precluded if you had pled guilty.
Right. So there are circumstances where that can happen.
Great. Thank you. That's really helpful to helping us hone in on a path forward here. Thank you. Representative Babbage, did you have another question, or is that a residual hand?
No, I do not, ma'am.
Okay, Representative Thorne, go ahead.
Thank you, Madam Chair. Mr. McGee, is it possible that if this were to pass, that even though there haven't been that many at this point, that this would change and that there'd be some more Hail Marys, if you will. I mean, if I'm sitting in jail and I got nothing to lose and somebody finds something, I'm going to file on this in an attempt to get out of it. Do you see that as a possibility?
Well, not, I mean, the bill as drafted talks about the bringing forward of new evidence. So we're talking about new trials based on newly discovered evidence, and the bar to that is the bill is now. So you're still going to have to be able to come up with that new evidence in the first place. So the time bar, the biggest concern, which is, you can't do it because you just, it was a little bit too late, would be eliminated. In theory, there always could be those, but I've found that as these statutes have changed and over the years, that there really hasn't been a change in the basic number of cases. Lawyers are challenged for their work in cases. New evidence is presented in cases at basically the same rate, regardless of what the changes that have been made. And there are fairly small number of cases in the first place. So a change in the time that it will affect some cases because there will be the opportunity to bring forward new evidence because the time bar would have been removed. But I'm not anticipating a significant number of cases, but people can file anything at any time for any reason. And I think that the additional piece of information here that was important to the amendment, I think helps that, which is the judge is going to have a little review process before, like, okay, you say you have new evidence. Well, what actually is it? And I think that'll be helpful in the process in weeding out the Hail Marys, if you will, or to continue the analogy, tackling the quarterback before they get to throw the long pass.
That's what I wanted to clarify with you, is that this wouldn't open up the floodgates, as it were, and open up a significant number of cases that found something to go back on any more than there currently is. Thank you.
Senator Kime?
Thank you, Madam Chair. So I feel like we're getting conflicting information about who can apply for these. So I wonder if you could help me understand that a little bit better, Attorney McKee. I think the Mr. Maycomber's in the attendee list and added to the chat, which I know we're not supposed to do that. But yeah, saying that, if someone pleads to murder, that they can, go after this to try to prove innocence, which, I mean, we don't want guilty people in jail, and none of us do. But there are going to be those people that have very thin or evidence that they're suggesting, and for them to tie up resources, because that's a reality of life. Resources are always limited. We need to make sure they're being applied appropriately. And but I'm confused. So I'm confused about who can apply for this. It's, according to Representative Evangelos, it seems like a very narrow this applies to a very narrow amount of people. And then I'm hearing other people say, no, it's fairly broad. So can you help me understand? I am worried about floodgates.
No, I think you're right. Whenever you have a change like that, you're concerned. People, there are people, the bad apples, that will do that and unfortunately ruin it for the others who have legitimate claims. But I think the language of the change really focuses in on that, because as it talks about, you have to have newly discovered evidence. And that's what you really have to have, something new. And so I suppose anybody can create something that they call new out of whole cloth. But I think the idea here is that if new evidence comes to light, it's going to affect the case. Those are the kind of cases that you would want to have come forward. So I don't see the floodgates opening anymore by changing the time. First of all, the floodgates as they are now, I mean, somebody could file one for, allegedly newly discovered evidence as it stands now based on the old standard, where it could have been discovered through the exercise of due diligence. So you already had that in the first place. I think removing the time bar allows that opportunity and allows that actual piece of newly discovered evidence to come to bear. So I don't know. I think it's anyone's guess, but I just don't see this the statute as it's written now opening up those floodgates that folks are worried about. I can't tell you much more than that. And I think the language of the statute or the bill helps in that regard.
And so just to clarify, you're saying that the amendment, the most recent amendment that I proposed, you would agree with?
Is that the one that talks about the requirement that the petitioner provide additional information about the nature?
Let me read it to you.
Sure.
Not quite.
Does someone have it right in front of them? I want to read. I want to make sure I'm reading it specifically, and I've got too many papers in front of me.
I can do that. I can do
Thank
that.
you.
Oh, great.
Okay,
Thank you.
Okay. Well, the new language reads, following the sentence that you just started to read, the court may summarily dismiss the petition if it determines that the petitioner has not made a prima facie showing that the new evidence was material and would have affected the jury's verdict.
Well, I need to think about that. That's a pretty major impediment in and of itself. I think the court is going to do that as part of its analysis. I'm just wondering whether that should be part of basically a complete yes or no at the very start without the opportunity for a full hearing. So you present the evidence saying, you know, I have this new eyewitness and this person's going to say X, Y, and Z. I'm concerned about whether a judge should, based on just that initial showing, say, well, that's not enough and it wouldn't have changed. I think it's important to have a broader hearing, especially when it comes to newly discovered evidence. So I hadn't heard the amendment before. Thank you for letting me know. But I think it may be more restrictive and ultimately unnecessary given the number of claims that are involved here. But I appreciate knowing about it.
At this point, committee members, I feel like we're working really hard to try to address this. I would like to do one thing, which is to ask Mr. Maycomber to weigh in on, actually, yes, because Senator Keim did ask him a question, and I would like for him to answer the question so that all members of the committee can hear the answer to the question. And then I do think we should move on to a vote. Mr. Maycomber, can you activate your audio and video?
Madam Chair, I have a point of order. I mean, he's a prosecutor for the Attorney General's office, and he's been functioning, trying to influence us over the chat function. It's totally inappropriate, and especially somebody of his profession and his position. That is just totally inappropriate. And we brought Stephanie Anderson, another prosecutor in, former prosecutor. This isn't a public hearing.
Yeah, we also heard from Attorney McKee, and so I'm just
Right. Attorney McKee testified on the bill and was the expert witness for the bill. But I'm just go ahead. It's fine.
the narrow question, Mr. Maycomber, is well, actually, could you please respond to the question that Senator Keim asked you through the chat?
She's going to have to refresh my recollection. And if I violated some protocol by putting in the chat, I wasn't aware that there was a protocol because there was a chat. So I just assumed that it was okay to chat.
Yeah, we can't disable the chat, but it's not part of the official legislative record. So let's just quickly wrap this up and then decide where we're going on the bill.
So
Go ahead, Senator Keim.
Senator Keim, can you repeat your question, please?
Clarify, I didn't ask a question in the chat. I simply read your chat. And yes, there is no way for people attending to know that the chat is only to be used for technical issues. So no worries there. Since you're here, I would just ask you what has confused me is Representative Evangelos stated that only people who claimed innocence would be able to use this process. And then Attorney McKee said, well, it's more than that. But it's rare. So I have difficulty reconciling those two things with what, other people are telling me that it's actually maybe more likely to open floodgates. So could you just offer me your perspective on that?
Well, just in regard to the simple question about can people that plead guilty utilize the post-conviction review process, the answer to that is definitively yes. And I've had dozens of cases and where they've done that. In fact, in almost half or more of our murder cases, within a year of them pleading guilty, they file a post-conviction. Once they get to prison, they realize that they don't like it. But in terms of the what you just asked,
I think you've actually answered the question that yes, people who plead guilty can file the post-conviction review.
okay, that's not the
Does that
question I
answer your
thought she just asked, but
Does that answer your question, Senator Keim?
Yeah, I think it does. Thank you.
okay, thank you.
Okay, at this point, what I'm going to do is recognize my co-chair who had his hand raised, and I'm going to excuse everybody who is not a member of the committee from the panel so that we can make our committee decision. Go ahead, Tom.
Thank you, Senator Carney, and I don't want to prolong this. This is the language, and I know that what we did in the 129th does not dictate what we do today. The sentence, the court may require the petitioner to provide additional information about the nature of the newly discovered evidence. And I guess the question we have to answer for ourselves is, does that allow the court, does that provide enough guidance for the court to say, no, there is not newly discovered evidence and end the process? I came to the conclusion 2 years ago that it did. There's a clearly disagreement on the committee about that. I do think the addition of the language that Senator Keim has proposed does make this a different statute. I too would like to get to yes and would love a stronger report coming out of this committee. But I'm not sure that's going to happen today. I mean, there is a motion on the table with a second, and it's a risk that the sponsor takes by forcing the vote today if he chooses to do so. And what I think I would do is really has no bearing on this, and I may disagree, but that's not my call. That's his call. I'm not.
Thank you, Representative Arnett. I see 3 hands up. Representative Evangelos, is your hand up from before, or do you have something new to add?
I just wanted to clarify for Senator Keim, and I stand corrected on a small point, that my recollection from the testimonies I've heard in the past, both last session and this session, that it would be extremely rare, and because a person had pled innocent, and you have to have newly discoverable evidence to move forward. But obviously, I stand corrected on a few of those cases, so I just wanted to acknowledge that. But I don't think it's something we need to get hung up on. It's not going to be a lot of the cases, and the bill's language gives the judges the full discretion. So I just wanted to get that on the record. The judge has the discretion. We wrote it into the bill, and I'm not going to weaken the bill any further. I started out with a 5-page bill from the Innocence Project, and I'm down to 1 paragraph. So, and I've waited 2 years because of guarantees that were made to this committee that weren't honored. So, yes, I want to pursue, but that's what I have to say.
Thank you so much. And Senator Keim, and then Representative Babbage, and then we'll vote. Go ahead.
Thank you, Madam Chair. If we're going to vote on this, we will need a corner caucus, and I just want to assure Representative Evangelos that I think the committee all agrees this is important and that we need to move forward. And there are new members, and they are being brought up to speed, and there are questions, obviously, that have changed our discussion as we move along. And so I think patience with committee members is really beneficial when I think we're all pulling in the same direction. And the difference of someone having to have maintained their innocence the whole time versus having claimed pled guilty, that's probably a significant change in population, like a percentage. So it doesn't change my opinion that we need to move forward with this, but it is a significant change in the population of people that we're discussing. So I think it was significant information to uncover at this late a date. So thank you. And yes, I request a corner caucus before we vote. Thank you.
Madam
Thank
Chair.
you very much, Senator Keim.
I'm
Just
out
a,
of time. I have
just a moment. Representative Babbage, you were next. Go ahead.
Thank you. Yeah. Thank you, Madam Chair. Yeah, regarding the pleading guilty, I don't know, but I can imagine an attorney coming to me and saying, listen, the evidence is really against you, and this does not look good. You're going to spend time in jail. You're going to spend less time in jail if you plead guilty. I don't know how many people would take that and therefore have a plea on their record. But that would be a consideration. I wanted to ask if Senator Keim's amendment, what struck me about it and would have affected the jury's verdict requires a higher degree of determination to me that is too much for a preliminary decision. And however, I just wanted to ask, is there any comfort that would help to bring more people onto a majority report or a unanimous report if we included the sentence without that final phrase? The court may summarily dismiss the petition if it determines that the petitioner has not made a prima facie showing that the new evidence was material. Is that helpful, or is that meaningless, or how do you feel about that? Anyway, I'm just looking for a way to us to feel good about this. So thank you.
Thank you so much, Representative Babbage. I think at this point it'll be, let's do a corner caucus and Senator, and we can discuss that in our respective corner caucuses. Senator Keim, how much time would you like for the corner caucus?
Just 5 minutes.
Okay, so we'll come back at 3:56.
Madam Chair.
Thank you, everyone.
Madam Chair, I have a commitment at 4 o'clock. It's ironclad. And that was made clear to the chairs several hours ago. So I don't want to be in the position of not being able to vote on my own bill.
We absolutely, and we are rushing to meet that deadline, and we will be back at 3:56 and we will vote when we return.
Okay.
Thank you. All right, it looks like we are returning from our corner caucuses, if that is the plural of caucus. I don't know, I never took Latin. Committee members, are we ready for the vote? Oop, hang on a second. I think Senator Babbage is, Representative Babbage is lost in cyberspace, but I think that he'll be with us momentarily. Committee members, are we ready for the vote? And this is, did somebody say something?
I just said I am.
Okay, great. So this is the ought to pass made by Representative Evangelos and seconded by, I believe, Representative Babbage. My notes aren't that great. Who seconded Representative Evangelos? It was Babbage. Okay, great. All right, Ms. Panette, we are ready when you are.
Madam Chair, I need to send a link to your co-chair. So I can't call the roll and send a link.
Oh,
I can do that. Can I have 1 minute?
Yeah, no, you can have, you can absolutely. Soupy, go ahead.
Sorry, thank you.
No, that's fine.
It's not like we're going anywhere.
Well, Jeff is, that's the problem.
Yeah.
Sorry. Do you want to wait till he joins or get him in the absentee?
Let's get him in the absentees.
I think I
Oh,
found it.
here he is.
All right, let's go.
Oh, my apologies. I was talking to Mr. Chair.
It's my fault. It's my fault.
That's all right.
Call the roll.
Okay.
Go for it.
Thank you very much. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll call the absentees. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 5 members voting in the negative, and 1 member is absent.
Thank you very much, Ms. Panette. So the what is the report of those voting no on the motion?
Mine is ought to pass as amended. And I would ask that if there are other members who are joining that they speak up and say so.
I am also as amended.
I am as well.
As amended.
Thank you very much. I think that's everybody.
No,
Uh,
Representative Hagan.
Representative Hagan?
I said no.
No, so you're just ought not to pass.
Yeah.
Okay.
Thank you for that clarification.
So I have 4 that are ought to pass as amended. Does that sound right? Okay, thank you very much.
All right, and so the motion ought to pass carries 8 with 4 ought to pass as amended, 1 ought not to pass, and 1 absent. And with that, we'll close the work session on LD 54. And Representative Evangelos, we know that you need to leave, and so we will, is there a motion to table LD 1273?
So moved.
So moved.
Okay. Moved by
Okay.
Representative Moriarty, seconded by Representative Harnett. So 1273 is tabled. And Representative Evangelos, thank you very much for all of your hard work on LD 54.
Thank you. Sorry I have to run, but Lisa and I are on a panel and I'm still in Augusta, so I gotta get home and get ready for it. Thank you.
Thank you.
See you tomorrow morning at 9, right? All right.
Yep.
Bye-bye, everybody.
Good night, Jeff. Good night, Representative Evangelos.
Jeff's fine.
Okay, so we have a motion to table 1273, and we have not taken a vote on that yet. Could you just raise your electronic hands if you're in favor of the tabling motion, everyone? And it looks like everyone, like that is unanimous. Thank you very much, committee members. And we will see you tomorrow, Representative Evangelos.
Thank you.
And we'll lower our hands. And so that closes the work session on 1273. And we'll open our work session on LD 957, an act to reform alternative sentencing programs. And let's see, Peggy, would you like to give us the bill analysis on LD 957?
Sure. So the purpose of the bill is to amend the deferred disposition process and allow a requirement that the person complete an alternative sentencing program. The idea is that you can use a deferred disposition means that the person actually pleads guilty, but the disposition is stopped. The district attorney says, we're just going to kind of hold this in abeyance. And sometimes there are conditions, things that the defendant would have to complete or show that they learned their lesson, and it's usually a period of time. It's usually a year. And if the defendant has complied with those requirements, I mean, it's an agreement, and if the defendant complies with the agreement at the end of that term, usually a year, the charges can be dropped. And so what the purpose of this is to make use of that time while the disposition is deferred, and allow the defendant to be involved in community service projects, education projects, and they think that would be a great use of that time. I think the concern that was raised by CLAC is that this is implying an alternative sentencing program to take effect before the person has a conviction and has been sentenced. So the idea is great, but maybe this is not the way to do it, because you're actually asking somebody to participate in an alternative sentencing program when they don't have a conviction, and in fact, they might not end up with a conviction. So I mean, the idea is to get them involved in programs and do beneficial things. There is a fee to this program as identified by folks who want to run these programs. But I'm not sure it can actually happen the way it's drafted.
Thank you. Committee members, are there questions for Peggy? Go ahead, Representative Reckitt.
Well, it's not a question, so, but I would like to speak.
Go ahead.
I just think this bill has too many problems that we have not solved, that no one has solved. And so I think it would be premature to do such a thing. And so I would like to move ought not to pass.
There is an ought not to pass motion. Is there a second? Seconded by Senator Keim. And thank you for the motion and the second. The bill sponsor is here, and as a courtesy, I'm going to bring her onto the panel. Welcome, Senator Maxman. Did you hear our concerns, the concerns of the analyst and the committee members regarding the bill?
I just heard the end of it, but I was going to mention that the folks that I've been working with at the Lincoln County Sheriff's Office have talked with CLAC, and I believe they came up with amendment language. And I'm wondering if, before you vote on the motion, Deputy Maker could come in and talk to you a little bit about that conversation. District Attorney Natasha Irving is also in the waiting room, who's also been involved with those conversations.
Do you know if they have specific a written amendment that they can share with us today?
I believe that Deputy Maker does. He talked with CLAC this afternoon.
Thank you very much. And one other question, Senator Maxman, has the amendment been shared with anybody on the committee at this point?
It took us a while to get in touch with CLAC, and so the conversation happened recently, and I've been in meetings all day, so it's been I haven't been able to connect with it, but I trust him, and I respect the committee's wishes, but would just want to give him space to talk about it if that's okay.
Okay, thank you.
Thank you.
And so at this point, and you suggested that it was Chief Deputy Maker who has the amendment?
Yes, he spoke with CLAC.
Good afternoon.
Good afternoon, Chief Deputy Maker. We understand that you've been working on an amendment to LD 957.
Yes, myself and DA Irving have been talking with CLAC, and I'm just trying to find the language here. I mean, I can email this language that actually was sent to me from CLAC, and we made one suggestion and he agreed to it. But the CLAC's really hang up was the fact that we were calling it alternate sentencing program, and where in their thoughts they weren't sentenced. So he came up with some language that really describes the program and gives the judge some leeway to place them in this program. So I don't know how you want to handle that.
Let's see. Peggy, is it okay if he emails the amendment language to you? Okay. So can you have him email the amendment? So this is John Pelletier, is that who you said who has the amendment language?
Yeah, yes, Mr. Pelletier had the language, and I'm
or do you
see if
yeah.
made any amendments to it.
I think
Yeah.
whoever can most efficiently get it to Peggy, and then she can screen share it so that committee members can consider it. That would be really helpful. Thank you.
I have it
Jill
right here.
sent it to me.
Have it?
I have it and I can screen share this.
Oh, thank you so much.
Thank you, John. Okay, let's make this a little bit bigger.
Thank you.
So this looks like the change in the language is the new language that was being added. Oops. So the underlying language. Did you want to speak to this, Chief Deputy Maker?
Only that as far as I'm concerned, it'll allow us to accept these deferred dispositions within our program, and Mr. Pelletier seems comfortable that the language doesn't infer that they are sentenced at that time. So it'll work for us if it'll work for CLAC.
So can I just ask a question? Does the court actually impose the deferment requirements? Or is that something that's imposed by the prosecutor?
Well, it's usually a deferred disposition is usually an agreed upon requirement between the prosecutor, the defense, and the judge. But the judge is the one who actually has to set the conditions.
Okay.
In the statute, he or she is the person who has to set those requirements.
Okay, thank you.
I do see one thing in the version that we're looking at here that I talked to Mr. Pelletier, and he agreed it had some benefits. In the version you're looking at here, myself and DA Irving had spoke about where it says that the days in a program run by a county sheriff and we wanted to add may involve overnight housing, just the word may. Because it allows, that language will allow a lot more flexibility to maybe even the potential for locally here, we've talked about a deferred disposition. We may be able to run even a day reporting event for some of these programs instead of requiring those on the program to attend the whole weekend. It really may be up to them.
Thank you very much, Chief Deputy Maker. And Peggy, thank you for the questions that you've been asking. I think they've helped us understand the amendment a little bit more. Let's end the screen sharing just so that the committee can see each other. And I'm just gonna, Mr. Pelletier has his hand raised, and we're gonna bring him in and ask him. I sense that he wants to share something additional with us about the amendment. Mr. Pelletier, can you activate your audio and video when you're able to?
Yes,
Welcome.
thank you, Chair Carney. Thank you. I just wanted to answer Peggy's question. The statute does talk in terms of the court imposing requirements. It says the court may order sentencing deferred to a date certain and impose requirements. So what the amendment does is the new language that was, it would replace the bill, and the new language that was in the bill is no longer there. And what's underlined is the suggested new language. And it removes the reference to sentence or sentencing program and is appropriate language for deferred disposition. And I do want to point out that I was consulted. I am not CLAC. When I talk on behalf of CLAC, I'm talking on behalf of a group of folks. But this was a suggestion that I was asked for and that I came up with. And then in the second paragraph, the statute allows the jail to operate programs where inmates participate in public works. And it sort of adds that in addition to an inmate, it makes clear that the people on deferred dispositions are not inmates. In addition to inmates, it says certain inmates of that jail, as well as other people required to do so pursuant to the deferred disposition statute. So this language appears to address the concerns that the members of the group had, in my opinion.
Thank you, Mr. Pelletier. Committee members, I see a number of hands up. Representative Babbage, go ahead.
Yeah, I'm sorry. I don't have that amendment in front of me again, but I just wanted to, my concerns with the original bill was that a guilty plea was required and that the fee issue kind of discriminated against those without funds. Are either one of those addressed by this, Mr. Pelletier?
No, deferred disposition requires a plea up front, although in many cases the plea is withdrawn at the end and the matter is dismissed. And the matter of a fee is not addressed in the statute in the proposal in any way. So that would be an issue for the entity running the program. So the amendment doesn't address that.
Thank you for the question and thank you for the answer. Representative Reckitt? Oh, Representative Reckitt, we're not able to hear you.
I'm willing to withdraw my ought not to pass motion, but I'm still not in favor of this. It just feels like a chain gang for which you have to pay. It just really just doesn't feel right to me. I don't know what I'm saying exactly because I'm so blessed tired. But the reality is, there's something. I don't know. There's something just doesn't fit for me. So, but I'd be happy to withdraw my ought not to pass motion so that you can proceed in whatever the logical fashion you think is.
Thank you, Representative Reckitt. So we'll take a step back. The ought not to pass is withdrawn and we are continuing questions related to the sponsor's proposed amendment. Senator Keim, go ahead.
I believe I seconded Representative Reckitt's motion, so I will also withdraw that.
Thank you.
And my question for the Chief Deputy is, would this apply to people who have not been sentenced and who are in pretrial detention?
No. It's really what we're designing this is for those who are in deferred dispositions who have this requirement to complete the community service and possibly get some education as well. I can speak more to the funding part if you want, because we have discussed that issue here locally.
Right, that was going to be my follow-up actually, is if, I mean, I actually have no issue with a fee as long as there's a way that it would be waived, but of course the program is going to be expensive, and I'm a firm believer in having skin in the game for people. So I was hoping you would talk about if this amendment doesn't prescribe a fee, but then you have the ability to work a system in however you see fit in your agency, but then would each agency would each department be allowed to choose their own pathway sort of with that? So if you could answer that, that would be helpful.
I don't believe with any clear legislative guidance. I think each program would have to run by whatever standards it wants to run. But I can tell you locally here, first of all, people who are on deferred dispositions generally are paying a fee every month anyway. And that's anywhere commonly $25, but I think the statute actually authorizes up to $50 a month. I can tell you locally here, we've had these discussions with DA Irving about diverting those funds that are going normally to her office, and possibly even using those funds for anybody that is determined to be indigent. I can guarantee you this, the program doesn't make money now. And if my county commissioners heard that, they probably wouldn't like that, but it doesn't make money now. But this isn't about making money. And if somebody can't afford the program, again, DA Irving has funds to pay for those indigent people. So the money issue, again, locally, we've worked that out here.
Thank you.
Thank you.
Chief Deputy Maker, I just want to ask you a clarifying question. So the people we're talking about are people who have entered a guilty plea, and then they're going to serve this deferred disposition with the hope that at the end of the time frame that their guilty plea would then go away. Is that right?
Well, each deferred disposition is handled differently. In some cases, that's exactly what happens. At the end of the 1 year period, it goes away. Most commonly, usually, it may be the difference between jail time and a fine. It may be the difference between a felony conviction versus a misdemeanor conviction. You know, so there usually is a change at the end of the year for a positive, you know, as we call a positive outcome. So it often doesn't go away, but it usually is either results in a fine, or somebody who's been charged with a more serious crime ends up with a misdemeanor conviction.
And do you feel that the newly proposed language will facilitate more positive outcomes through the deferred disposition program?
I'm thinking that those people that are in those deferred programs are maybe struggling to commit some of the community service that they may be required to do. And the DA's office may be struggling to use that as in a sentencing option, because it's hard to find places for them to do it on their own. But it also puts them into the programming portion of it, where again, substance use disorder, decision-making skills, restorative justice is all part of the training. I wish we're doing a program literally this week. I should have invited every one of you up there to visit. So.
Thank you for that information. Representative Hagan?
Thank you, Madam Chair. Could you explain how you meant by like a more serious crime down to a misdemeanor? Would that be what kind of, I'm assuming, felony, and what kind of felonies would be reduced to a misdemeanor upon this kind of community service, and what kind of community service would take a felony down to a misdemeanor?
That's generally not my business. That's handled within the DA's office. So, but I mean, it might be a felony assault to a misdemeanor assault. Could be a felony drug charge to a misdemeanor drug charge, that kind of stuff. And I think the sentence is more than just about the community service. I think it's an opportunity for that individual to prove to the court and the district attorney's office that whatever happened was a real not an everyday event, and that they can prove for a year period they can be a good citizen, and thus not end up with a felony conviction or even have to do jail time.
All right. Thank you.
Thank you.
Committee members, are there additional questions for the bill sponsor related to the proposed amendment? I'm not seeing any. Are there any additional questions for Mr. Pelletier or Chief Deputy Maker? Okay, I'll go ahead, Senator Keim.
Right. Actually, a question for Mr. Pelletier. I wonder, Mr. Pelletier, if you're familiar with the deferred dispositions that happen in Cumberland County and how this system here or how this program would compare to that, if you know.
No, I don't. I'm not familiar with a particular deferred disposition program in Cumberland County.
Thank you.
Representative Babbage?
You know, pardon my ignorance, and I am a little fuzzy this afternoon, I think anyway, but if Deputy Maker could help me with understanding how long might a person be in county jail in a pretrial status, and would this program in some way influence whether or not they would plead guilty?
I don't know if I can answer that question, sir. I'm sorry.
Yeah, I think what we clarified, Chris, Representative Babbage, is that this is not the pretrial detainee situation that I think we originally maybe thought it was, that it's really about the deferred disposition group of people. Is that right, Senator Maxman?
Yes, I believe so. Yeah.
Yeah, so people who might enter a plea and then have a period of community service, and I think some of the other services that Chief Deputy Maker referred to as like counseling and substance use disorder treatment and that sort of thing, with the hope that their sentence might be reduced at the end of the 1-year period. So it's not the pretrial situation.
Well, you understand my question was that given the opportunity here, might and I guess it can't be answered, might a plea be entered that would not otherwise be entered? That's
Mr. Pelletier, go ahead.
I could take a stab at that. I think that the people who are charged with very serious crimes and are long-term pretrial detainees are unlikely to enter to be accorded a deferred disposition. So that group is probably unlikely to be affected by this. There are some people who have relatively minor things and spend a few days in jail before they go to court, and an early agreement is reached to put them on a deferred disposition. But the incentive to plead guilty, to the extent that's a problem for someone who finds themselves in jail, is no more or no less with this proposed sentencing alternative than any other plea bargain sweetener that the prosecutor might offer. You know, it's just part of the negotiation. And to the extent that a favorable plea offer encourages people detained to plead guilty, this is neither here nor there on that point. That's just a practical reality. But my main point is that the long-term people who find themselves in jail and can't get out are not the group of people who are getting deferred dispositions.
So can I ask, may I follow up, Madam Chair? I just want to ask, so Mr. Pelletier, given this new amendment, you're withdrawing your testimony in opposition?
Well, again, I can't speak for the group. What I'm saying is what our group objected to was the implication that people were sentenced or participating in a sentence program, because on deferred disposition, you're not sentenced and you're yet to be sentenced. But my personal view is that the opportunity to participate in a program like this might well be a welcome thing for people, because during the year of the deferred disposition, they're not in jail. And if they're incentivized to behave well, then that's a good thing. That's why the legislature created deferred dispositions. And the more options, the better. That's my personal view. The group's objection was that it suggested that you were conflating a deferred disposition with a sentence, and that the new language, the proposed language, solves that discrete problem.
Thank you, Mr. Pelletier. Committee members, let's ask our final questions, and then I'm going to excuse the panelists so that we as a committee can move forward with this bill. I see Representative Moriarty has a question.
Thank you, Madam Chair. I just want to confirm with the sponsor, Senator Maxman, that she is on board with the new language and which Peggy shared with us.
I am on board with the new language, and if I may, Madam Chair, I think Natasha Irving, the DA, would be really helpful to clarify some of the concerns and questions, if it's okay to bring her in quickly.
Yeah, I will bring her in. Representative Hagan, go ahead and ask your question.
Thank you, Madam Chair. A real quick one for Mr. Pelletier. So you had mentioned that maybe a more serious felony more than likely would not receive a deferred disposition. So more serious felony could get that? Is that what you're saying under this bill?
No. Deferred dispositions are not available for Class A or Class B crimes. And Class C crimes are often, for example, a third offense assault is a Class C if you have 2 prior convictions, even if the conduct would be misdemeanor conduct. So that's the kind of case where you would get a felony drop down to a misdemeanor based on good behavior, based on doing a year deferred disposition where you show no further untoward conduct. And so it's only available for Class C, which is the lowest level of felony. And of course, the DAs are part of this agreement. So to some extent, they regulate it to ensure that it applies to appropriate cases and not cases that are more serious than should be treated in this fashion.
I appreciate that. That's very helpful. Thank you very much.
Senator Keim, I know you have your hand up. We were just joined by Ms. Irving, and I would really like her to provide the comments that the bill sponsor suggested, and then I'll call on you. Is that okay with you?
Yes, but my question was for Mr. Pelletier.
Okay, I will not dismiss him yet. Ms. Irving, go ahead.
Thank you. I have a 6-year-old in the other room that hopefully will not be making an appearance while we're here. So I wanted to just answer a few of the questions that came up that I think would be helpful. But first, I'll just give a really quick overview of why, from my perspective and my staff's perspective, this is an important bill. So right now we have the opportunity to offer deferred dispositions on anything up to a Class C felony, and we do enter into a lot of these. Now, some folks, a good outcome may result in a jail sentence. It may result in a long, a less lengthy sentence than it would have resulted in. It could result in anything from a jail sentence to probation to fines to a dismissal. The reason this seems really important to us is that we have a lot of folks who would really benefit from this programming that are not going to benefit from going to jail. So right now, we don't want to have the good outcome be 7 days in jail. We want these folks to be able to go take care of this, engage in this programming that really helps them stop the criminal behavior. Now, some folks, and this is where the crux of this is, we want this to end in a complete dismissal, right? It could be a first-time theft charge. It could be a first-time drug possession charge. And we have somebody that's maybe a young person, just somebody that really doesn't need to have a criminal record, But if we don't get a conviction, we can't get a sentence. And if we can't get a sentence, we can't send them to alternative sentencing program where they can take advantage of substance use disorder treatment. They can do community service work, giving you more connections with the community. So this would make it so we can send folks to go do that community service, to get that really, that programming that's going to help get them out of the criminal world and be part of a community without creating a criminal record. Now, for everything else, if they're going to be sentenced at the end, right? If it's going to be a good outcome is going to result in a conviction, then this isn't a problem. So these are usually to kind of answer Representative Hagan's questions. These are going to be really your lowest level, where we really just want to avoid a conviction at the end because of all the collateral consequences I'm sure you've heard about in a lot of the bills that have come forward. As far as the funding goes, we do have a funding source. We charge folks that can afford it a fee. Those are folks that are not considered to be indigent. We do anything from $10 a month to $50 a month based on some criteria that we have, and that has padded up an amount of money that we can use to offset the cost of alternative sentencing for folks who are indigent and can't pay for it. But as Senator Kimes said, sometimes having some skin in the game is really important. So we use the court's analysis of whether someone's indigent, and without that analysis of screening of whether someone's indigent, then it wouldn't even be considered a jail case, a potential jail case, right? So if it's not even considered a potential jail case, then they wouldn't be looking at an alternative sentencing program issue. So I hope that that answers a lot of those questions. And the last question, I think that, is it Representative or Senator Babbage? I'm sorry.
Representative Babbage, but you can just go ahead with the answer.
Yeah, and that was whether this might, kind of, I don't know if it was whether there's a concern that this would have people change a plea. I mean, I think, to tell you the truth, in this situation, really we're looking at folks that are going to, in a good outcome, not have a criminal conviction at the end. That's the point of amending this statute in this way.
Thank you. That was super helpful. Senator Kimes, go ahead.
Thank you, and thank you for being here, DA Irving. So do you already run a deferred disposition program out of the DA's office?
Yeah, so deferred dispositions are in statute, and we routinely offer these to get folks into treatment. I mean, I would say that's a bit, to get folks into treatment, to defer folks into restorative justice programming. That's been really helpful to get restitution paid. It's a real victim-centered process. So we use it routinely. We use it quite a bit. Yeah, every day.
So, okay. So then, and those people are being supervised, right, to make sure that they're in compliance with whatever conditions there are?
Sort of. I would say that's probably a strong way to put that. They have bail conditions, typically, throughout the deferment, and they could have depending on what the bail conditions were, they might not be able to be in possession of alcohol or drugs, not have contact with somebody, or be at some certain place. So there's those things. There's also the requirements, the affirmative requirements, right? Like treatment, could be mental health treatment, med compliance. We don't check up on folks during the deferment because we actually can't, well, we can't talk to anyone that's represented by an attorney. We do check in with attorneys to see if folks are in compliance. But at the end of the deferment, people come back to us, and they are able to either show that they completed treatment or they did X, Y, or Z. And if somebody is picked up on a bail violation or picked up on a new criminal charge, that shows up in our system, and we may terminate the deferred disposition or revoke bail or let them keep working on it, or that kind of thing. We don't have a lot of really hands-on, eyes-on supervision typically, but a lot of the folks that are on the deferreds wouldn't be on for typically anything violent. Occasionally, or deferred dispositions are often used or sometimes used in domestic violence cases, but that's usually has more to do with the fact that we can have proof issues with cases because victims often are either reluctant to testify, they've recanted, or don't want cases prosecuted. But other than that, we typically do not use deferred dispositions for violent crimes.
So can you just help me understand? So if the DA, if you are currently doing the deferred dispositions, so then this is an expansion to allow the sheriffs to do them, which they currently can't according to statute. Is that right?
No, what this does, I'm sorry, what this does is it makes it so somebody could go and do the alternative sentencing program without a conviction, I guess is the way I would put it most succinctly. So right now, somebody as a good outcome of a deferred disposition could be sentenced to second offender alternative sentencing program, which is 7 days. And so, but that would require, right, that's the term we use. We use the first offender, second offender. These are kind of antiquated now. So you could do 2 days up to 7 days. And that requires a sentence, right? That requires sentencing, that requires a conviction. So this would just change it so while they're on that period of deferred disposition, that they could engage in the programming and then have a good outcome at the end that would include a dismissal right. These would only be offered in my opinion, what are appropriate cases, often shopliftings, mental health and substance use disorder type crimes usually. So that's really the difference, is that it gets folks into that, able to take advantage of that really good programming and community service work. I'll just add that we extend these offers to folks, some folks who have criminal records, right? They might have a possession charge. They might have a history of mental illness and homelessness that's created a record that's nonviolent, but that's certainly a criminal record. And that wasn't always the case. That somebody that had anything on their criminal record might not be offered this previously, right? So we've expanded who is eligible to get this alternative sentencing program, and who's eligible to do a deferred. Sometimes when you have folks that have a criminal record, it's really hard for nonprofits to have them come in and do community service because of their insurance providers, right? You might not be able, if you have a criminal history of shoplifting, you might not be able to do community service with some organizations, but the sheriff's department does that's what alternative sentencing, a big portion of it is a lot of community service. So people can get their community service hours done in a 2-day period that some folks are having a hard time getting done in a year. And I have people that have come to me that have, and to my staff that have looked into doing community service with, a dozen organizations, and they were turned down because the organization couldn't, for insurance purposes, couldn't let them do it. So that's the other aspect of this, is that it would get folks who, again, we want not to be going back to jail or going to jail because it contributes to criminal behavior, especially for low-level offenses. We want them to be able to do this really good programming, including community service, which has really been proven effective at getting folks become part of the community instead of become a problem in the community. And we can't do it unless they're sentenced. So it's just helpful to avoid those convictions when somebody can really earn it, and also to get them into community service that's supervised by the sheriff. And they do it in a really, I think Rand Maker could probably speak better to this, but they do it in a way that really brings people into the fold, whereas sometimes throwing somebody in a jail cell just shows them more that they're not part of the community and they're never going to be a part of the community.
So you're saying that this program is after they've been sentenced?
No. So deferred dispositions are entered into.
But I guess you're saying alternative sentencing programs and deferred disposition, and it seems like you're using them interchangeably, but maybe you're not.
Yeah, can I just interject something as well? Because I think we've had a very full day, and I think that you're giving us a lot of information really quickly that we can't maybe, like, I'm completely lost.
I'm so sorry about that. I have a tendency to, probably go too deep into detail.
Yeah, and we as a committee also, I think, need a break. But could you tell us in 1 or 2 sentences why this amendment that has been presented this afternoon is important.
Right. I
Please.
feel like this is the SATs, but yes. I mean, not the SATs, is my college exam, but this amendment makes it so somebody can truly earn the good income, good outcome of a dismissal at the end of a deferred disposition, while taking part in really good programming that's been designed to keep people from committing crimes in the future, and building up our communities with community service. And my opinion, there is a large swath of folks whose good outcomes should be dismissals, and they will not be afforded this programming. And right now they're not afforded this programming because they won't be convicted at the end, because we will not convict someone that truly earns a good outcome. So that
Okay,
is
so
why
I'm going to just interrupt you. So the ability to participate in the programming is currently tied to a conviction at the end, and these people will not be convicted because they will have done the alternative sentencing and avoided the conviction at the end.
that's exactly what this carve out is for, that group of people that we really want to take part in that programming, that would really benefit from it. But we also, we are of the belief that if they can get themselves out from under a conviction, that's also extremely important to their futures of staying out of the criminal life.
Thank you. Senator Keim, do you have additional questions? I don't know if I was hoping to help clarify. I hope that did clarify for some committee members. Did you want to ask any more questions, Senator Keim?
I have another comment, but I can wait until after Representative Babbage.
Okay, go ahead, Representative Babbage.
Thank you, Madam Chair. I'll lower it right now. Actually, my question is from Ms. Irving, DA Irving. One of the people that expressed concern about the financial end of it said that they were concerned about the indigent, and they would probably be alleviated if there were a sliding scale. You described a sliding scale. Is that just for your jurisdiction, or you said $10 to $50? I was just wondering if that's standard or regional.
Okay, so the $10 to $50 is a supervision fee that we levy on folks, and that's folks that can afford 10 or more dollars. Some people have a completely waived fee for the deferred disposition. So that's how we kind of build up our coffers to be able to pay for programming, including
That's a local decision.
That is absolutely a decision that I made coming in. I changed what we did in the district when I came in. So that is up to each district to do that.
Okay, that's what I wanted to know. Thank you.
Yes, sorry. Yep.
Okay, and then Representative Libby, and then Representative Moriarty, and then Senator Keim.
Thank you. I just wanted to clarify that I think I have a complete understanding of the bill and the amendment, and I just want to make sure that I do before we would vote on this. So with the amendment, the bill will make it so that the folks who are in a deferment could both take advantage of the alternative sentencing program, but also end up without a conviction. Is that correct?
You get the prize for actually summing it up in one sentence. Yes,
Okay,
that's exactly it. Nail on the head.
Okay, thank you.
Representative Moriarty.
Thank you, Madam Chair. I think the primary stakeholders have worked this out well between themselves to include the bill sponsor also, and I would move ought to pass as amended.
There is a motion. Is there a second on that motion? Seconded by Representative Sheehan. Okay. Senator Keim, go ahead.
Thank you, Madam Chair. I appreciate the intent of this bill very much, but this is a lot of conversation that we're trying to hurry because we have so many bills in front of us. So I'm quite uncomfortable voting on this bill right now. I mean, I guess I can just vote no, but I think it probably has value. I think we should either be carrying over this bill. We definitely need more conversation from other people around this process than, now that we have something sort of different set out in front of us. So I, for one, do not feel comfortable voting on this bill. I'd be happy to table. I would be happy to, work it, kind of on the sidelines, I guess, or carry it over or something. But I think this is a lot in the moment.
All right, I will just comment that we're really limited in the number of bills we can carry over. And we're tending to carry over those that we can consolidate, like 4 or 5 bills into the bill that we carry over. So that I appreciate your suggestion. I'm not sure that that's a feasible option for this bill. Let's see. Representative Babbage, go ahead.
Yeah, thank you, Madam Chair. I just, when we were talking about actual alternate sentencing programs, we were talking about $300 and $500 fees. I appreciate the sponsors, getting this amendment done. I know it's 11th hour, but I've totally done a turnaround on whether to go forward on this bill or not. The only thing I have that's left is consideration of the indigent. And I don't know what a maximum financial burden might be in other counties other than DA Irving's. That's the only question I'm wondering, or if we wanted to somehow specify that in the amendment.
Yeah, I think that we only have information from Lincoln County for sure. And we have, okay. So we need to decide how to proceed. Senator Keim, if we tabled this bill and revisited it, and we'll have to fit it into I think we have work sessions on about 80 or 100 more bills to do before mid-May. Do you foresee yourself being able to support the bill after looking into it more? Or I'm just trying to get a sense of whether we're going to end up in the same place a couple weeks from now as we are right now.
All I can say is it sounds very good and something that I would like to support, but I don't like voting when I feel like I've had so much information thrown at me and I haven't had time to sift through it.
I appreciate that. This was very dense and not it took us a while to really sink our teeth into it. Representative Hagan.
Thank you very much, Madam Chair. I also find myself really liking this, but I feel like it's a tremendous amount of information that I'd like to have a little more time for. And I have to go back to the caucus and the community and make sure that all of my ducks are in a row so that I can clearly, as a pseudo expert, be able to say this is why I voted for this. And so a little extra time would be helpful for me also. Thank you.
Thank you very much, Representative Hagan. Senator Maxman, it looks like there's interest in tabling this. If we tabled it, do you think that you could bring us some information about what's happening in counties other than Lincoln County as well?
Absolutely. I'd be happy to work on that for the committee.
Okay. Thank you very much. Committee members, is there a motion to table? Senator Keim?
Yes, Madam Chair, I move to table.
Senator Keim has moved to table. Is there a second? Seconded by Representative Hagan. And let's just use our electronic hand feature to vote on this. Anybody who's in favor of the tabling motion, use your electronic hand, and we'll just leave them up until Soupy's been able to record the vote.
Fine, thank you.
Thank you very much. And so the motion to table has carried 10-0 with 4 absences. And with that, I want to thank everybody, the bill sponsor, and all of those who have been working so hard on this important bill for all the information you provided today. And we hope to take it up shortly. And with that, we'll close the hearing on, the work session on LD 957. And I would like to, we have 3 more bills. The next 2 are Representative Warren, and I know she is here and has been waiting to present on these bills. Can we take a 10-minute or a 5-minute break and then return and continue our work sessions? Is that acceptable to committee members?
Yes.
Yes, and just Madam Chair, so the committee knows, I have to sign off at 5:30 tonight. Thank you.
Okay. And thank you, Senator Kyman. We do have the option to vote for 48 hours after the work session. And so those who have to excuse themselves will still be able to weigh in, of course, on the bills. So, all right. And Peggy and Soupy, is a 10-minute break good with you, or a 5-minute? What do you? Okay, let's say 10. Pardon me?
Whatever you want to do.
Okay, let's split. Let's come back at 5:10. Thank you, everyone. Hello, everyone.
Hey.
Long day.
Yes.
Indeed.
Let's
Not as
This
long
can-
as yesterday.
yeah. So thanks everybody for hanging in there and returning to try to complete work sessions on 2 more bills. We've all been working really hard today, and I just want to express appreciation for everybody for sticking in there with us, and especially you, Peggy and Soupy. Peggy, I think we're ready for the bill analysis when you are.
Are we on 1303?
Yes, yeah, actually, let me formally say, welcome back from our break, everybody. We're going to resume the Judiciary Committee meeting and open the work session on LD 1303, which is an act to ensure judicial discretion in sentencing, sponsored by Representative Charlotte Warren. And first we'll hear from our analyst, Peggy, and I'll bring the sponsor over to the panel as well. Thanks very much, Peggy.
Great, thank you. So the purpose of this bill is really to identify mandatory minimum sentences or mandatory sentences and not have those apply. And the way the bill is drafted, it's trying to reimpose judicial discretion in any crime that has a mandatory minimum sentence involved. And the first subsection applies to crimes in the criminal code. And the bill wasn't really drafted exactly as the sponsor wanted it. It was turning every mandatory minimum into a maximum, which is not what she had intended. And so Representative Warren had presented an amendment at the public hearing. But the purpose of it was to, subsection 1 says the judge has discretion, though those mandatory minimums don't apply. And in subsection 2, mandatory minimums don't apply to crimes outside the criminal code. So like there are quite a few hunting and fishing regulations that have some 2-day mandatory minimum jail sentences. And then the last piece, section 2, was directing the reviser of statutes to go through the statutes, identify all those crimes that have a mandatory minimum or a sentence that can't be suspended, and list all those. The bill directs the reviser's office to prepare a language that would eliminate all those mandatory minimum, and then the Criminal Justice Committee would be able to report out a bill next year. So the sponsor had provided the bill, an amendment that says, okay, we're not turning these into maximum sentences, we're just eliminating them and giving the judges complete discretion. CLAC was very concerned that you could be looking at a statute and it looks like there's a penalty there when this one section over here is saying, no, that penalty doesn't apply. And so I actually worked with Representative Warren and John Pelletier late yesterday evening to focus down just to the crimes that are in Title 17A that actually, maybe I shouldn't even be saying this for Representative Warren, but she was trying to narrow it down because she understood about it being important that when you read a statute, you know what the penalty is. And then still the language about the reviser's office going forward with identifying all those statutes. In working with the reviser's office, they're really kind of uncomfortable putting together legislation that they haven't actually, legislation that would repeal those sections, but they would be happy to pull that together. And then the Criminal Justice Committee could figure out how they want to deal with each one of those statutes. So I thought I sent the amendment to Representative Warren and John Pelletier last night for them to review this morning. They let me know a little bit after 8 that they couldn't read it. And I just now found that email. So I apologize profusely to Representative Warren and to Mr. Pelletier and to the Judiciary Committee for slowing things down today. I apologize. But I can, if Representative Warren wants you to look at this amendment, I'm happy to share it.
Representative Warren, would you like Peggy to share the amendment with us and give us a little bit of analysis on it?
That would be great. And then if I could add just a quick sentence, I'll be super quick.
Do you want to give us that sentence now or after the screen share?
I'm happy to do that now. First of all, Peggy, thank you so much for helping. So as Peggy said, we worked with Mr. Pelletier. This drastically makes the bill smaller, just focused on the criminal code. And then the second step of the revisor looking at all those mandatory minimums. That's all I wanted to say. Thank you.
Thank you. That's very succinct, which is probably good this time of day, given all we've been working with. Representative Reckett, your hand is up. Did you have a question, or is that from? Okay, Peggy, you can go ahead. We would appreciate the screen share. And also, Peggy, thank you for working last night to get this ready for our work session this morning.
Well, you're welcome, but you were working too. That was my deal with Representative Warren. I was going to try to get it done by the time you adjourned. So we were very close. So we actually, John Pelletier was very good at identifying the statutes that have mandatory minimum. The first one he identified is stalking, and it's a Class C crime, sorry. So the actor violates paragraph A and has one or more prior convictions. So already has been convicted of stalking, commits stalking again. It's a Class C crime. It raises a crime because of the prior conviction. The current law says there is, it includes a term of imprisonment. So it has to include select a term of at least 1 year. So that's actually in the sentencing process. And I think this is what Mr. Pelletier identified as having to be struck out. So I'm just going to keep going. It's all, we're in the same section. This is, it's again enhanced by a prior conviction, and again it's a discussion of how the judges get to a final sentence, and they have to start with at least 2 years of a sentence. Okay, I think I'm going to speed through. So here's our so the next one is special sentencing provisions for gross sexual assault, and so right now there is, again, the court has to look at that first step and impose a sentence if gross sexual assault is committed when the person who it's committed against has not yet attained 12 years of age. So that's involved in the sentencing process, determining what the sentence is. And the court may not suspend that portion of the maximum term of imprisonment based on a prior conviction. Those are kind of hard to understand because they're written in the context of how a judge reaches the appropriate sentence. And that was originally created in case law, and then the legislature enacted it into statute. So it was very clear. It's a 3-step process that the court has to go through. This is a little bit more clear. This is in Chapter 45, which are all the drug offenses. There is a special section, 1125, that has a mandatory minimum sentence for certain drug offenses. And this is really easy because it just strikes it all out. So that's where the mandatory minimum sentences are for the drug violations. It's chapter 45 of the criminal code. And then this is in the kind of like in the sentencing section. This is where the different maximum terms for crimes are. And there is a subsection 3 is mandatory minimum term of imprisonment for crime with use of a firearm against an individual. These are mandatory minimum. And then the sentence could be greater than that. But if a firearm is used in any of these crimes, then this has to be the mandatory minimum. This is the minimum sentence. And then subsection 4 is an additional mandatory minimum term of imprisonment. And I think that might be it. I had the whole section and I wasn't sure about that language. I think John has told me that we don't need to do that. And then the last piece is the revisor report and legislation. And in talking with the revisor's office, they said it would be really helpful if you could explain to us what a mandatory minimum is. And so we thought this language might work. For the purposes of this section, the term mandatory term of imprisonment includes a required minimum term of imprisonment, as well as a term in which some or all of the term of imprisonment may not be suspended. So the revisor's office would bring this list to the Criminal Justice Committee, and Representative Warren and the Criminal Justice Committee, once they get it in January, would have time to report out legislation addressing all those. I understand there are some federal programs where money is dependent on there being a minimum sentence for certain crimes. And this would give the Criminal Justice Committee the opportunity to look at that and weigh the benefits and decide whether or not to make those changes. So all set. That's the amendment.
Thanks, Peggy. That's okay. Yeah, thank you. Whoop.
You calling on me?
I don't know what I'm doing because I lost my screen. I think I am going to have to log out and log back on, everyone. I'll be right back with you.
I hope sharing a screen didn't do that.
I don't know what happened because I can hear you. I just can't find. Oh, there you are.
Oh, good.
Whew. All right, so that is a lot of information to digest. I see 3 hands raised. I'm going to start with you, Representative Babbage, and then Representative Hagan, and then Representative Reckitt.
That's actually the exact opposite order of how we raised our hands, but I'll be glad to take the
Just
lead.
go for it. We don't. The more efficient we are at this point, the better.
Thanks. I have a very elementary question. Is it possible to get a 6 or 9 month sentence for a Class C crime? I was under the impression that more than a year was a felony, but that's not a minimum. In other words, it's if it to be sentenced to more than a year, it would have to be a felony or Class C crime. But is there a minimum currently? Okay, thank you very much. That helps me. I did not. I thought.
Oh, you did. I didn't even have my microphone on.
No,
right.
But yes, no, but in other words, I thought that all Class C crimes had a minimum of 1 year, but that's not the case. Thank you.
No minimum.
Representative Hagan.
Thank you very much. I came in just a little bit late in their 10-minute time span off. I plucked a chicken, so I was a little bit late. Is this an amendment? Did I hear it right, or did I not even hear it? That this amendment, we don't have it, and it's brand new. We just minutes ago got it. And
yeah, I don't think you've even gotten it. I think I just showed it to you.
Okay.
Yeah.
Thank you, Representative Hagan. Representative Reckitt.
Well, the first thing that came to my mind is, have you has someone, Charlotte or otherwise, talked with the sexual assault people and the DV people? Because there's a lot of minimums in those jurisdictions. And I think some of them, they may not be willing to go quietly into the night. So I think that's an important conversation that has to have before. I don't have any problem with the reviser, pulling it all out and telling us where it is. But I think that the earlier that conversation begins, I think the better road we'll have next year if we're trying to decide whether or not to put anything in there. So that's commentary more than question. Sorry about that.
Do you want me
Yeah,
to
that
answer?
does- Go ahead, Charlotte.
Did you want me to answer the question?
Yes, go ahead.
I am in actual constant conversation with Elizabeth Ward Saxel and Francine Stark about all of the bills that we're working on. So yes, I know those are very important statutes, and they will absolutely be part of that conversation, and are already, and are very aware of this bill. The second amendment that you received was actually written by Andrea Mancuso from the Coalition to End Domestic Violence.
What, could you just clarify what the Second Amendment is, Representative Warren?
It was what I presented to you at the public hearing last week.
Okay, thank you.
So just to simplify it for the gentleman who just plucked a chicken, which might be the first time I've ever heard that during a work session, but I love it. Basically what I did, Representative Hagan, was I presented you with a bill that was about this big, and what I brought to you today does exactly the same thing, but in this much of the statute. So the process remains exactly the same, but knowing that we as a state need to adhere to certain federal regulations in traffic statutes, et cetera, I said, let's just take that right out and not deal with that confusion right now. So we just went to one title, if you will, the criminal code. So I hope that's helpful. All the rest remains the same.
Thank you, Representative Warren. Representative Rickett, did you have a follow-up?
No, I just have a lazy hand. I'm
Well,
sorry.
okay. Thank you. And Representative Moriarty?
Thank you, Madam Chair. I think a lot of good work has been done here, but frankly, we are in the same position which we found ourselves at the end of the last work session. We haven't received this, we haven't digested it, and I think inevitably this has to be tabled. I won't make the motion because there may be more comments or debate.
Committee members, are there additional questions for either Peggy or the bill sponsor? Let's do questions first and then we'll do more comments. Not seeing any questions. Committee members, are there comments regarding the amendment we've been presented with today?
Well, am I the only one with my hand up?
Yes, go ahead.
The comment I have is I don't see this like the last bill, because I think what we're looking at is a simple process in a way. We're asking if we can take the criminal code, hand it to the reviser, say, find the minimums, the things with minimum sentences, and bring that to the Criminal Justice Committee by January so that they can look and see whether or not each thing should have or shouldn't have those minimums. But I think that we're not having a discussion about what should have minimums and what shouldn't. We're only saying we want the survey of what is eligible in our head because it has currently a minimum sentence, and turn that over to the Criminal Justice Committee to make a decision next year. So it's sort of a sophisticated table in a way, because we don't have to table the bill to do that, but we can set the process in motion. So I don't see why we couldn't figure out how to vote this today, unless there's some other wrinkle that I'm just not getting.
So then I guess I have a point of clarification or a question to raise probably either to you, Representative Reckett, or to the bill sponsor, because I thought that we were actually changing the law in a couple of areas, the stalking law, the gross sexual assault, the drug offenses in Chapter 45, and minimums. I mean, I think the amendment does propose changing specific statutes, right? Is that right, Representative Warren?
You're taking out the mandatory minimum. The judge may decide, I mean, you know, really, it's going to take a while for all of this to get printed and get to the judiciary, but the judge may decide to stick with that same sentence. But the bill proposes to eliminate those mandatory minimums. And I will remind you that CLAC is unanimous in their support for getting rid of mandatory minimums, as John shared with you at the public hearing.
Representative Libby?
I just wanted to put forward that I will need time to digest the amendment once it is in hand. I regrettably would have to be a no automatically today if we were to vote. Not because it's not a worthy bill, but because I can't possibly vote on something that I haven't read myself thoroughly. No disrespect to you, Representative Warren.
Not at all. I understand. Thank you.
Representative Reckett?
I think my question is, so we don't really have to do anything about the criminal justice, or about referring to criminal justice. That's just going to happen. Let's say we saw this, we agreed, we passed this, then the mandatory minimums would be gone. And then the Criminal Justice Committee could decide next year to look at the whole package and make some individualized decisions. Is that accurate, Charlotte? I mean, Representative Warren? Okay. Do we have some assurance that they would let that bill in to have that happen? Whoever the they is.
If you, as far as I understand, when we've done this with other bills, once you pass the bill, you have authorized a bill in the second session. Similar process we did with the county jail bill last year. So you've sort of authorized it. If I'm wrong about that, Peggy will correct me, but that's my understanding. Okay.
Okay, thank you.
Representative Hagan?
Thank you very much. I'm not loving it, so I'll probably be a no. I can't. I have to see everything. I have to sit for whatever time it takes, and so I'm uncomfortable with it. So I'm just going to vote no on it.
Committee members, I will say that I would not be able to vote today because I really do need to consider the bill, the version that the sponsor has brought to us today. And so we can have a little bit more discussion if there's any more discussion. Otherwise, I'll entertain a motion to table. Nope. Representative Moriarty?
No, I see Chris raised his hand, so he wants.
Okay, Representative.
I don't want to make the motion.
Move to table, Madam Chair.
Oh.
All right, is there a second? Is there a second? Seconded by Representative Moriarty. All right, and let's do the electronic hand voting system.
I want my name in the history books, Steve.
Yeah.
You go too fast. Can you slow down?
Representative Hagan, are you voting? So you have 8 in favor. I have 8 in favor of tabling. And I think Representative Hagan is voting no to tabling.
Yeah, I just, as written, I can't support the bill right now. So do I
Excuse me.
go to table, or do I I don't
Well,
really.
if you want, I mean, I think there are plenty of people on the committee who want some more time, and we will bring this up in our next, probably the next work session.
I'll be a team player. I'll do
Okay. Soupy's happy she doesn't have to do a roll call.
All right. Soupy, let me know when you're all set.
Oh, I'm all set. I'm sorry. I thought it was announced. I thought you announced. 9 members voted.
So the motion to table carries 9 to nothing with 5 absences. So we'll close the work session on LD 1303, and then we'll take up our last bill that we're going to take up today, which is LD 841, also sponsored by Representative Warren. And so this opens the work session on LD 841. And let's start, Peggy, with your analysis, and then we'll ask the bill sponsor to provide us with her a statement about the bill. I'm getting a little tired as well.
So the purpose of the bill is to provide a presumption of probation for sentences for the sentence for certain Class E crimes, and those are listed here. It also makes deferred disposition available for a person who pleads guilty to unlawful possession of a scheduled drug under section 1107A in the criminal code. So most of this is about making there be a presumption of probation rather than any term of imprisonment for Class C crimes. And that's what Section 1 cross-references the change in Section 2, which says, here's the presumption that we're going to have a presumption of probation for the Class C crimes listed in Section 1605, which is Section 3. And you will see that probation is presumed to be the appropriate sentence for a Class C crime listed in subsection 3, unless the punishment has been enhanced to a Class C because the person has 1 or more prior convictions, the crime was committed with the use of a dangerous weapon, or the person waives the presumption of probation. And then you get to subsection 3, which is the whole list of crimes that are Class C crimes. Some of these statutes have more than one crime listed in that cited section. But all of these Class C crimes, there would be a presumption of probation rather than a term of imprisonment in all of these cases. So if you have the bill analysis, I went through and listed them all, and I can talk to you about them if you'd like. I will point out that paragraph F includes chapter 45 of 17A, which includes the drug crimes. And also the Title 32 provisions are the Maine Uniform Securities Act and the Maine Commodity Code. And you had information from Judith Shaw, who's the securities administrator. I included that. I just pasted it right into the bill analysis. And also I see Leanne Robin from the Attorney General's office is here for this bill. If you have questions about particularly white collar crime, she's one of the prosecutors that deals with these, and Attorney General Fry had said she would be available for this work session. I think that's all I need to say.
Great. Thank you so much, Peggy. And Representative Warren, did you have an amendment on this bill as well?
Thank you, Madam Chair. Yes, and I just want to suggest that you all are probably going to want to table this bill as well, and I support that and I understand that. I did work with Ms. Shaw from the Securities Administration. She was very helpful and shared her concerns at the public hearing, and also with me. I also reached out to Mr. Pelletier about this bill, and as I've spoken with other folks about this bill, including a bunch of the people that were on the commission last year where these recommendations came from, So remember that this was a working product that came out of the Council of State Governments, you know, working for over a year, looking at data from our criminal legal system here in Maine. But it seems that folks aren't ready for that sort of level of change. So what I'd like to do is pare the bill down to just be focused on one very specific thing. And it's a very specific thing that you all talked a lot about today, which is deferred disposition. Currently in Maine, you cannot receive a deferred disposition for all of the Class B drug crimes that we are seeing in Maine. And that's what puts people into the deep end of the system. So I would like this bill to be amended to just allow for, if the prosecutor and the judge agree, right, to just allow for a deferred disposition for Class B drug crimes. That would be the entire amendment. Again, this comes from, you know, what I hear from law enforcement constantly, which is, you want us to not just incarcerate people that are struggling with substance use. Well, then change the laws about it, because our job is to enforce the laws. So I'll stop. That is where I'd like to see this bill go, but I hear you that you'd like to see that in writing. With yesterday's craziness and today having all these conversations, frankly, I have not been able to put it together for you. So, but I'm happy to get it to you.
Go ahead, Representative Libby.
Thank you for your succinct explanation of that amendment, Representative Warren. Can I just ask Peggy, unlike those of you who've been on judiciary for longer than a few months, do not have at the tip of my brain what would be classified as a Class B drug crime. So I don't need that right this second, unless we're going to vote today, in which case I would. I just would like to know where to look to find that categorization.
So I think each section of Chapter 45 in the criminal code has the class of crime in it.
Okay.
And I could certainly, I can pull out, if you're just looking for Class B drug offenses, which is what Representative Warren is, I can put a list of those together for you.
That would be great. Yeah, just exactly what's covered by this amendment.
Yeah.
Thank you very much. Thanks, Representative Warren.
Thank you. Madam Chair, may I give a quick just description if it's very quick?
Yes, please do. Yeah, we actually, I would just say that we're going to have limited time to do another work session on this. So anything you want to share with us, I think would be great if you could share it with us today.
Thank you very much. And I failed to do that, and I meant to. So I thank you for the opportunity. Representative Libby, an example of a Class B drug crime might be the second time somebody gets caught for possession. So when you are caught with even just a usable amount of a substance, if it is your second offense, as we know often, well, let me not editorialize. It could be your second offense that can be bumped up to a Class B. Additionally, our sentencing structures allow for possession based on weight to be bumped up to a Class B. So although Class B can also be a trafficking crime, it also contains both possession when it's a second offense or possession of just an amount that's still a usable amount, and it can be bumped up to that Class B. This does not in any way mean that that people aren't going to still be able to be sentenced to the deep end of the system, Wyndham and Warren, if they are possessing the amount, and they're, sort of pinched for trafficking and furnishing at all. This is literally for the cases where, the judge and the prosecutor realize this person really messed up. They're struggling with substance use disorder, and they're getting their life back on track. And if we can give them a deferred disposition, they may be able to get out of this cycle, right? They're back at their job, they're home with their kids. And if we can give them the opportunity for this deferred disposition, does not mean they have to, but right now judges do not have that discretion at all. So that's the goal of the proposal.
Any other questions, Representative Libby?
Thank you. I appreciate the opportunity to follow up on that. So, Representative Warren, second that proper possession, yes. Then, so possession by weight, so that could potentially include trafficking if a judge was inclined to do deferred disposition in anything that might be trafficking related. They would have to have prosecutor cooperation and agreement. Is that correct?
Thank you, Representative. That's exactly true. And I can guarantee you that no judge is going to give a deferred disposition on a trafficking charge. It's just not going to happen. And I don't think that we believe that it should happen, right? This is not an off-ramp for folks who are profiting off folks who are ill. This is literally an off-ramp for Mainers who are suffering. And yeah, absolutely. Thank you for the clarification.
Thank you both. And Representative Moriarty, go ahead with your question.
Thank you, Madam Chair. Of course, the real distinction between the 5 classes of crimes is the maximum length of imprisonment. And unless I misunderstood her, I thought Representative Libby was basically asking, how do we distinguish A through E? To just recite the maximum periods of imprisonment, I think that tells you what I think that would answer the question.
Representative Moriarty, thank you. If I might answer, Madam Chair.
I'm sorry, we didn't hear you, Representative Libby.
Sorry, I have the wrong earbud in. If I might answer Representative Moriarty. My question was initially very specifically what would be classed as a Class B crime, not necessarily the minimum sentencing for it, but what the actual crime might be. And so I think Peggy is going to be providing that, so I can have that in hard copy, and then the explanation around what might be in that category from Representative Warren is helpful as well. Thank you.
Representative Thorne?
Thank you, Madam Chair. If appropriate, I would make a motion to table.
There's a motion to table. Is there a second? Seconded by Representative Hagan. And let's see. So let me just make a record of that. And let's vote on the tabling motion with our usual raise hand function, and just leave your hands up until we're all, we've counted all the votes. All set. Thank you very much, Ms. Panett. And so the tabling motion carries 9-0. And Representative Warren, if you could get us your written amendment, as soon as you're able to, we'd appreciate that. And we will schedule this for a work session that'll probably focus kind of more directly and exclusively on voting, since we've had a discussion of the bill today.
I will do that. Thank you all very much, and good night.
Thank you. And that closes the work session on LD 841 and wraps up our work for today. Peggy and Soupy, thank you so much for all you've done to help us get through a huge volume of work today, and committee members, thank you for all of your hard work. Yes, go ahead.
Do we need to table 844?
No, we're not going to table it. We just haven't gotten to it, so we'll reschedule it.
Thank you.
Yeah, I think, is that, Peggy, is that appropriate?
However you want to do it is fine. If you had planned to skip it, that's fine. But I would like to touch base with you, Senator Carney, just about what we're moving to next week's work session. That would be really helpful.
Let's do a phone call so that our necks get a little break from looking at the screen. Okay, let's speak right after this. Anything else, committee members?
If we have a motion to adjourn, I may move to table.
Representative Babbage, are you making a motion to adjourn?
I am, Madam Chair.
All right.
All right. Thank you, everyone. Thanks so much for all your work today. Bye.
Okay, folks. Good night.
One of 12. One of 12. Yeah, my printer was messed up. I might even have more for you. I printed the Maine Municipal Association thing on. Oh, yeah. You already printed it? I have not. No, I have stuff. Oh, okay. And I found that makes a few notes on paper bill. Then it's probably better. This is just a report she added to it. I don't know why, but it messed up my computer. My computer doesn't like 126-page reports. It messes up with its memory. Yeah, it was all day long. I continue to have this concern with the Zoom platform. I feel bad because when we're not in person, I hope the main citizens don't think that we're just off job and doing other work, taking notes or looking at the testimony on our second screen, because I think it looks like folks are just kind of ignoring it, working on it, but you can't tell that. My guess is that if people that are familiar with Zoom don't see it that way. But somebody today, like today, there were a lot of people that we've never seen and they've seen it. For example, I saw a chat, which I find it inappropriate for people to put that in the chat. But there was somebody that had a problem with a facial expression. Yeah. And I thought, you could watch everybody's facial expression. Yeah. Every single person would be caught making some kind of, yawning or, and you don't need to. I mean, it's just, and nobody, I'm thinking, like Aaron is, that's maybe, they just, she may be talking to somebody off screen. Exactly. I got caught doing that, laughing at something one of my kids did. Oops. Oh, shoot, I missed him. It was Representative Thorne. I just saw the THORN. I know, at first I only saw the James and I said, I don't know any James. I think I do. Okay, Annie. Okay, I need to.